Yes, any original side mentioning, appellate side mentioning, when we take up the appellate side, we'll take up the mention. Appellate side should call on the list.
But item number 1, Mr. Sarkar is online.
Yes, Mr. Sarkar.
Yeah. Well, I'm for the respondent.
I appear for the appellate.
You are for the appellate, right?
Lordship, lastly, I was not there.
Mr. Ghosh, if you can please address into the microphone so that
Very
Mr. Sarkar can also hear it. Yes.
Lord, this is an appeal arising out of an order dated 17th of January 2025 in relation to a suit for disparagement, Millard, and Millard infringement. Millard.
Yes.
Also, Millard, principally disparagement of a product of a plaintiff. The plaintiff is one of the market leaders in manufacturing cool talc. It has, Millard, two products, Navratna and Dermicul, by virtue of which the plaintiff holds 42% share in the market. The defendant is a trade rival. They also have a cooling Millard powder.
It was a modification, so you are the plaintiff.
Yes.
There in the suit.
Yes. Now, Millard, I just, before Lordship touches the paper, Lordship has seen, Lordship has heard my junior. I'll be try to be as short as possible.
No. Thank you.
Now, Millard, the defendant, Millard, also has a, Millard, cool talc, Millard. Millard, they, Millard, advertised, they make a TVC, Millard, that's Millard, television, Millard, advertisement, Millard, which is in the media, internet, everywhere, in YouTube, wherein, Millard, a bottle is shown, which is having a white bottle, green cap, with a tapered notch. And Millard, the Millard actor who is a hero, one of the renowned Millard artists in the Hindi cinema, Millard, he is seen, Millard, that he is sprinkling, Millard, the defendant's powder, Cool King, where, Millard, the crystals like ice in the heat summer, extreme summer, Millard, is falling, Millard, and the heat is, Millard, they are basically, Millard, getting a very soothing effect. Millard, and Millard, they are referring to one bottle which is white body, Millard, green Millard, tapered Millard, green Millard cap, and Millard, that is ineffective, that's ordinary, and that has been basically discarded. I don't say it's thrown away, it's discarded. And Millard, there is a specific Millard assertion that you use this Millard, defendant's Millard cool talc, and you get the same, you get the relief like a air, very cooling effect like a air condition, and basically don't use any other talc. Ordinary Sadharan talc. So, Millard, the term ordinary Sadharan talc in context of the bottle of the defendant was, according to the plaintiff, was disparaging or demeaning the product in question. It's slander of goods. Now, Millard, an application was filed before this court in aid of the suit. It was not ex parte, it was a contested order. A contested order was passed where the entire advertisement was restrained. In Millard, the order, I'll show the order on the first date when it was moved on contest. Millard, the defendant offered to change the advertisement in question, modify the advertisement in question by replacing it, the green bottle with Millard, a white generic bottle, Millard, which was not allowed by the single judge, Millard, when moving on contest, because according to him, this would any event be disparaging because the recall value of the customers will be there. So he did not permit it. Thereafter, affidavits were filed, and the allegation was that you also in some advertisement referred to the product as ordinary, but I will not give a generic white bottle, Millard. I do not, Millard, try to, Millard, show someone else's bottle. Like, Millard, ordinary talcum powder vis-a-vis the cool talcum powder. And this modification suggested by the defendant was only restricted, Millard, to the bottle. The bottle, see, Lordship can see from the advertisement, but Sadharan, Millard, they are entitled to use. An application was also moved under Order 39 rule for vacating, Millard, on the same set of facts, which was basically, Millard, shown, Millard, to the court on the first day. The order was modified, Millard, saying, Millard, the plaintiff is very hypersensitive. Millard, Sadharan by itself is not disparaging. Millard, with overlooking, Millard, two, Millard, portion of the advertisement in question. Millard, and the most important part, there's an order which is not annexed, I'll hand up, which says, Millard, since Millard, the affidavits are complete in Millard, the main application, GA1, no need to file an affidavit in Millard, the vacating application. In effect, the vacating has been allowed, or a final hearing, the order is modified without any change circumstances.
The temporary injunction application is still kept pending.
No, disposed of. All
Along with the order.
all disposed of. Lordship will kindly have a look at.
No, the offer to use a generic bottle, that was not also accepted.
Millard, they offered to use a generic bottle, but I said don't use Sadharan because Millard, ex-actor with the same
So,
advertisement.
but general the generic bottle that was accepted by the court.
So
But in
generic
the-
bottle, Millard, that was accepted by the court, as well as the word Sadharan, according to the Honorable Court, Millard, learned first court, Millard, the word Sadharan by itself is not derogatory or it's defamatory. The plaintiff is being, Millard, too hypersensitive in Millard not accepting the modified. Because this modified, our contention was, this modification you have suggested on contest, it was not an ex parte order. At the Millard very first day itself, the order,
that suggestion was made on the first day.
first day itself, that's recorded in the order itself.
The first order restrained them from using the ad
Using the
altogether.
advertisement altogether.
Very good.
Now, Millard, Sadharan by itself, courts have held, Millard. Like, Millard, if I say a lawyer is appearing, an ordinary lawyer. There are cases to that effect. That is, Millard, demeaning a lawyer, an ordinary lawyer. Now, Millard, Sadharan. Now, Millard, Sadharans in cases have been restrained. There are judgments of various
But Sadharan has been associated now with the generic bottle.
with
because
the
now
generic bottle, but the bottle, Lordship can identify the notch itself, which my junior pointed out.
the nozzle
Tapered notch.
that remains.
That remains. And Millard, I also have a case for generic disparagement.
All right.
Now, Millard, if your Lordship kindly have a look at the order, I'll not place the entirety, which is, Millard, part of the memorandum of opinion.
Yes.
It's in volume 1, Millard. If your Lordship takes volume 1,
It's part of the memorandum.
Yeah,
also.
Mr. Sarkar, we are looking into the memorandum. So what is it?
well, I'll be doing it from volume 1, Millard.
We'll be referring to the internal pages.
No, we'll use the internal pages, Millard. Should not
Right,
be a
right.
problem.
Yes,
No.
yes. Sir, it's I am reading page number 2.
Page number?
Para 1, Millard, if your Lordship takes.
Yes.
Para 2. Briefly, the petitioner is entirely engaged in fast-moving consumer goods and manufactured talcum powder under the mark Navratna and Dermicul. It is alleged that the market share of the above products is approximately 17% and 25%. So, Millard, it comes to 42% on odd. It is contended that the color combination of sea green and the white colored skin in relation to talc and the distinctive bottle and the cap design, along with the green and white color combination in respect of prickly heat powder, are exclusively associated with the product of the plaintiff. The respondent is a trade rival. The manufacturer of the FMC product, including the talcum powder, the storyboard is set out below. Now, Millard, if your Lordship, Millard, takes Millard, a colored touch, Millard, a colored copy was given, Millard, I believe. And
Probably annexed also.
it's kindly, Millard, takes Millard, the colored copy, which is Millard, annexed, Millard, to Millard, yes, advertisement, যেটা set out করেছে, যেটা proposed, যেটা দেখা যাচ্ছে.
Page 374 probably.
Yes, 373, if your
373.
Lordship takes.
Yes.
373, if your Lordship takes, Millard.
373 contains nothing about you. Your
Yes, kindly have a look at 374 second screen.
second and yes, second photo.
Second screen.
Right, right.
And also, if your Lordship takes, Millard, the 378 first shot. This is the change tag. Change tag কি হলো? Yes.
Yes.
So this was shown in the initial advertisement. Change tagটা দেখাও. So this was per se held to be, Millard, disparaging of, Millard, the plaintiff's product. This is the ad or the advertisement with the subject matter of the suit. Change
Yes,
tagটা দেখাও।
yes.
তুমি তাহলে দেখাচ্ছ কেন? Now, Lordship will kindly take, Millard, internal page 6 of the order,
Do you have a picture of the throwing away?
discarding.
Discarding?
In the main ad. কোথায় আছে? Kindly take, Millard. It's not discarding. Lordship will find it's not throwing away. I have seen it myself. Serial page, internal page 5, if your Lordship takes, of the order itself. I better show it from the order. Miss such and such is then showing to be recommending giving Dabur Cool King talc to a person earlier using the product, the music continues. So, Millard, you replace this particular Millard product with Dabur Cool King. Now, Millard, kindly take omits Millard, Dabur Millard, then Millard, next, the fourth frame at page 5 of the order.
Yes.
Dabur Cool King talc then translate into the cool crystals of ice is shown that the person feels icy cool with the ice and mental in the background and contains mental crystals such and such. Now, Lordship will now take the next page, page 6. Millard, the second last, where is the modified?
Yes. That
Uh,
sadharan part.
Yes. Now, Millard, the Ranbir then compares the prickly heat powder, calling it to be sadharan, and indicates that Dabur Cool King has a superior cooling. Ranbir dala sadharan nahi, sirf Dabur Cool King they ice super icy cooling. So this is the bottle, Millard, which has his sadharan. Millard, so use Dabur. Now, Millard, then the ad ends with Ranbir surrounded by such and such. Everyone is surrounded by ice cool like crystal units. Now, if your Lordship takes the modified ad at page 692 of your Lordship's brief. Color আছে ওরা কালো করেছে কোথায় Now 693, if your Lordship takes 693 অত সব কালো কালো ভর্তি If your Lordship takes 693
Yes. 693.
bottom, green has been replaced and made into perhaps black. This was offered. And thereafter, 698. If your Lordship takes 698 or 696 bottom, that's part of the stay application. বসো না, চুপ করে
Yes. The bottle is shown again.
Yes. Now, Millard, 698. If your Lordship takes Millard, 696 Lordship and sees, the 698 gives a cooling effect. So 696 and 693 Lordship, the bottle is there. So Millard,
Sadharan is repeated.
Sadharan is there. Learned single judge Millard did not give me Millard protection on Sadharan. So Millard, in effect, Millard, 701, if your Lordship takes Millard, the word Sadharan is already there. Millard, may I place 701? The TVC ends with Ranbir Kapoor stating Sadharan nahi, Sri Dabur Cool King,
The
they
same
I super, same to same. So Millard, this was suggested Millard at the ad interim stage, which was Millard, or the interim stage without, which was when moved on contest.
But Mr. Ghosh, isn't this a question of associated memory? I mean,
Recall,
some other bottle being shown as sadharan does not affect you.
Yes, the
This
same
bottle
Millard,
does not resemble your product.
Millard,
the
each Millard
tapering.
has the Millard same type of Millard resemblance because the advertisement remains same.
Yes.
People have seen it once. That's the recall value. The people have seen it once. They visualize it. Same actor, same story, same Millard TVC. You replace, try to replace. I could have understood Millard, a whole generic bottle like a white bottle is given Millard. With it a distinctive bottle, you make the green into Millard blackish, and Millard, you say Millard, come to court. This was suggested and a date Millard which was not accepted by the court, by the interim order. And Millard, worst case is Millard, a vacating is filed. Millard, the honorable single judge records Millard, there is no necessity to file Millard affidavit Millard because the main matter is now complete. Now, main matter Millard, there is no change circumstances. The only allegation is Millard, look, Imami in some other advertisement has shown a generic bottle. I show Millard, it's a fully white bottle Millard, normal shaped white bottle. Now, Millard, kindly, and Millard, Imami has not been sued for that. Now, Millard, kindly have a look at the order itself. Millard, let us Millard take the order Millard. Just after the storyboard, it is contended that the impugned advertisement makes a direct reference to the product of the plaintiff. The same feature, configuration, design, color of the container bottle with the unique cap depicted in the impugned advertisement, which is only identifiable of the petitioner's product. It is also contended that the word Sadharan displayed in the bottle a bottle in the impugned advertisement with the white color and green cap having a distinctive tapered notch can only be identified with the petitioner's product. The use of the word Sadharan also reflects poorly on the petitioner's product. In conclusion, the impugned advertisement seeks to convey that the products of the petitioner are ineffective and useless. It is contended that the impugned advertisement has also been deliberately and intentionally conveyed in electronic and social media, which has a higher impact, and outreach has been displayed more than 2000 times over different media formats including YouTube and Instagram. As such, by hearing the impugned advertisement, respondents has particularly identified the petitioner's products while seeking to run down the entire class of talcum and prickly heat powder. In such circumstances, by specifically identifying the petitioner's product and describing them as ordinary or sadharan, the idea conveyed in the mind of a reasonable consumer is that the petitioner's products are bad. The respondent is also guilty of disparaging and denigrating and disparaging all other powdered products by describing the entire class of talcum powder to be ordinary, ineffective and useless. As such, the impugned advertisement also disparages the genus of talcum and prickly heat powders in general and specifically targets the product of the petitioner. In support of its contention, the petitioner relies upon a decision of Hindustan Lever Limited versus Reckitt. Decisions are there, only one or two else. Some of them are division bench. On behalf of the respondent, it is contended that the word Sadharan can never be per se disparaging and has been only used in a comparative sense without any sense of malice. So it's merely a puff. You are boasting your product. The entire case of generic disparagement is also untenable. In any event, the petitioner themselves on numerous occasions are marketing their products. Use the word ordinary and it's common to the industry. And
anything was produced to show that you use it yourself?
One Millard, their Millard advertisement, part of the vacating. I'll show what bottle was shown, Millard. Upon filing the suit, an ad interim order dated 11 July 2024 was passed, inter alia restraining the respondents from telecasting the impugned advertisement. The ad interim order dated 11 July reads as follows. This is very important. In the view of the above, the respondents is men, servants, agents, or anyone claiming to through the respondent is restrained from displaying and or playing or hearing telecasting advertisement Cool King by showing the bottle container Dharmikul and Navratna of the petitioner by referring the same to as Sadharan till 9th August 2024. So this was the order I was enjoying. Thereafter, the respondent filed GA number 2 of 2024 inter alia seeking modification of the impugned order on the ground that the respondent was willing to vary the advertisement by changing the design of the bottle and by removing the green cap as well as other reference of the green cap. Despite parties were unable to arrive at a concession, the primary bone of contention, the use of the ordinary in the modified advertisement, was not acceptable to the petitioner. It is true that the concession made on the respondent records and the ad interim stage to remove the bottle in the impugned advertisement and the green color is not binding. So there's a concession by the counsel on the respondent on the ad interim stage. Now, I do not know why it is not binding, Millard, in the final hearing. It's a concession given by a counsel. However, in view of the offer to modify the impugned advertisement by changing the labeling white and green container shown in the impugned advertisement along with cylindrical bottle, any further discussion on the aspect of the matter with reference to the impugned advertisement is academic at this stage. Once the reference to the petitioner's product is removed in the impugned advertisement by both color and shape of the bottle, that's actually not Millard. If your lordship sees 693 and 696, what is the bottle shown? It's a cylindrical shaped bottle he is showing with Millard. May not be so much tapered, but Millard, there is that ovalish Millard top there. If necessary, to add a touch of reality in such matter, consumers are not ignorant. Some way trademark law for all reasons and all intellectual property law is primarily meant to protect the public from confusion or deception. It is not the role of the trademark law to pander to illusion and amplify the image of the product. Undoubtedly, the role of advertisement or marketing cannot be undetermined. The use of the words like ordinary, extraordinary, exceptional, unexceptional without any reference to a particular manufacturer or a particular product or adjective descriptive attributes only add to puffery by the manufacturer, and no rival can afford to be hypersensitive. It is also necessary to consider in which context in which the word ordinary or sadharan has been used. Prima facie, the word sadharan or ordinary is being used in neutral sense without any negative connotation. The negative connotation, Millard, I give an example. Someone, my lord, floats, my lord, or my lord, airs a TV commercial with the product of the plaintiff. Court finds prima facie. Yes, this is the product of the plaintiff. Everyone sees it. The plaintiff is already defamed, denigrated the plaintiff's product. Now, after showing it 2000 times, my lord, the bottle is only replaced. I say it's completely replaced. It's not here for an argument's sake. It's completely replaced. But the same, my lord, advertisement is aired and permitted to continue with the word Sadharan. Will not the, my lord, person who has already viewed it in an electronic media do not have any recall value, that what you were showing is nothing but to demean the plaintiff in question? It could have been a different story, that it was initially launched with a generic bottle without any reference. So reference you made, you demean the product. Thereafter, when you are caught, you say that, well, I have shown it 2000 times, but now I replace with a generic bottle, but the recall value will not unfortunately remains. It's the same advertisement, same actor, same lead actor.
Mr. Ghosh, how far can you concede to the same advertisement continuing with whatever changes? I mean, no bottle will be shown, or
Milord, they can
pure
replace
white,
it. Milord, they can pure white bottle. What they have done, they have, Milord, shown initially
darker cap.
With a word of reference to ordinary. Now, my lord, ordinary, by showing to, my lord, the bottle in questions, have held by the court to be, my lord, disparaging
Yes,
itself.
but that bottle has to connect with your product.
Yes.
Otherwise,
Now, my lord, whether
recall value, apart from the recall value argument.
what was offered? Offered was I replaced with a fully generic bottle. Has he done so? At page 693 and 6. My lord, something, my lord, he does in future. I have a future cause of action. So far as this advertisement is concerned, my lord, we had an objection to it, because, my lord, it's a cylindrical bottle with a, my lord, now green, it becomes a black cap in question. Now, my lord, kindly have a look at, my lord. My lord, Tata Sons is quoted, paragraph 12. There is also no merit in the case of generic disparagement. Significantly, the respondent is a rival manufacturer and distributor of talcum powder. Both the petitioner and respondents are trade rivals selling similar genus of goods. In any event, keeping in mind the size of the class targeted, the generality of the charge of extravagance of excuse, there is no basis to the allegation of generic disparagement. Now, my lord, similarly, there is no substance in the argument that the identification and the impugned advertisement is so pervasive that even if all reference to the petitioner's products are removed, the viewers and the prospective customer would immensely associate and identify the products, any modified advertisement with the petitioner products. Admittedly, the advertisement has neither been, this was by a court order that he suo motu did not withdraw it. Admittedly, the impugned advertisement has neither been telecast or broadcast for nearly 6 months. The creation of such advertisement is time consuming and expensive. In some cases, it will be more practical and commercially to modify the existing advertisement rather conceive a new advertisement. In view of the above, there is no merit in the contention of recall value, and the same stands rejected. This is, my lord, where I, my lord, lordship has to consider. My lord, an advertisement which is per se disparaging, completely restrained by the court. It goes out of the market. It's not on the volition of the defendant. My lord, thereafter, defendant files an application in October. July was the order. And it is decided finally, my lord, by the impugned order in January. Now, my lord, my lord, take that 6 months and say, since court order has basically put it in the hibernation. Now, my lord, to take that recall value is again, it's pursuant to a court order, my lord. So it cannot be a weighing factor.
Whether it's pursuant to a court order or not, Mr. Ghosh, the recall value remains the same. The time span in between may affect the recall value in a negative way.
My lord, it will
Recall value will lessen. Definitely 6 months back,
6 months back, pursuant to a court order,
pursuant to a court order, not of their own volition. They are not, I mean, they cannot be treated to be an angel that they have. But even then, from the public perspective, which is the relevant factor here, now 6 months before someone saw that advertisement, where is the recall value there?
Now it's advertisement.
Unless somebody has a habit of looking at advertisements and
it's in the YouTube, it's fleeting, Miller. Nowadays it's fleeting.
Yes, 6 months back someone saw.
Now, Miller, the advertisement comes out with a cylindrical bottle itself and the word Sadhara. What is the effect in law?
All right.
There is also no question, Millard. There is also no question, Millard. kindly take, of pre-approving any proposed TVC as contended by the petitioner. It is true that the modified and changed advertisement is not the subject matter of the suit. Nevertheless, the contention that a modified advertisement cannot look into is unsustainable. Now, whether I am in court with a particular advertisement, Lordship restrains it or Lordship doesn't restrain it.
You are not seeking a dynamic injunction sort of
No,
thing.
I am not so dynamic. I come back if the second advertisement in question, I feel it's generic disparagement, or any event I have a cause of action to file a fresh suit.
Right.
Nevertheless, the contention of the modified advertisement can never be looked into is unsustainable. In order to complete justice between the parties to bring to the quietus to litigation, court while adjudicating such matter do take into consideration the modification, alteration and variation of the impugned advertisement in order to come out of the mischief of the restraint order or negate the element of disparagement. Now, Millard, he relies upon the courts in some cases have done so. Now, Millard, kindly take. The authorities cited by the petitioner on the aspect of ordinary or sadharan are distinguishable and inapposite. In Hindustan Lever, the court had arrived at a finding that the impugned advertisement clearly indicated intention to compare the two products, Domex Flash Guard and Harpic Plus Powder and Max Clean. It was held that clear reference from the impugned advertisement could be drawn by the person viewing the impugned video of the product of the Harpic. Similarly, in Parle versus Britannia Industry, it was held that the letter G in the advertisement also use of similar looking packaging of the video left no matter of doubt the defendant's products was identifiable. Moreover, in Dabur India Limited versus Colgate, the representation of the word interpretation of the in facts of the case of comparing Chyawanprash with Lal Dant Manjan. Hence, the genus of two products were distinct, separate, and together of the above discussion have to be read in context. In such circumstances, none of the decision support the proposition the word ordinary or sadharan per se without any identity can be interpreted deformated or I am not saying so. I am saying the bottle which now show is nothing but similar looking my bottle. In view of the above, the petitioner has been able to make a strong prima facie case on merits of the matter. So these are the findings against me. But the Honorable Single Judge holds, in view of the above, the petitioner has been able to able to demonstrate strong prima facie case on merits insofar as the impugned advertisement in concern. The balance of convenience is also in favor of the orders being passed. So, my lord, despite this, there's a prima facie case in my favor in favor of the impugned. In view of the above, the ad interim order that is modified to the extent there shall be a restraint order to the impugned advertisement. It is made clear the order is limited to the impugned advertisement whole and not to any particular portion of the word impugned, etc. Then, Miller, there should not have been any discussion on the word sadharan itself. I have a fresh cause of action to file a fresh suit. If he is not making, Miller, any, either he is approving the impugned advertisement or, Miller, not permitting the impugned advertisement, then simpliciter, Miller, this advertisement should have been restrained. Where is the question of this sadharan?
Let us please read para 17 again once.
17 I read.
In view of the above, ad interim order is modified to the extent that there shall be an interim order restraint of the impugned advertisement. It is made clear that the order of restraint is limited to the impugned advertisement as a whole,
yes,
and not to any particular portion or any particular word.
Yes.
So the entire advertisement is restrained.
Restrained. But, Millard, there is sadharan impugned advertisement has a reference to the word sadharan. So, in effect, Millard, the word sadharan has been taken away.
No, but Mr. Ghosh, let us understand it clearly. Now, they have modified that advertisement. It's a new advertisement now.
Yes.
So, you have not sought for any injunction regarding the new advertisement. This order is maintained. The previous order is
maintained, but it's saying it's modified.
I mean, where is the modification? We don't see any modification.
I don't see.
So why are you aggrieved?
Millard,
I mean, you sought an injunction regarding the previous advertisement that has been injuncted in general.
Kindly look at the order. Look at the interim order. I also got surprised. Look at the order in question.
But at the end of the day, para 17 clearly says that order of restraint is limited to the impugned advertisement as a whole.
Yes.
That means it's not dynamic in nature. Basically, the dynamic injunction concept that has come under some. Yes. Anyway, yes. So this is not a dynamic injunction. You did not pray for a dynamic injunction.
But I had prayed the injunction or referring to Millard
of the specific
the specific, and also not Millard the injunction with do not refer me as sadharan. That is the part of the interim
that was vis-a-vis the original advertisement.
Yes.
that original advertisement has been injuncted totally by this order, by the modification order
Now
also.
look
There's
at
no
Miller.
modification in fact.
Millard, he says it's modified to the effect. Millard, I do not know.
Can we see the original order once? And your injunction prayer.
Yes, kindly look at I also got surprised. Kindly take the
It has been quoted here also, in this order also, the previous order.
Said Millard, I allow the injunction application. Now, Millard, kindly take the petition.
Page 33, volume 1, Millard.
Page 33,
Thank you, Mr.
volume 1.
33, volume 1. That's the full order.
Yes. The petitioner has filed the
One.
present application.
Yes.
The petitioner has filed the present application for grant of an ad interim order. The petitioner was established. Now, Millard, kindly take, Millard, the portion. Millard.
Mr. Ghosh, if
Yes.
you may be candid,
Yes.
you have got a better injunction, better order in modification than the original order.
Millard,
While we are clarifying ourselves, then you make it. The
Millard,
original
kindly-
injunction was that they cannot show the bottle container of Dermicul and Navratna specifically.
Yes, kindly.
Now this is more generic. I mean, the
Millard,
present
kindly
modification which has been
Millard,
granted,
Kindly
that
take,
that advertisement cannot be displayed at all.
yes.
But they did not show in the first place Dermicul or Navratna.
Millard, what they are doing, they have the original advertisement is restrained.
They should have challenged, because we say why. The original injunction restrained them from using a bottle container specifically of Dermicul and Navratna,
Yes.
which they didn't do in the first place. They used that bottle, definitely it has a resemblance.
Yes.
But injunction restrains them from specifically using bottle container of Dermicul and Navratna. But now the injunction is that advertisement is stopped altogether.
But that has not stopped the modified act. Lordship has seen what is the modification.
That's a new cause of action, as you said.
It's
You
a
have
new
not-
cause of action, but is it, Millard, the part
The
of
modification is better for you than this.
kindly,
They had
Millard,
to show specifically Dermicul and Navratna in the previous order.
No, they have to basically, kindly look at
If you
Millard.
take this strictly,
Yes,
then the initial advertisement does not say Dermicul or Navratna.
Millard,
The bottle is shown.
is bottle shown. Now, Millard, kindly have a look at, Millard, the interim order, Millard. Let us read, Millard. Instant case, that's, Millard, internal page 40 bottom.
40 bottom, yes, in the
In
instant case.
instant case, the respondent in the TVC has shown an unhappy person holding the petitioner's prickly heat powder by still looking and sweaty sprinkling Dermicul. In the TV advertisement, respondent has been used the word Sadharan Nahi. Considering the above facts, the court finds the petitioner has made a prima facie case and balance of convenience in favor at this stage if respondent is not restrained by using the container bottle Dermicul and Navratna and also referring the same as Sadharan Nahi.
They're not using that in the first place. They're using a generic type bottle,
Millard, that's the shape of they didn't
Shape,
use it in
shape,
the first
nozzle,
place, Millard.
shape,
The
color.
names were not there, the shape was there.
But the injunction restrained them from using Dermicul and Navratna,
Yes,
not
Dermicul-
regarding shape and color.
Yes, that's Millard the bottle because the bottle Lordship says it's a shape because I have a registered shape. That's the Dermicul.
The
bottle.
injunction order does not say that, Mr.
Millard,
Kosh.
injunction
Injunction
is you-
says they cannot show bottle stroke container of Dermicul and Navratna
Yes.
specifically.
That's the Dermicul and the
But that
Millard,
does
this
not
is the
restrain
bottle.
them from using this sort of a bottle.
This is the bottle of Dermicul. This was before the court.
It's not written anywhere. The talcum
written
powder will go into
That's
your
my
nose
guess.
soon. So be careful on that. No, then we don't want a seasoning session.
Millard, I just put it in this way. Millard, initially also they did not write Dermicul.
If you hold that up, Mr. Ghosh, you will see that it's not a bottle of Dermicul or Navratna.
No, it's not.
But the bottle and the shape and the color is exactly the same.
Yes.
So this injunction does not restrain them even from using this.
Millard,
Because it's
this-
not a Navratna or
The court came to the conclusion. My case was names were not written. But this is a Dermicul bottle.
now the entire advertisement has been
Without
injuncted.
removing, Millard, the word Sadharan Nahi. That's the problem, Millard. That's otherwise, Millard, this is pre-approving an advertisement without by Millard affirming my
Then
order.
you are asking for a dynamic injunction without seeking so.
I have sought for a dynamic injunction, but I did not get it, Millard. In initial stage, this was the order. So in effect, Millard, kindly look at the effect, Millard. What is
Let
the
us see your prayer once.
Kind. Great.
The injunction prayer.
Injunction, page 98, Millard, volume 1. Prayer, the respondent, page 98.
Yes.
The respondents and other men servants, agent representatives claiming through the respondents be restrained from displaying, airing or telecasting or displaying whatsoever the impugned advertisement developed by the respondent for cooking prickly heat powder of the storyboard annexure M. So annexure M injuncted. To the petition or any other advertisement including the print advertisement media
Acha.
or or the disparage and or defame the petitioner or its talcum powder, prickly heat powders manufactured under the trademark Dermicul by referring the same as Sadharan and or infringes the petitioner's trademark and the shape of the petitioner's distinctive bottle cap design and the trademark being such and such to the petitioner. Otherwise, any other bottle which is identical or deceptively similar
The
to the
second part of your prayer is too wide. It's an omnibus prayer. That any other advertisement, including any print advertisement, which purports to disparage and defame. What purports to disparage and defame, that has to be decided by a court.
Yes. Millard, now Millard,
I mean,
if you
they cannot do it. Whatever they do, you can say that it is disparaging you.
no, may not be. They may.
So
they
the
may
second part is rather omnibus in nature.
Millard, this is my prayer. So it's covered by the suit in question. But Millard, when you are holding, Millard, there is an advertisement. Sadharan part was restrained initially.
You sought an injunction regarding the impugned advertisement developed by the respondent in the first part.
The shape of the bottle, Millard, that is.
What is that in the prayer?
Millard, kindly look at Millard, the prayer in question.
Register shape,
Yes,
yes, at the end.
And Millard, registered shape of the
Or the
petitioner.
register, yes. Right.
Cap design. These are my registered bottle with the registered
True,
shape.
true.
In Millard, design Millard, color Millard cannot come in the way Millard. So shape and design both are there.
Shape
So
and
these are both Millard, shape and design. So this was there which initially Millard.
So you don't have a trademark on the color.
No, color scheme Millard, there is no Millard trademark.
So your color argument goes.
Color argument, it's a Millard, in a disparagement matter, it's a question of recall value.
True.
I Millard come up with this bottle.
But in the
People
first
think-
place, you have to have a trademark on something.
No, I
for it
don't
to be
need.
dispensed.
In a common law, Millard, there is no necessity of getting a trademark registered.
All right.
In common law, Millard,
All right. Yes.
one can acquire a right to a mark or a shape of goods or Millard any artistic work or Millard any layout get up by user.
That pleading is there.
Registration, Millard, and
That
I
that
just
pleader,
told-
that user over a long period is pleaded.
Yes, 74 it's pleaded, Millard.
Very well.
Now, Millard, I'm little since Mr. Sharkar is appearing on my other side, I am little confident. Millard, registration of a
So how does it make a difference that Mr. Sharkar?
I can't follow what my learned friend saying. Doesn't want me to appear.
Millard,
No.
my friend on my left.
Whether he is Sadharan or Asadharan, that has to be.
He is Oshadharan. For him, Millard, there is Millard. He's Oshadharan.
Acha.
Now, Millard, who knows the subject better, or you have learned from him, Millard.
Definitely.
Now, Millard,
Yes.
trade registration of the trademark, Millard, doesn't create a new right, Millard. It's Millard recognition of your pre-existing right under the common law by our statute.
All right. Yes.
This is the
Accepted.
exact phrase, Millard, which
Accepted.
Supreme Court says.
Yes.
So, Millard, this is the recall value in question. Now, Millard, this is my prayer. Millard, the learned single judge could have simply said, Millard, Millard.
So in effect, Mr. Ghosh, what you are aggrieved with is non-grant of the last portion of page 99. Because the other portion has been given that advertisement has been stopped altogether. But this non-user of registered shape and of the distinctive bottle and cap design, this is what you are now aggrieved with.
Now aggrieved with the word Sadharan written on it. Because Sadharan was initially restrained.
Very well.
Sadharan nahi. That was restrained. That's part of Millard. The
Yes,
order.
yes,
He quotes
yes.
it. Now Millard, the Honorable Judge Millard says, Millard, I am confirming the injunction to the impugned advertisement in question. Where is the question of modified to such effect? It can be interpreted both ways. That's the reason, Millard, I am in appeal. My learned friend has accepted the order because this was his offer on the first date. Because Lordship, if your Lordship kindly, Millard, takes Millard the initial order in question, if your Lordship takes Millard the initial order at page 33, volume 1, where Mr. Sharkar's submission is recorded.
Yes.
At page, per contra, middle paragraph. Per contra, Mr. Sharkar, learned senior advocate appearing.
Page 33.
Page Millard 39, bottom, just after Mr. Bachawat's submission.
Yes. 39.
Per
Mr. Shah.
contra, Mr. Sharkar, learned senior advocate representing the respondent submit that the petitioner before filing the suit and the present application has not issued any cease and desist notice to the respondent so as to take appropriate steps by the petitioner. Mr. Sharkar submits that the respondent will remove the bottle container from the advertisement, if the court permits till Monday, he submits that the respondent has directed telecast in advance. It is not possible for the respondent to immediately remove the same, and it will take some time to remove the bottle from the advertisement which the plaintiff is in objection. Mr. Such and such submits that the petitioner having objection with regard to the bottle and the respondent will remove the same, but the total advertisement cannot be stopped. Mr. Such and such submits that Article 19(1) of the Constitution of India, there is a freedom of speech and same cannot be restrained by the court order. So this was Millard not permitted, Millard. In fact, Millard, he offered on the first day, Millard, I replace with this particular generic bottle. The court still felt that this will any event be, Millard, disparaging, Millard. Millard, this is, with deepest of respect, my man, it's senior, Millard, Mr. Sarkar, this is some sort of a concession by the counsel appearing, Millard, before a court of law. That particular, Millard, I am going to replace with a particular shape of the bottle.
So what has not been granted now is the shape of the bottle.
Is the shape of the bottle, Millard. That he will, that to continue.
As well as the shape of the cap.
I
Tapered notch and all.
put it in this way, Millard. Sadharan is one part.
Yes.
There was an offer to replace this particular bottle with a black cap or say any other cap. That offer was given to the court. There was a concession, Millard, by the advocate that I'll replace it with the generic bottle. That is not.
No.
If there is any mistake.
But I'm sorry, Millard, I have to correct my learned friend. Millard, I made no concession about any bottle. I removed the bottle, all bottles altogether.
There is there. I will withdraw the term.
Let him finish, Millard. Let him finish.
Yes. Yes, Mr. Ghosh, anything else?
There was offer. I say there was offer. Millard, concession, Millard, it's a bit harsh. Let's take it, Millard. There was an offer. Millard, there was an offer to replace, Millard, this bottle with a generic.
No, I'm sorry, Millard. I made no offer to replace any bottle. I said, if an injunction should not have been granted, I said, I'll remove the bottle altogether.
He's not used the bottle altogether. That is the offer given. That appears from the order also.
No order should have been passed in my submission.
Very well. That was not, Millard.
So if the bottle is removed altogether, Mr. Ghosh, your problems are solved.
Yes. Which bottle? Now there is a bottle in place.
That's the offer I made, Millard, at that time.
They'll change that. They'll remove the.
Look at the changed bottle with Sadharan. Look at the changed bottle.
No,
Millard,
because there is no injunction. If that offer, no, Mr. Ghosh, if that offer was not accepted, that's why. If Mr. Sarkar still offers that he will not show any other bottle than his own product.
His own bottle he can show. Can he
his
show?
Own bottle obviously has to show.
Bottle associated.
Mr. Sarkar, let us understand you clearly before proceeding with Mr. Ghosh.
Yes.
Do you say that you won't show any other bottle than the bottle of your product in your hand?
No, I'm not, Millard. I am only, I'll answer my learned. Millard, on that day, Millard, I offered to Millard that showed no bottle at all in the advertisement. That is no longer the case, Millard. To my bona fides, I come back, Millard, with my own bottle, which is, Millard, not his bottle at all. I will answer my learned friend's argument.
Very well, very well. Yes.
You will come back.
May I just point out, Millard, the argument about design registration was not advanced, but at any stage with learned trial judge, and not even recorded anywhere. It was not pleaded, prayer was there, no argument ever had. First time I'm hearing this argument.
All right.
And but with respect, Millard, that should not be permitted in the Court of Appeal. Somebody must not urge before the trial court, Millard. Lordship should not permit that to happen. I can answer that point on merits also. But Lordship should not permit that to be urged.
Very well. Mr. Sarkar, let us complete with Mr. Ghosh.
Yes.
Mr. Ghosh, you get a clue of one of his points. Yes.
Millard, the argument which was advanced, that Millard, it's a case pleaded that Millard, this bottle shape is registered, so there's an association. It's not a design infringement because there cannot be a design infringement in an action for disparagement. Why, Millard? Infringement of a design can happen if someone gets a shape registered. It's an application on, Millard, the goods. So, Millard, per se, there is not a design infringement case. The application on the goods, the shape is applied to a particular goods in a tangible form.
Yes, the association between the two.
It's an association. So, Millard, design registration have shown the cap is registered, the notch is registered, etc., etc. It can be a copyright case in an advertisement. Can be. It can be a trademark infringement within section 29(8) of the Millard Trademark Act. But there cannot be, Millard, a infringement of a design vis-a-vis, Millard, disparagement, because, Millard, there is no application of shape to a tangible form. That's, Millard. So, Millard, naturally, Millard, this can't be argued. It's a case of association. Now, Millard, the offer was to change it. He will use some other bottle or, Millard, his own bottle. Now, Millard, kindly.
Let us see the two bottles side by side, Mr. Ghosh.
This is, Millard, the.
Yes, we understand which is which.
This
The
is
other bottle?
the other is mine. Let him use Miller this bottle. This is the
Correct.
tapered notch one. Kindly now sees what he is using it now. 624 if your lordship takes.
693 and 94.
Yes. Kindly also 693 and 94 lordship takes that par.
But the taper in the bottle is not very visible. I mean, we don't know whether it's the quality of the picture.
Miller, this is Miller. He is showing
694 is something else, Mr. Ghosh.
yes, 696 lordship.
693 and 696.
Yes, yes. These are the two places. Millard kindly takes Millard. The old bottle is gone. Now, Millard, what is there is
The
basically
is the taper visible at all in this?
Millard, this is Millard. That bottle already shown
You
in
put
one
up their
article.
bottle, you see whether there is a resemblance with that also.
That also there is no resemblance. So, what was the offer initially?
No, if you put it up, their bottle. Now, this is somewhat like their bottle, in fact.
This is their bottle. How
The
can
shape, only the shape.
their shape has Millard all
The
this
taper
Millard,
is not clear from the cap.
they have grooves by this side. It's not a cylindrical
No,
bottle.
they are not showing their bottle as Sadharan. They're showing generic bottle as
Bottle
Sadharan.
as Sadharan.
Obviously, they'll not show their bottle
Yes.
and say
Now,
it's
the
Sadharan.
entire effect of the advertisement remains the same. Maybe it's replaced by
Whether this can
bottle.
be associated with your product.
Yes, kindly take Miller 2. It's green, black, whatever Miller. Kindly takes Miller these two bottles in question. White body with a Miller darker cap.
We are not sure whether the taper is visible, very visible there.
There can be a remote association also. If there is Miller, this Miller cannot continue.
All right.
It's a question of recall value. Because one recall value is with the public, the advertisement goes out. It comes up with a different cylindrical bottle with a different color cap. I put it in this way. With the word Sadharan. If the word Sadharan is not there, it loses significance altogether. If the word Sadharan is there, there is a significance. This is the argument all about. The design infringement is immaterial here. And my suit covers it. Because
The association with the
be
product.
covered.
Yes.
It's covered by prayer, maybe it's broader, it's not narrower. Now, Millard, the learned Judge Millard, and 384 is the original advertisement. If you're 386, 384 and 386 original advertisement. Compares it with 693 and 696. Of course, with the word Sadharan affixed to it or running with. And I have 42% share in the market. Who else is Millard being targeted than me, Millard?
এটাতে টেপারটা তো বোঝা যাচ্ছে yes
Yeah.
yes গ্রিনটা জাস্ট একটু ডার্কার করে দিয়েছে
If the advertisement is stayed altogether here, because this is his vacating application. And the vacating application, the ground is very interesting. That in some advertisement, that's his only
yes
main point in the vacating application. If your lordship takes the vacating application in question, which is page 604, which you are showing.
what was the premise of the order 39 rule for undue hardship?
Millard, they have offered to change the bottle. It's a generic bottle in question.
No, the ground of order 39 rule for which ground? Undue hardship must be.
Undue hardship. Then Millard,
What
he has
else?
basically undue hardship.
Can
is
be
the
only
main-
undue hardship.
And Millard kindly takes his vacating application, which starts at page 603, starts at page 604. Lordship, first foremost point that this green cap bottle, his main thrust of argument, this green and white is basically used by various other persons. He has given the shapes in question. My bottle is shown. Now, Millard,
609 is your.
yes. Now, Millard,
Others
Six-
have been given also. Other pictures,
Yes.
other product.
Now, Millard, in some advertisement, I have used a generic bottle that's 616 continuing to 617 as ordinary. I have used, Millard, a normal bottle in question. Millard, I have not been sued for that also because I writing ordinary talc. Look at the bottle shape. This is some unique shape. This is the old cylindrical bottle shape. We have used this powdered shape bottle.
You have also said ordinary.
Ordinary talc. So this is his ground, but look at the shape of the bottle. No
Yes.
resemblance from anyone.
No.
Only now Ponds even Millard stopped using the cylindrical bottle. This is a generic bottle. Not what you are showing at 603 and 604. With the word Sadharan. So this was his ground. You replace it with a cylindrical bottle without reference to Sadharan. Because kindly appreciates the situation. If a plaintiff is holding, Millard, more than 40% share in the market,
What can be more innocuous than Sadharan? I mean, if you don't, I mean, this, whether it's a denigration. Now, unless you say that your product is better than the other one.
yes, of course, it's buffering. Millard, kindly, Millard, appears, takes two things, Millard. It's a question of test of, Millard, what Millard a reasonable man thinks, Millard, in this parity.
Yes.
Now, Millard, it's a test where a bottle is there, which is not a normal, I say a generic bottle. This is a generic bottle which is appearing at page 15. Cylindrical bottles we have seen, Millard. So, Millard, a bottle which is more or less a different shaped bottle and with a different shape, different colored cap. A competitor is using it. So, Millard, green is removed with, Millard, say some other color, or Millard, little modification is there, Millard. With the word Sadharan, someone will have a cause of action in the suit because the suit praise covers it.
Even if you grant an injunction regarding Sadharan, there is use a synonym. And you cannot go on doing this.
Millard, Sadharan, by my...
Ordinary, there are several synonyms.
Yes. Millard, kindly look at, Millard.
They can use something more crass also.
There are, but courts have said when a product is shown with, Millard, side by side Sadharan, then it's, Millard.
Sadharan is, isn't it innocuous? I mean, Sadharan, it's Sadharan, I am Asadharan.
I am Sadharan, you are Asadharan.
Now, what more innocuous could it be than Sadharan?
Yes, Millard, what is wrong, Millard?
Yes, we thought initially it was being thrown out or something like that.
Yes.
I mean, it was not being thrown out.
No, it's they are giving that don't by application you get it's discarded, not thrown out. It's discarded.
No,
It's discarded.
Discarded is a very, I mean, wide term. It's not
Or
being
will
replaced.
It's replaced.
Replaced by their product.
Yes, replaced by their.
Not discarded, it's something else.
You don't because in effect, Lordship has to see the impugned advertisement also. It's the same advertisement. It's nothing new. Nothing new. He has come forward. I am trying to cover it by the suit. By Millard, the fresh injunction.
No, this modified advertisement which has been annexed, that was being done prior to the modification order of Justice Kapoor.
Yes.
Prior to that.
Yes.
So now, as per Justice Kapoor's order, that entire advertisement has to go. But they can still use, there is no other restriction that you're saying. Sadharan is not removed. They can use Sadharan again.
But not by the means of this advertisement in question. Millard, the advertisement is same. Lordship takes it. Only 2 frames have been removed.
This is still going on, the modified advertisement, even after Justice Kapoor, the impugned order.
That's I would have been in a difficult situation, Millard. If Millard he has come forward with say replacing Ranbir Kapoor by Amir Khan or some other Millard celebrity or
Whichever one you prefer.
Whichever one, Millard. Nowadays, Millard, I don't see my next generation sees the movies. I do not.
You're not so old, you say.
No. They take.
Amir Khan is of even
He's
elder than
brilliant,
us.
But
So
people do not. My next
anyway,
generation.
let us not discuss on these.
Yes.
The heroics of heroes.
Yes. Some other Millard advertisement with the word Sadharan, which I am trying to cover it by my present suit. It's not such a case. It's the same advertisement with Millard, which has been restrained. But
We can have the ladies removed or the fire removed if you want.
No.
Tomorrow you will come up with that.
No, why? I am concerned with my product only. Now, Millard, if it is done, Millard, with deepest.
Court has said Sadharan is not, so you are being hypersensitive.
Yes, that's all. But
is it such a case that we should interfere in an inter-court appeal? Sadharan aren't you being hypersensitive? You replace it with a better word with which you wouldn't be aggrieved.
Millard takes Millard the word Sadharan.
If I project my product, I have to not disparage, but I have to show that it's better than other products. So what else could be used?
It's better than the other products, but if buy of the same advertisement, Millard, it's the same advertisement. I'm not, it's not a different advertisement. You just try to, Millard, little modify, Millard, the 2 Millard bottles in question with the word Sadharan. That is the test, Millard. Test is not that a new advertisement I'm seeking to restrain altogether. In our old suit, he has come up with something. He has modified the advertisement 2 screens only. The same thing is there with Millard 603 and 609, the page numbers, with the word Sadharan. This is where Millard it says, because then Millard a simple Millard injunction, Millard, without discussion on the Sadharan at all. What is the implication, Millard, one would have seen. Now, this in effect permits him to make this advertisement. He had said, because otherwise, Millard, the Honorable Single Judge would not have said the order is modified and relating to the injunction. then it's a case of further injunction.
The modification is in your favor. The previous injunction was that they cannot use the bottles of Navratan and Dermicul. They're not doing that. They were not doing that in the first place.
Yes.
That was the injunction.
Yes, if that
So
is-
by virtue of that injunction, they could still go on doing what they're doing. They're not using the products of your, not
now
using the
this
bottles.
injunction has been restrained altogether. This,
Now- Now that advertisement has been.
has been restrained.
Very well.
altogether.
You will be happy, Mr. Ghosh, if Sadharan is also included in the injunction, and they cannot use the shape and the contours of your bottle.
Yes, that's all. Yes, that's all. That was my prayer, Millard, altogether.
Very well.
Millard,
No advertisement with the shape and color or whatever. I
I
mean,
just
anything to associate with your product.
yes. Millard, kindly have a look at ওই একটাই judgment দেখো আর দেখিয়ে ওই দিল্লি ডিভিশন বেঞ্চ কোনটা কোনটা না
আপনি এসছেন না যাচ্ছেন? আপনি তো আগেই এসছেন, এখন বাবু করছেন।
ডিভিশন বেঞ্চ paragraph 40 just
Yeah.
one judgment and I may not sit. Lordship, just give me a moment. Harpic domains. Are division names দেখো kindly have a look at Hindustan Lever to this one. Millard, this is HUL versus Reckitt Millard. Kindly have a look at this is a Delhi Division Bench. This is reported in 2023 volume 95 PTC 239. I have given Millard the Manupatra copy because it has the diagrams in it.
But the paragraphs have to. We will.
From Manupatra because SCC nowadays many cases Millard in this type of matters diagrams are necessary. There were 3 advertisements in question. Copy dilam to Judge Sahib. 2 copies I have given.
Yes, yes, absolutely.
Patata bolo, third advertisement. There were 3 advertisements in question. There's a third advertisement. Patata bolo. Internal page 9, which is on the bottom, Millard. Millard 7, Millard 9 of 14.
Yes.
Kindly, Millard, look, Millard. The third video. There were 3 videos, 2 videos, products were shown. This is a third video in question, which the third impugned video title, Domex flat gas helps skip bad smell. A bottle is shown. Lordship remembers, Harpic bottle is a blue bottle with a red cap. क्या साधारण टॉयलेट क्लीनर बदबू नहीं स्किप कर पा रहे? Kindly look, Millard, the Sadharan bottle, it continues. This is the third. Millard, I read the product, no product's name is mentioned. In this type of matters, normally, if there is no Millard, very Millard, actual comparison Millard, normally in cars, Lordship will get 100,000 cc's 998,
Yes.
which is not Millard, absolutely Millard, side by side products.
That's a comparison of the parameters section.
Parameters. Millard, then Millard, the names are not mentioned.
No, this was blue. This is a black and white picture. So this was the original was blue in this case. Are you?
No,
You have it?
Lordship, Harpic bottle is blue.
Acha, no, this advertisement. This was.
It is as it is. As it is, they have printed. What they have done, they have.
This is in black and white. So we don't know anyway.
Oh, colored নেই কালারটা তোমার ট্যাব থেকে দাও তাহলে
No,
তাহলে ট্যাব থেকে আই এম ভেরি সরি কালার প্রিন্ট আউট নাওনি কেন আমি তো বুঝতে পারছি না
no, original. The judgment. This is from the.
Brother,
Manupatra
Lordship,
gives a color copy.
yes colored I have it in the colored copy
Is it blue or not? We are just
no
wondering.
it's not তুমি নাও বার করো আমারটা
Let him find out the colors. In the meantime, you continue. Blue or whether it's blue or not.
Lord
with a red cap.
yes Lordship will take it
With a red cap.
What bottle?
Grayish
Hey,
bottle.
okay.
With a red.
I am very sorry Millard
No, it's sure.
টমিক্সটাই দেখাবো আর কিছু দেখাচ্ছি না আর ম্যাড্রাসটা দেখাবো এই দেখো
গ্রে করেছে নেগেটিভ একটা গ্রে মানে হচ্ছে নেগেটিভ একটা বাজে গ্রে ইয়েস গ্রে ইয়েস ইটস only one shade of gray so no difficult
কপি চাইছে Millard kindly takes
Yes.
the advertisement. The advertisement is shown as Sadharan. The
yes we have seen it yes
water.
so
Now,
Sadharan yes
Yes, Sadharan.
No.
Now, Lordship will kindly take paragraph 42.
yes please
We are also unable to accept the shape of the bottle shown as ordinary toilet cleaner is not similar to the shape of the bottle used by Reckitt for competing products. Harpic, it is well settled that similarity between the competing trademark is not required to be resolved by juxtaposing them closely resembling the various features of the trademark. Similarly, between the trademark is required to be viewed from the standpoint of a person of average intelligence and imperfect recollection. The question is whether such a case person viewing the shape of the bottle is impugned videos could consider the same to be depicting the bottle of Harpic. Prima facie, the answer is required to be in affirmative. Now, Millard, kindly take Millard. Next, we concur with prima facie view of the learned single judge. The shape of the bottle as depicted is deceptively similar to the Reckitt's trademark. We trademark a source identifier, and therefore no informative for reasoning of the depiction of the bottle of an ordinary toilet cleaner in the is likely to be identified as the Reckitt's product Harpic. Now, Millard, Hindustan Lever and Colgate is quoted. Now, kindly take para 47. There is no dispute that comparative advertisement is permissible. However, the same cannot disparage the product of the competitor. It is permissible to advertise a particular feature or quality of the product is better than that of the competitor. However, it clearly subject to the condition that the overall advertisement must not be misleading. A statement of fact or a misrepresentation made in the advertisement must not only be accurate but also should not be misleading as well. This has to be viewed from the standpoint of the customer that the advertisement seeks to target. For instance, it is possible that a particular feature of the product which has no material relevance is feature a competitive craft advertisement by reflecting the product of the advertiser to be superior of the product. Whilst the statement regarding competitive features may be true, the overall commercial may be grossly misleading. Now, Lordship, Meghalaya Kalartek is quoted. This will kindly have a look at paragraph 52 in question. The question whether the test report we are not given the nature of controversy, no infirmity, and Miller has not indirected broadcasting but merely directed to remove reference paragraph. This should be Miller. Given the nature of the controversy and the facts, the learned single judge has not interacted essay from broadcasting the but merely directed that to remove all reference to Reckitt products and the bottle representing ordinary toilet cleaners as the same is identified with the Reckitt's product. So, ordinary toilet or ordinary should be removed. This judgment Miller says follows Meghalaya Kalartek. It says so Miller. আর কোনটা দেখাবো বলো? Madras to just one more Madras division bench which also no কপি দাও একটা আমারটা দাও না দেখতে পাচ্ছি জিলেট এসসিসি থেকে নিয়েছো
Yes.
Kindly, it's a very long. This was in Wheat Miller, also Reckitt Miller. Kindly have a look at this very longest judgment. I just straight away take Lordship Miller, paragraph 89, 88. As held by the Supreme Court in Tata Press versus Mahanagar Telecom Limited, advertisement is a part of a commercial speech and the right to advertise a part of a commercial speech is a fundamental right under Article 19(1) of the Constitution of India. Right to advertise in our view is also an integral right to carry on commerce, trade or business as it is through the advertisement an entrepreneur can promote and sell goods and services. Moreover, advertisement itself a business and the importance of finance, important source of finance for print and electronic house of the film exhibitors, magazines, etc. At this stage, we do not deem it necessary to go in the question whether the fundamental rights conferred in a citizen under Article 19 of the Constitution are well available to the appellant, which is a multinational corporate body, since the respondent plaintiff has not argued the point. However, the facts remains the right under Article 19(1)(a) and 19(1)(g) of the Constitution of India.
Both of you are Indian companies.
Millard, yes. Both of us are Indian companies. 19(1) of the Constitution is a reasonable restriction of all, including fundamental rights, limited to the extent which does not infringe the right of the other. The right
These are settled propositions. Probably Mr. Sharkar won't be disputing. So
Millard, kindly Millard takes Millard paragraph 95.
yes, 95.
Even though it is now settled that comparative advertisement is permissible and it's open to the advertiser to compare the goods or services advertised with those of others, and portray the goods or services as better than those of the others. This can only be done without denigrating or disparaging the goods and service of the others. The meaning of the word disparage as a given in the commonly used to in dictionary inter alia to seek slightingly to undervalue or to bring discredit to honor or disrepute to de- degrade or denigrate or defame the approach or to justify the class. Disparagement inter alia is the act of speaking slightingly or undervaluing or bringing a discredit or dishonor or deprecating or degrading or disgracing or unjust classing. It also means derogation, derogating or degenerating or defamation. When an advertisement is disparaging or not would depend on several factors. For each advertisement would have to be judged on its merits on consideration of the overall impact of the picture that is to be portrayed in the language used in the histrionics and and gesticulation and movements and acrobatics, catchphrases, hierarchy and other catchy scenes. While humor, hilarity, or other even ridiculing, highlighting advantage of one product may permit ridiculing the services and products of the other amount to disparage. To decide whether an advertisement disparages any court has to consider the intent of the commercial advertisement, the message sought to be conveyed, the mode and manner of conveying the message, condemning the goods and service of a competitor, or ridiculing the same or showing the same as substandard would amount to disparagement. Of course, as stated above, mere puffing of one's products or services in comparison of one would not constitute disparagement. It may be permissible for an advertisement to compare the technology or formula of the products in an attempt to impress upon the viewers of the superiority of the products and the articles advertised over those others. In the process of the advertise, maybe even the brand the modern technology or formula, but while denigrating or disparaging the products of the other. Now, Millard kindly takes Millard, paragraph 102. Now, paragraph 101. Advertisement in electronic visual media have indelible impression in the minds of the viewers. The medium of advertisement has a greater impact on the viewers of advertisement noted in Delhi High Court in the GlaxoSmithKline written a catchy phrase or an enacted slit or a slurry or even a distinctive sound or a distinctive pollution of color make a lasting impact and more so when viewed repeatedly. Moreover, different consumers viewing the same comparative advertisement may come to different conclusions. To constitute disparagement of a product, the message conveyed should be defamatory or disparaging. As argued by Mr. Raman, a truth may be legitimate defense to defamation, derogatory or disparaging message. However, if an advertisement apparently conveys a matter which appears to be justification of a truth, would necessarily have to be decided as trial. This is not a defense bill on 67 from 1967 because India we don't have jury trial. In granting interim relief of injunction, the court is required to examine whether the plaintiff has made out a strong prima facie case, whether pecuniary compensation would afford to the applicant an adequate remedy. Now, Millard, kindly have a look, paragraph 107.
Yes.
Each advertisement has to be judged on merits on consideration of overall impact of the picture that is portrayed, language use, historic agents, movement. In issuing an advertiser is legitimately entitled to highlight the advantage of his own product over similar products of others. And a mere comparison with the products of the other highlighting one's product's own advantage would not amount to disparagement. In a disparagement suit, court have to examine whether the object of the advertisement is to highlight the benefit of the product of the advertiser in comparison those of the other or to denigrate the products which would amount to defamation. This is exactly because here it's the same advertisement by removing Miller two clips Miller or replacing two clips. What was your intention? Malice is not necessary nowadays, Miller, though malice is one of the parts, Miller, essential. Now, paragraph 110 or 109. In judging the impact of the advertisement issued inter alia in audio-visual media, it is important for the court to keep in mind that watching the television and surfing the internet are part of the daily routine in the every household. An advertisement has a great impact on the viewers who are potential buyers of the customer's good. Just as novelty of an advertisement attracts the intention of a potential buyer, the novel way of derogating the goods and services of others would also leave a lasting negative impression to deter the potential customer. So this is where what was my argument, Millard, is this, Millard. The novel way of denigrating the goods and services of other could leave a lasting negative impression to deter the potential customer. In judging an advertisement, one has to keep in mind the potential user of the goods and services advice. Depilatory creams and hair removers as also razors of they are likely to be purchased by class of more discerning customers. Customers conscious of their looks and hygiene may not likely to be carried away by gimmicks or purchaser of daily household food. Like no one could include less informed or less economically weaker society, more likely to be influenced. Now, Millard, kindly have a look at, Millard, the last part. And Millard, ultimately, Millard, if your lordship takes, Millard, last part, paragraph 115. The overall impact of the advertisement is disparaging by the reasons of the depiction mentioned above. Even more, the discerning purchaser of a depilatory creams are likely to be swayed. Overall impact of the advertisement, and in particular assertion that all depilatory creams, urea, TC acids and other chemical strong bathroom clears, read with disclaimer, based on analysis and technical test of pH level 12. It is difficult to accept Mr. Arman's argument only educates the public on various feature removal. So there was a disclaimer also. It is true that argued by Mr. Raman, there is no specific reference to wheat. As Lordship Millard on the first impression, Millard said, Millard, no specific. So, Millard, where is the question?
No, that was the first injunction granted. That's not our view.
I'm sorry.
The first injunction granted was that your products cannot.
I stand corrected. I'm very sorry. It is true, as argued, there is no specific reference to wheat in the advertisement. However, admittedly, the respondent plaintiff dominates 80% of the market in depilatory claims as observed above. The overall impression created by the advertisement by your video clip is that all removable creams which do not include hair removal creams of the respondents are harmful, having strong chemicals and strong bathroom clears. Prima facie, there is disparagement of the deliberate cream of respondents. Defense of truth may be a good defense in the disparagement suit. However, whether the advertisement is truthful would not necessarily have to be adjudicated upon trial. Dispute as to the acidity and alkalinity of the depilatory claims of respondent is beyond this, cannot be decided. For the reasons above, the appeals are partly allowed. The order of the learned single judge is applies to print advertisement. The order of injunction is affirmed in respect to advertisement by way of video clip. With the clarity, injunction will not prevent the displaying or displaying advertisement in electronic media after editing and removing offending portion of the advertisement. This should be the order. Remove the offending portion.
But what would be non-disparaging is anybody's guess. I mean, you cannot implement this order.
That Millard, I will have Millard if he does so. Millard,
Cannot implement this order.
It's Millard.
We can say they will not use any. Even today, we can do that. Non-disparaging.
Non-disparaging.
What is non-disparaging? What is not the? I mean,
that is
you cannot implement that order.
It's made clear the observation of prima facie observation, etc., etc.
Anyway, yes.
Now, Millard, if Millard, this was the intention of the honorable single judge that I will confirm the order, it's not necessary, Millard, to go into it. Gives Millard because the same advertisement. Lordship has to see the vacating application. That was before the honorable single judge.
The modified one.
The modified one was before. That's page 303, 603.
Yes.
That's there. So it's Millard A and modified Millard, little modification of advertisement data. It's the same advertisement. So Millard, in effect, saying all this, he has basically approved it without Millard passing such an order. Ar kichu dekhano dorkar nei to. Konta dekhano? Just Millard, let me say this. Let me ask them.
Single word পুরে রেকর্ড এটা 77টা দেখেন তারপরে 79
স্যার বুকলেট আমি তোমাকে দেখিয়ে দেবো এটা
77 সেম কেস 77 এ গেল তারপরে
Now Millard, I do not understand Millard.
77টা আগে দেখতে হবে
If someone is called as ordinary Millard, if he is aggrieved by a court order and he gets an injunction Millard on Millard, whether Millard this lies, this is Millard, of course a single bench Millard.
তারপরে 70 that is the clue
Judgment আমাকে একটা কপি দাও একটা কপি দাও
Human being called ordinary.
Yes,
What a product.
Kinetic Dabur versus Colgate Palmolive 2005 79 DRJ 461 other side a copy এটা আমাকে
79 টা দিয়েছেন তো
paragraphs 2 to 5 কপি দাও একটা এটা পড়ে দিই পুরো করতে হ্যাঁ আসছিস কেন Millard, kindly take Millard. This was cited in the court below. It's Dabur versus Colgate Palmolive. The application seeking directions has been filed pursuant to the order of the division bench, which as follows. During the hearing of the appeal, the appellant has given a modified version of the storyboard, which is at page 83 to 86 of the paper book. The learned counsel for the appellant said that this court may take modified version and decide the controversy of the matter. As a matter of fact, single judge passed an order on the basis of the impugned storyboard at pages 37 to 41 of the paper book. Judicial propriety demands that the modified version of fresh application be filed by the appellant. Let the application be filed by the applicant before the learned single judge, and the learned single judge after affording the opposite party an opportunity to hear and pass expeditiously order with expeditiously. Now, the division bench. As per the aforesaid judgment of the division bench, a modified version has been proposed by the defendant by this application. Some of the captions are modified, wherein the purchaser is asking for Dant Manjan and the star advertisement Sunil Shetty is warning about Sadharan Dant Manjan, which is said to be khurda or rough on the teeth, has an object of the counsel. The plaintiff on the ground does not depart from the generic disparagement prescribed by the advertisement by the judgment order dated 9 September 2004. So, Miller, it's Sadharan, the modified advertisement. Division bench says, please consider. During the hearing, certain discussion took place between the counsel regarding the modified version, and during course of the hearing, this application, the parties were asked to suggest version different from the annex to the application. It is, however, contended that the suggestion given by the either side for the alterations are not acceptable, and the court was therefore asked to decide the application in respect of the annexed advertisement campaign, considering the fact that the divergent views expressly show the resolution of disputes by amicable settlement. The law on disparagement of the rival product was set out in Dabur versus Imami Limited.
Same party.
They are extremely friendly, I can say.
Yes.
They're
They have an affinity for each other.
Yes. And followed the order of the court dated 9th September 2004 in the aforesaid judgment. Generic disparagement as opposed to specific discussed in paragraph 19 and 20. I place it because generic disparagement is also a part because I am the market leader. I am further of the view that the generic disparagement of a rival product without specifically identifying or pinpointing the rival product is equally objectionable. Clever advertisement can indeed hit a rival product without specifying referring it. No one can disparage a class, genre, or a product with a complaining the plaintiff falls and rise the defense that the plaintiff has not been rightly specified, has not been specifically identified. In this context, the plaintiff has rightly rejected the offer of the defendant to drop the container from the advertisement as to avoid identification of the plaintiff's product. So, my lord, here Imami offered that I do drop the container. That was rejected. In paragraph 20, the findings were made by the court. The practice of undue obscenence of English jurisprudence without thought on merits, without reasoning of the judicial wisdom should also be discouraged. Where there is a judgment of the Honorable Justice such and such directly on the point of generic disparagement, I see no reasons why one should travel westward for seeking enlightenment. Similarly, on the question of rival product disparagement of court in Pepsi Supra also held a defamation of the product of a rival competitor cannot be done. Undeniably, this is not puffing up of the defendant's product. The Colgate tooth powder, which can be found objectionable, but running down the rival product, which is suitable in the present case. The division bench, I'll read from a hand up separately. I have it, not necessary, placing it.
The relevant paragraph is quoted here.
Yes,
so no
thus the division bench of the court in PepsiCo and others versus Hindustan Coca-Cola, the two orders of the learned single judge held that rival product cannot be disparaged. It has to be seen that the generic disparagement of a class or product is not permissible. Considering the facts in the proposed advertisement suggesting the defendant in the present application, the word lal qualifying Dant Manjan has been removed. Yet harmful effect of Dant Manjan generally amplified in the proposed advertisement, calling it Sadharan Dant Manjan, which is khudra, abrasive on the till, falls within the prohibition of generic disparagement meant to be prescribed by the judgment of the court dated 9 September 2004, and this form is not calling the application is dismissed.
But in Harpic and this division bench judgment, there was something more than Sadharan. In your case, it's only Sadharan. Their case, abrasive, and it has corrosive
It
chemicals.
has to go back. I will not restrict it.
Not only Sadharan, coupled with that Sadharan, which
here Millard
has
it's like
abrasive
what?
effects on the.
Millard, someone Millard sprinkling Millard, the dabur powder Millard, the cool Millard, everything is coming. Someone Millard putting Millard, the sprinkling Millard, the plaintiff's powder, nothing is the effect on the Millard. It is causing no effect at all in the extreme heat. This is Millard the test. One has to see it as a whole. How one compares.
He's trying to give an impression that
This
my
is
product
Millard.
bad.
So we can put some ice cubes in your bottle
Is that lordship can
এটা হচ্ছে পেপসি কোলা
if you want that.
এটা দেখালে এইটা যেটা পরেরটা গেল না এটা কেন দেখা যাচ্ছে
আর্লিয়ারটা আর্লিয়ার লুট এটা ছিল তারপরে ডিভিশন বেঞ্চে গিয়ে সিঙ্গেল
ঠিক আছে not
Don't multiply judgments on the
no,
same.
I'll not this is the earlier
And
first judgment
We
which
won't
got
go northwards also too much.
is.
Like this judge did not go westward.
দরকার আছে
আপনি বললেন রেফার করে যে দেবেন
para 70
70 দ্যাটস ইট
in fact Millard the division being judgment in Pepsi
We have covered north and south, Madras and Delhi.
yes Madras
So,
and Delhi Millard and
East is
Bombay.
Calcutta, which because Madras covers east also.
Case
Justice Indira Ganji's judgment, so
yes.
only west is left.
Calcutta is the base case Justice Barin Ghosh Rekit case the Calcutta is the base case that quoted in Justice Indira Banerjee first case which is followed everywhere is Justice Barin Ghosh with 5 Millard so the east case is covered in the south case and the other cases also
Yes.
Millard kindly takes Millard just one paragraph. Just Millard, I just cite Millard formally and I indicate the paragraph. That's all, Millard. Nothing more. Millard, this is Millard 2003 27 PTC 305. Must be intermarket. Copy now. Copy the name again. Just Lordship will kindly look. The law on the subject is well discussed. Here, Millard, it's discussed in quite detail, not well, Millard. Millard, where Millard, Pepsi was no harmful effect. Lordship knows, Millard, the soda aspect of Millard Coca-Cola, one gets Millard,
Fizz.
is more than Millard Pepsi because Pepsi is sweeter.
Yes.
So Millard, it was said Pepsi is not bad, but Pepsi is a bachcho wala drink. May I read Millard, paragraph 17, only Millard, and then Millard, I Millard stand. And also 18 for our Millard High Court is quoted. It is one of the commercial.
You're placing which paragraph? Sorry, Mr. Ghosh.
Paragraph 17.
17. You start with 17. Very
16 or Millard 16. By calling cola drink the appellants ये बच्चों वाली है, बच्चों को ये पसंद आएगी, wrong choice baby. The respondent depicted the commercial in a derogatory and a mocking manner. It can't be called puffing. Repeated telecasting of the commercial will have an impression in the mind of the viewers that the product of the appellant is simply sweet and not meant for grown-up children. If they chose Pepsi, it would be a wrong choice. The message that is that the kids wants to grow up should not drink Pepsi. They should be growing up with thumbs up. The manner in which the message is sought to be conveyed does show disparagement of the appellant's product. In one of the commercial lead actors on the screen asked the two boys to come on the stage and point out their favorite drink. One boy has indicated a reference of mouthing towards the word Pepsi. He asked the lead actor to taste a drink from the bottle which was covered by glasses. After taking a sip from each of the bottle, the boy gave reference to one another. When the reasons for preference were asked, the boys tell them that them is a sweet drink meant for the children and uses the word ये मीठी है, बच्चों को मीठी पसंद आएगी, ये बच्चों वाली है. It is sweet like children, meant for children. The moment it is said, the lift up by the actor from the bottle. The drinks boys say bachcho wali meant for children. On it's written puppy. The other bottle is thumbs up. The comparison is the fact that Pepsi and thumbs up. It is seen the fact that the bottle name is puppy is shown to be certain Coca-Cola color. The logo used in the commercial consists of a circular device and the red and blue along with the word puppy. The respondent depicted the bottle with the mark puppy in the global device with an insinuation showing the product is meant.
This was a much better case for them because
now Millard kindly
puppy is used for Pepsi and they
Yes.
mouth the word Pepsi.
Yes. Now Millard bachcho wali drink. Now Millard kindly takes, so that was the first. Millard kindly takes paragraph 80.
Yes.
Admittedly, this is Millard the case I refer to, it is followed. Admittedly, one's product by comparing the other products saying its goods are better is not an actionable. But when puffing or puffing amounts to denigrating the product of the, it's actionable. Calcutta High Court in the case of Rekit Coleman versus MP Ramachandran, while dealing with the question of disparagement, laid down the principles in which the court will look while granting injunction. One of the principles the court has to look whether the advertisement or the commercial, as the case may be, merely puff the product of the advertiser or the guardrail indirectly or directly contains the products of the other, directly or in the contents of the products of the other trader is inferior. That is, in the present case, the garb of puffing its product, thumbs up prima facie, have tried to depict the product of the as inferior. So this is Millard. Every case is there, Millard. So this is on the touchstone of the advertisement, and Millard, Mr. Sarkar Millard successfully argued this was the first Indian case, Millard, which is followed all over. This is the first Indian case which is followed all over. So, Millard, if your lordship takes the advertisement, looks at it in the totality, where Millard my product has been shown to be ineffective. That is the finding of the honorable signature. So, I am not Millard deliberating on the Millard advertisement. Yes. There is because there is no cross. These are my respectful submissions.
ওদের ডেকে নিন, আমরা এখন ঘুরে আসবো। Where are they? Mr. Sarkar will take a short break and within 5-6 minutes will come.
Grateful, Millard, for your lordship.
Thank you, Mr. We'll start with Mr. Sarkar after you come back.
Yes, yes. Millard, lordship will give me a 5 minutes break for going to some other court.
We'll take more than that.
Very
Yes, Mr. Thank you.
My lord, there will be a large number of cases, my lord, in this branch of the law. May I, my lord, request your lordship, my lord, to look at some fundamentals, my lord. And I
Yes.
believe the law, my lord, laid down by Calcutta High Court in 1999, as Mr. Ghosh said, my lord, this matter which I argued, still remains, my lord, good law, followed, my lord, all over. Now, my lord, this is an inroad being made into Article 19(1)(a) of the Constitution of Freedom of the Speech, part of law of defamation. Now, my lord, any inroad to any constitutional right, my lord, must be, my lord, strictly construed. Exception can't be enlarged. And when it's said to advertisement is part of that right. Now, my lord, if your lordship is keeping that in mind, let us, my lord, look at what happened. They filed a suit, made an application for injunction. Lordship, look at the first order of Justice Krishna Rao, which is at, my lord, page 33 of volume 1. Now, my lord, I submit this order was totally unnecessary, but nonetheless, my lord, since an order has been passed, what should we look at it?
Yes, 33.
Petitioner has argued, my lord. My instructions were, my lord, that we will not show any bottle at all. No other bottle, my lord, was put up as comparison. But kindly keep this in mind. To show no bottle at all. That is, my lord, page, I think 39, my lord, of your lordship brief.
39, yes.
Volume 1.
That is the impression we got, that you will not use any bottle at all.
That's right. Can you see my submission, my lord? Kindly see, my lord, the submission. In that context, the order was passed. Kindly keep that in mind. That is why, my lord, arguments are advanced by the petitioner, three or four pages. Then, my lord, per contra, you got it, my lord?
Yes, yes, absolutely.
So and so, representing respondent submit petitioner be filing the suit. Present application has not issued any reason. This is notice. Respondent has to be prepared soon. So submit, respondent remove the bottles containing if this court permits till Monday. Submit suggest telecast in advance. So and so, my lord. Therefore, my lord, having no objection, my lord, I removed the bottle altogether. I did not, my lord, suggest that, my lord, we will show some other bottle. So this consensual uninformed saying, my lord, was at that stage not show any bottle at all. Now, my lord, see the order. After the analysis, my lord, kindly, my lord, very carefully look at the order. Page, my lord, 41.
Yes.
Considering the above facts and circumstances, this court finds that the petitioner has made out a prima facie case and the balance of convenience influence in his favor. And this state, this point, not restrained from using, now, my lord, kindly see, using the important. The container bottle of Dermicool and Navaratna, and also referring the same Sadaran Krishna. So, my lord, I was being, my lord, restrained from showing, my lord, a Dermicool Navaratna bottle of the plaintiff, not, my lord, anything else. Then was next paragraph.
Yes.
You have the above, respondent is men, servants, and agent. So and so it is displaying so and so. Then more kindly see, Cool King by showing the bottle container of Dermicool and Navaratna of the petitioner, and by defining the same as Sadaran Krishna. So specifically, my lord, confined to, my lord, the bottle of the plaintiff and not any other bottle.
Yes.
Now, my lord, actually speaking, my lord, I need not have, my lord, come to the court at the after affidavits, my lord, directions were given. Lord, you will see list the matter. The affidavit given, my lord, with an application order 39 rule 4 at all. But my lord,
Yes.
to our bona fides, my lord, to, my lord, get the matter at rest. Because otherwise, what happens when litigation goes on? We made an application, my lord, to the trial court saying that this is what we want to do, despite the order of injunction. Now, my lord, there was serious opposition, my lord, to the modification, or the clarification. Can you see that in the trial court's order under appeal? Kindly, my lord, see when the advertisements are there, and my lord, the question of, my lord, discarding something, I don't know, my lord, why my lord is saying that. Lord, you will see at page 25 of the order.
Mr. Shorga, can you please refer to the internal pages of the order?
I'm sorry, page 6, my lord.
Page 6, right. Yes.
I'm sorry, I beg your lordship's pardon.
No, sir. Yes, page 6.
Now, my lord, see the advertisement, my lord, their basic grievance was, my lord, Ranbir then compares the prickly powder calling out Sadaran, indicates so and so, such and such. They are saying, my lord, that we are showing, my lord, their bottle, my lord, and not anything else. That was the grievance. No question of discarding. Then, my lord, it goes on. Kindly see, my lord. And, my lord, the modification, my lord, they oppose. Lord, you will see that also, my lord, in the order. I take the internal page. Kindly see, my lord, paragraph 9.
Yes, 9.
Thereafter, page 9, my lord. Thereafter, the respondent filed GA 2 of 2024 inter alia seeking modification. The impugn order on the ground the respondent was willing to vary the impugned advertisement by changing the design of the bottle and removing the green cap as well as any other reference to the color green. Repeat opportunities, the parties were unable to arrive at any consensus. Primary bone of contention, kindly note this, being that
Yes.
the use of the word ordinary in the modified zone not kept. That was the only dispute. Because we had said that we don't want to show any demi-cool bottle. We do not want to show the petitioner's bottle. Green cap, in fact, they have a distinctive cap. I've asked my colleague, show you lots of two bottles. Their cap is different from our current cap. Their shape is different. They are not showing a cylinder at all, but they have a tapered cylindrical bottle. In the sense, the bottom, I think, is either narrower or thicker than the actual cylinder. But ours is a pure cylindrical bottle. All entire same size, top to bottom. They have their size varies. I think either tapers down at the bottom or it becomes a little thicker. Now, then my similar paragraph 10. Concession made on behalf of respondent so remove the. Now, the concession learned judge says, I'm not bound is that I remove bottle altogether from all advertisements.
Is that concession still on, Mr. Sarkar?
No, certainly not. I'm advertising since January. Kindly think of this. I removed that bottle altogether in July or August. For 6 months, there was no bottle in my advertisement. When I came to court, and after the order was passed in January, I started the new advertisement. Now, now to examine. Today, your Lordship is in June 2025. Does your Lordship think that anyone who saw the advertisement in January, in July 2024, 1 year back, still remembers that the bottle was that of the plaintiff? That's the case today. And that's referred to what is, when I talk about Sadharan, that the consumer thinks of July 24 and thinks, no, this is the plaintiff Sadharan bottle. That is the argument at once. Now, kindly see, the offer is recorded. It is true that the concession made so-and-so, however, in view of the offer to modify the improved advertisement by changing the unlabeled white and green container to an improved advertisement along with cylindrical bottle, any for discount as reference to so-and-so academic. Once the reference to the petition is removed in the improved advertisement, both by color and the shape of the bottle, the only question remains is whether ordinary Southern person can attract prohibition. So only point added. Then kindly go reality submissions. Article 19(1)(a) is considered. And
Mr. Sarkar, at the risk of disturbing you, were you using during these 6 months the modified advertisement?
No.
Oh, you were not
at all.
That is only after this order.
Yes.
All
so, therefore, a question of recalling with respect. Recalling has to be recalling of an advertisement which has shown for a bit, which I stopped showing all the bottles altogether, which my client had shown for a bit in July 2024.
Yes.
That is the recalling argument today. That now, by looking at this advertisement after 1 year, the consumer will remember and recall that the word Sadharan was used in July 24 in relation to plaintiff bottle. That is the case. And then Lordship will now, may I put it this way, as I said, for a law of defamation. Now, there can be no defamation of a class. Law does not recognize defamation of a class. Now, therefore, when you are talking of general disparagement, the only restraint can be if the class can be identified with one attack at one particular individual. So that the plaintiff can show that although class is mentioned, he is the target. Otherwise, law of defamation, someone I say tomorrow that all members of the Bar Library Club are corrupt. There is no defamation. Although I will be included in that, but nonetheless, there is defamation. No one can say that I am supposed to be. Now, to use ordinary, if someone calls me an ordinary lawyer, I cannot complain saying that he's defaming me. My reputation is not suffering, but it's a point of view. But some lawyers may think, some judges may think I'm ordinary. There's no harm in that. Using a word ordinary is defamatory at all. Very common. So, unless it can be identified, there's some bi-motive in it. So that when you're calling some product ordinary, you actually mean something disparaging. That is what is here. Now, kindly see. Similarly, there is no substance in the argument that the identification of the impugned advertisement is so pervasive that even if all references to petitioner products are removed, the viewers and prospective customers immediately associate and identify any modified advertisement to petitioner's product. Admittedly, input advertisement has neither been telecast nor broadcast for nearly 6 months. Now, my lord, is this, my lord, can I say with respect, my lord, because he knows from the, my lord, judgment for wonder and talks, my lord, can my lord, an appeal court say this judge has gone horribly wrong by making this observation, taking this view that there can be no recall value, no bottle, my lord, for 6 months, there will be no recall value after 6 months. Creations are determined, time consuming, so and so, then, no pre-approving any proposed TBC. Well, they are objecting. So he said, I'm not pre-approving anything. Part of modified so and so is not the subject matter of the suit. Nevertheless, the contention that a modified advertisement can never be looked at is answer. I can cite cases not required. Many cases, my lord, where, my lord, to solve the dispute, a party comes up, my lord, and suggests a modification. And my lord, court accepts that modification because the court feels that the modification no longer amounts to disparagement. It's very common. But in fact, my colleagues...
It's obvious. Obviously, yes.
Yes, so I don't now, but they oppose. So that's why the order was in that form. Right now, and in order to do complete justice between the parties and bring a quietus to litigation, courts when adjudicating such matters to take into consideration modification, alterations and variations to the input advertisement in order to come out of Mr. order. And large number of cases we had cited, he recorded that. Then authorities, he goes on to Southern, and Lordship will see, learned as a view, and my learned friend has cited those cases. Lordship will see that all the Southern generic cases are all cases where, my lord, the court came to a finding that although it was generic, it was, my lord, meant for the particular plaintiff in that case, like, my lord, Reckitt and Coleman's harping and the other cases. They cannot be, my lord, a generic disparagement. And the learned judge, my lord, does that. So, my lord, then he said, I restrained the order only to the advertisement and nothing more. Because they were saying, my lord, other advertisements should also be stopped. Now, my lord, today, my lord, if I am doing something wrongful, with respect I submit, they can move, my lord, again, afresh. It is not covered, my lord, by the earlier suit. Because it could have been if the court had modified it. The court did not modify it because they objected to the modification. So there is no modification. So without a modification, only in paragraph 17, that, my lord, modification is, he's making, rather it's a clarification that the interim order should be, my lord, for the whole advertisement and not a part of it. That's really, my lord, what the learned judge observed. But, my lord, he's not giving me permission to carry on with my advertisement. But, my lord, we thought, my lord, if we start afresh, the other thought, then, my lord, they have to apply afresh if they want to succeed. On this suit, my lord, today current, my lord, can't be, my lord, altered. But I've asked, my lord, my colleague, my lord, to show you lordship 2 bottles. I don't know, my lord, whether they have it. Then your lordship will see the difference, my lord. One, my lord, has the cylinder, my lord, is not uniform.
Shows the
This is in the modified advertisement.
Yes, lordship will see, my lord, it's a black cap, black grey cap, cylinder, and
this is the one used. This is the one used in your modified advertisement.
That is right, man. That's the one. That's the one.
All right.
It's a black grey cap and it's a white round cylinder. If your lordship takes the plaintiff's packing, it is not a round cylinder. It's a slightly tapered. I don't know whether plaintiff has a copy of his bottle.
Take a photograph of their product and take out a printout and give us during the course of the day.
I'll try and get it from the plaintiff's feelings here. Lordship, look at the bottle.
These are the products in the impugned, your lordship.
Take a photograph, send him a copy, you get a printout.
Yes. And lordship will see, my lord, that there the cylinder, my lord, is not uniform.
Yes.
It's, my lord, tapered on one side, but thicker on the other. I think, my lord, bottom is thicker, top is thinner, my lord, narrower. And the cap, my lord, is, my lord, distinctive cap, which lordship, my lord, they have claimed, my lord, design over that. I have no grievance. Not, my lord, the cap that we are now using, which is, my lord, basically a round cap. They have, my lord, they had distinctive, my lord, cap, my lord, narrower on one side, thicker on the other side. It is, my lord, not their product at all. With respect, my lord. Now, my lord, if your lordship, my lord, see, my lord, this is the position today. Now, if your lordship, my lord, look at, my lord, our advertisement they have shown is that it will be very clear, my lord, from volume 5 that what we are doing, my lord, is the photograph I have given your lordship. I think 694 or whatever they were showing your lordship. Yes, kindly, my lord, look at 693. This is the normal of the bottle being shown. It's a white cylindrical bottle with, my lord, a dark grey or black cap. Now, my lord, this has to be identified, my lord, with a plaintiff product, which is, my lord, not a round cylinder with a green cap and a distinctive cap, which they have designed, which they've got registered now.
Yes.
Now, my
Basics.
lord, there are other, my lord, distinctive features. My lord, their product, my lord, is an Ayurvedic product, registered as an Ayurvedic, my lord, medicinal product.
Huh.
Our, my lord, is a cosmetic product, not an Ayurvedic product at all. It's a different, my lord, licensing, my lord, provisions altogether. There is no dispute about this. They advertise, my lord, as, my lord, medicinal, my lord, benefits, my lord, of using their, my lord, powder. Whereas, my lord, we don't do that. We cannot do that. Because ours is a pure cosmetic, saying, my lord, the cool ice crystal, what your lordship has seen.
All right.
And, my lord, now if your lordship will go back, I don't know whether lordship has got a copy of Justice Ghosh's observation there. I don't know judgment my lord was referring to. Otherwise, my lord,
that is not with us.
no, my lord, I'll give you
It was
lordship.
quoted favorably in a different judgment. That
I'll
was.
give you lordship 2 or 3 judgments, my lord, if lordship doesn't mind.
Yes, please.
My colleagues have put them all in a volume. So I'll not cite all of them, my lord. Lordship will only look at those I'm citing. Please ignore the others.
Yes, please.
My lord, there are some written submissions also prepared.
All right.
Which, my lord, I'll ask my colleagues, my lord, to hand it up your lordship. My lord, I'll just cite 2 or 3 cases, my lord. Unfortunately, my lord, in Calcutta, we had a lot of cases in those days, my lord. We don't have them anymore. They all, my lord, as lordship said, move northwards.
Right.
Now, my lord, if your lordship got both volumes.
Yes. Mr. Shortkar, if you have got a list with you, if you can please just indicate to us first which ones you citing. We'll just put a tick mark and
volume 1, my lord, lordship will see volume 1 has an index.
Yes. We are there.
Well, I will only show you, lordship, my lord, item 2, 3, and my lord, 11.
Right. 2, 3, and 11. All
Yes,
right.
sir.
Thank you. Thank you very much.
There's a Calcutta judgment there also, but I don't think I need trouble with lordship with that. Justice Ghosh's judgment is not here, but it's quoted, my lord.
Yes, it's quoted somewhere. Yes.
Now, lordship will take, my lord, first, my lord, take, my lord, volume 2.
Yes.
I'm trying to go chronologically, my lord. They're all Delhi judgments. Page 279. Well, it's, my lord, Justice Madan Lokur's judgment.
Justice Lokur, yes.
Yes. Now, lordship, 2 or 3 things are important. My lord, lordship will first see, my lord, it's about honey.
Mm-hmm.
Now, my lord, lordship will come to paragraph 11 of the judgment. That's the first case, my lord, of its kind that Mr. Gotu was saying in India, my lord, which I had the privilege to argue.
Oh, great.
Learned counsel for the parties, this of Calcutta High Court, Reckitt and Coleman, lordship seen that. Now see that, my lord, this is what is being approved even now. This is a law and something stated that now kindly see, my lord, the principle laid down there. A tradesman is entitled to declare his goods to be best in the world, even though the declaration is untrue. Very important. Did not be, my lord, correct. He can also say his goods are better than his competitors, even though such statement is untrue. Then, for the purpose of saying that his goods are the best in the world, or his goods are better than his competitors, he can even compare the advantages of his goods over the goods of others. He, however, cannot, while saying that his goods are better than his competitors, say that his competitors' goods are bad. That is what can't be done. You can compare and say, mine is better, it works better, blah, blah, whatever lordship wants to say, but you cannot say that goods are bad, because then if he does so, he really slanders the goods of his competitor. Other words, he defames his competitor, good is not permissible. So law of defamation is involved here. You cannot defame.
Mr. Shortkar, there is a distinction drawn between comparing the advantages of the goods and the goods per se.
That's right.
Now, in your case,
you cannot call it bad. Just because I say my goods are better, my lord, it is permissible.
But in your case, you have not compared the advantages. You have not said my products are better for this reason.
No, I have not said his products are, my lord. I have just, my lord, said some product is, my lord, ordinary. His product is not identified there.
So you hit the products, not the advantages, not the comparative advantages of your product.
No,
but you
I have not said that word. I have said that because it's cooler and all that. That's what I've been referring to. That is not, my lord, disparagement. That is permissible. But all that, my lord, we have done is we have called this product or one product ordinary. He does not say it is my product. He says recall value, my lord, this was my product 1 year back.
All right.
Then, my lord, look at D. Lord, you see the E. There is no defamation to the goods or the manufacturer of such good. No action lies. But if there's such defamation action lies, so my lord, can be, my lord, restricted. That is, my lord, the principle, my lord. There were lots of people see, my lord, 12 weeks. That's the local goes on.
Yes.
And then, my lord, he has dealt with other judgments. That, my lord, Malenfeld cited, PepsiCo and so on. There are a large number of cases.
Right.
And Lordship will find, my lord, ultimately, my lord, although, my lord, an injunction was granted, there was nothing disparaging. Paragraph 26, Lordship will see that. And, my lord, look at, my lord, I'm sorry, look at, my lord, paragraph 23.
Yes, 23.
In comparative advertising, a consumer may look at a commercial from a particular point of view and come to a conclusion that one product is superior to the other. While another consumer may look at the same commercial from another point of view and come to a conclusion that one product is inferior to the other. Disparagement of a product should be defamatory or should border on defamation. The view is consistent with by this court. In other words, this disagreement must be such, it will tantamount to also almost tantamount to defamation. He's presently overall so-and-so doesn't leave an impression that the storyline of commercial message is so-and-so is double honey, is being denigrated, rather than Wipro Sanjeevani honey is better.
This is also important. It has to border on defamation.
That's
So,
right.
Karan is not defamation, you say.
That is right.
Right.
I'm trying to say that my talcum powder is better, it's cooler.
Yes.
Well, whether it's Ranbir or someone else, well, I don't know.
So things happen also. Things happen. People flock around you and
that's why
ice
the
is
cool
put in your
ice
bottle.
and the other product, there is no ice cool. So I'm sharing, comparing two products and saying that my product is better.
Right.
Then object use of double honey, it goes on, register design, then lots will see, para 26.
Right.
Do not find anything disparaging in it, therefore dismissed. Now, nonetheless, lots will see, in order to buy peace, they agreed to a modification, defendant. It's always done, people don't want to fight, commercial people don't want to litigate.
Right.
That's what they want to get out of it. Now, this has been followed, and the two other judgments I gave you, Lordship. The court is quoted there. Kindly, take page 28. Another Delhi judgment.
Capital A. Yes.
And here also modified. That Lordship will find that at page 29 of the volume. Sorry, page 28. Paragraph 15.
Para 15, yes.
I may note that on 14 September 2018, matter came up for hearing. Learned counsel for appearing for defendant had made some concessions. And if you look at paragraph 5 of that order, learned counsel defendant state, try and settle the matter. Defendant would be willing to change the depiction so-and-so, he submits so-and-so, and it was done. And that went on. That was allowed. But nonetheless, they wanted more order. And now lots will see the finding. Kindly come to page 37. That apart has already noted the cream that is depicted in the impugned TV serial. It is now being shown does not primarily resemble that of plaintiff product Fair and Lovely. Like the bottle that we are now showing, does not resemble prima facie even of the plaintiff's bottle.
Yes.
In fact, plaintiff now cannot complain about the TV. Now look at the law here. I may also look at judgment relied on by learned counsel for the defendant, Dabur and Wipro, Bangalore, so-and-so. This is just a local judgment which I have set out. Now look at para 34. Similarly, this court in Mother Dairy Food Processing referred made to Bonard, Perry Court of Jurisdiction, action of liable to grant an injunction, any say of the case, resident defendant of liable, but the decision should be exercised with great caution. Although the publication, if untrue, would clearly be libelous, the interpreted injunction will not be granted by the defendant with justification, and the court can be sure defense will not be sustained and so on.
It was on a somewhat different footing.
That's right. Now, kindly come to Lord Denning's observation, next paragraph. Lastly, reference is invited division bench decision of Kushwant Singh and Maneka Gandhi the court vacated the injunction granted against defendants from publishing, circulating, or selling the autobiography pertaining to the respondent family. The division bench vacated the injunction upholding the obligation of Lord Denning in Woodward and Hutch. The reason is because the interest of the public in knowing the truth outweighs the interest of the plaintiff in maintaining his reputation. There is parallel to drawn libel case, just in libel, the court do not grant because so-and-so, this is part of truth, they grant. So, if I'm saying something true, it should not be restrained. And here, no injunction is granted other than the original modification.
All right.
That is similar. Next case, page 40. This was also earlier one was Imami. This is also Imami. Imami, somehow they don't want to settle, I think, matters. Page 40, is also Imami.
Yes.
Here also, you will see, is modified. Kindly look at page 41.
Yes, 41.
Yes, after 10 line, division bench in this court, video judgment so-and-so, permitted the defendant to publish his advertisement in the modified form, incorporating the changes suggested by counsel, and also we see defendant is Imam against Dabar. They might have got the advertisement modified, it is permitted. It is mentioned here, then it was then. Kindly now go on, kindly come to. Again, Justice Barin Ghosh is cited, page 54. Paragraph 16, Miller.
Yes.
And here, you will find, paragraph 20. In view of the above noted provisions and the case law, there cannot be any dispute that comparative advertising is permissible in law. There are, however, certain guidelines that the courts have recognized when it's concerned. There are guidelines and noted. And guidelines are, I cannot, say something is bad. Now look at para 28, page 59. From the reading of the above noted judgment, it emerges that the court has necessarily examined the intent and overall effect of the advertisement. The look and feel of the advertisement message conveyed by the storyline to an average person are the critical factors which assist the court to come to a right conclusion. One way to view the proposed modified print advertisement can be clearly discerned print product is not the subject matter of comparison. Comparison is with Chyawanprash generic product. As discussed earlier, the law permits comparison. While making a comparison, a competitor can declare his goods to be the best in the world, even though the declaration is untrue. However, while claiming that the goods best and better than his competitor, he cannot say competitor goods are bad. Thus, puffery is allowed, but slander and defamation of the goods, so it's impermissible. The proposed advertisement is only making a comparison with the generic product Chyawanprash. Declaration be given product so and so, it goes on. Very clear, my lord. Generic advertisement is always permitted. I must plaintiff must show the plaintiff's product is the target. And that they are doing by showing some recall value of July 2024, which is no longer there. And my lordship will find injunction paragraph 38, injunction was denied, except the modification was allowed.
Yes.
I respectfully submit, my lord, that there is no case of interference with this order. In fact, my lord, I should have thought we have succeeded, my lord, in getting an injunction. The learned judge was inclined to modify. They opposed modification, so he did not modify. But instead of modification, my lord, the learned judge's modification, my lord, is he restrained, my lord, the order to the whole advertisement, so that other advertisement could be done by my clients.
Yes.
So, the only ground now remains the generic disparagement, which I submit. My learned friends' cases are not cases where generic was allowed. It can never be allowed in law of defamation. With respect, I submit. They have to show that the advertisement I am now showing really targets their product, and I am trying to say that their product is bad. In fact, lordship will look at, kindly go back to the advertisement that I am now showing. I am not targeting them at all. Kindly take volume 5, what the was showing, 693, the advertisement I am now showing.
Yes.
Kindly go there. I'll give you one moment. My lord. There's so many more advertisements. I think it begins, my lord, at page 692.
Yes. 692.
Yes. Can you look at the storyboard? Storyboard commercial so-and-so begin with a creative shot depict extreme heat condition. When firing heat waves in an area wherein so-and-so, no one will be able to escape from heat and sweat. That's my lord, one. Then my lord, next page, what you will see, voiceover asking, Kahan hai tumhara Dabur Kul King? Where is your Dabur Kul King? That's my lord, 693.
Yes.
Then my lord, women earlier fired heat waves to indicate are perplexed with the sound coming so-and-so. They look up and surprised, see a huge pack of Dabur Kul King, perfume, icy perfume tag, landing from the sky. Now, these women are all there. These are not there in the earlier advertisement. Only Mullah, Mr. I think his name is Ranveer Singh. No, even I can't see him, Mullah. I must confess my ignorance, Mullah. I am not a Hindi film person, Mullah. I never have been. So then, Mullah,
Yes.
once it lands, animated cool wave, so and so, Dabur icy perfume tag. Then, Mullah, next page, once the jingle reaches the Dabur icy, then Ranbir Kapoor now comes.
Yes.
Walks over the women while applying so-and-so, so-and-so. Well, where is my learned friend's painted product? I asked myself.
No, the next page is 696, Mr. Sarkar.
America would recommend Dabur Cool King to the person as a better option to unlabeled, unmarked cosmetic talcum powder with a special anti-Dabur Cool King. Now, that unmarked, unlabeled one is the black cap, white cylinder.
Yes.
My product, Mullah, is Dabur Cool King is something different. That's what you can see at 696 Mullah top part.
Yes, but the second photograph in 696 shows.
That's right. That's the one, Mullah. That's their complaint. That
Yes.
Now this is something, Mullah. Lordship will have to be satisfied that this bottle that I am doing refers to Mullah their bottle with a different shape of cylinder and Mullah a different cap. After 1 year.
Mr. Sarkar, during the hearing, was any third company's product, similar product
Some
bottle?
of them are here, Mullah. Quite a lot of are there. But green appears to be very common.
Green appears to be common, but the
There
shape,
some of them are here. A lot of products are here.
just for the sake of
Yes,
comparison,
yes. But green appears to be common, Mullah.
we
There are
want to
there's
see the
some- there's some-
context, the entire perspective.
Yeah, no. Green appears to be common, Mullah. Not black. Green appears to be quite common. I'll just give you lots. There are some other products.
Yes.
I've forgotten the name, Mullah, of.
No, need not give the names. The bottles and the color will do.
Yes. I'll just show you lots. I remember having seen them.
If you can help Mr. Sarkar. Yes, please assist Mr. Sarkar. No difficulty.
55.
Yes, but if someone, my colleagues can show it to lots.
Volume 4, page 455.
Volume 4, 455. Volume 4, 455, he says.
Yes, but there are many. Here, he's right. He's right, Mullah. But
Yes.
you can see a boroneem
Thank
and
you.
Mullah. But they are Mullah more like the printed products. Lots will see the boroneem Mullah bottle at 455 Mullah. Printed bottle is
Right.
like this Mullah. Bottom Mullah
Yes.
is Mullah thicker. The top Mullah is thinner, and the cap Lot you will see is not a straight cap.
Yes.
The boroneem Mullah cap is Mullah similar. The other products Mullah some Tetmos Mullah talcum powder must be common Mullah. There are 456 the other products also. But green Mullah appears to be a common color. That's what
Don't hand over any other third products.
This is the plaintiff's product. Lordship.
Oh,
wants
yeah,
the photograph with that.
Thank you.
Are you Lordship seeing the printed product? Mullah? I hope I'm right in saying the bottle is different and the cap is different.
Yes. That has been given to us.
Yes.
The Matix. The Mate Lordship's leave.
Yes, Mr. Sarkar, thank you so much.
Yes, but I don't think Mullah, any case product is made out Mullah, in this case for interference. of any
No, we
kind.
don't feel you have covered all the points.
Yes, I hope so. Mullah, I hope so.
No.
Actually, my friends cite some genetic disparagement cases. I've indicated Mullah, they're all cases where I did a Harpic case, Mullah, particular
Yes.
product was identified, the plaintiff was identified. As
No,
this,
in Harpik's case and that Dant Manjan case, there were specific allegations that there were chemicals in the Harpik.
that's
and
right. Mullah.
Dant
About the
Manjan
product,
appreciated.
about the product.
about the product and
That's right.
there were harmful effects.
But here, nothing about the product. No,
They are only sadharan, no harmful effects or.
no, not at all. Here, as I said, I couldn't, but they are an Ayurvedic product. Mine one is mere cosmetic.
Yes.
I not difficult for us to apart from the effect of being cool or icy or whatever. I cannot, it be impossible to compare.
But Mr. Sarkar, probably that Ayurvedic and cosmetic distinction would not be perceived by a normal.
No.
It's just
my advertisement.
that is on a different footing.
But my advertisement cannot target Ayurvedic product because it is not within my domain.
Achha, all right.
That's all that I'm saying. It cannot.
All
It's a different product altogether. Although the customer may not know that, unless he is looking for something Ayurvedic, that may be an added selling point in their favor, which I am not disputing. Mine is not an Ayurvedic product.
Thank you very much, Mr.
I'm sorry, I'm taking too much time. I'm getting
No, not at all. Thank you. Thank you, Mr. We'll just go back for a reply. Yes.
So, Lordship will keep the matter for Mr.
No, keeping the matter any day else. We'll just conclude arguments. These matters, we take original side only one day of the week. So,
Yes, Your Lordship.
you please do argue whatever Mr. Ghosh would argue.
Yes, Your Lordship. If Your Lordship kindly sees, Your Lordship, on the date, Your Lordship, when the injunction was granted, Justice Rao, Your Lordship, considered the point that they would remove, Your Lordship, this particular advertisement. And thereafter, Your Lordship, the argument has been made. And Your Lordship, Justice Rao, finally, Your Lordship, granted an order of injunction.
Page 696, 695, that zone, that is the current advertisement being used. Because Mr. Sarkar specifically referred to that.
That's part of my application, bro.
Yes.
My application starts at, I think, page 604.
Yes. 693, 696.
And Lordship will see
That is a part of advertisement, Your Lordship, and that is not the entirety.
No, the bottles are there. We are only concerned with the bottles.
693, Your Lordship, this bottle.
Apart from the bottle.
This is a changed bottle which, Your Lordship, they are trying to show. But our case, Your Lordship, based on once the advertisement, Your Lordship, has already come in the market.
Yes, obviously, recall value you are saying.
There is a recall value.
Achha, Mr. Sarkar argued that recall value after about 1 year. Does that have any meaning?
Lordship, if you Lordship remember, still we remember those advertisements of Pepsi and Thumbs Up. Your Lordship, till Your Lordship, after 20 years. What happens, Your Lordship? This particular advertisements, Your Lordship.
So our memory is very selective on that.
No.
Depending on various factors.
Certainly, Your Lordship. But on the date when this advertisement made, Your Lordship, there were at least 5,000 views at that point of time when we filed the suit.
Maybe, but at that point there has to be a double recall in a sense.
Yes.
First recall is that yes, a similar bottle was used,
Yes.
and secondly that bottle was associated with you.
With me. Because
on two scores, 2 counts.
Lordship, and the reason, Your Lordship, we actually, Your Lordship, we are the market leaders in connection with, Your Lordship, prickly hill powder. Now, Your Lordship, this particular device, Your Lordship, I have shown that this is, Your Lordship, a registered design.
Yes.
Belongs to us.
No doubt.
Now, once they have said, Lordship, the Mr. Sarkar has argued that Sadharan is not defamatory. He has said so. Lordship, if your Lordship kindly sees the Delhi High Court judgment, it clearly says that if you say somebody's product as Sadharan, Your Lordship, that is also defamatory in per se. And Your Lordship, the people at large, Your Lordship, will think that this product, which is actually in the impugned design, impugned, Your Lordship, the advertisement, Your Lordship, belongs to us. And Your Lordship, this will not actually work in, Your Lordship, the heating condition. And Your Lordship, the product, basically, Your Lordship, is inferior in nature. Now, once, Your Lordship, this particular advertisement are in the market, Your Lordship, then even if the modified advertisements are there, Your Lordship, it will defame, Your Lordship, or disparage, Your Lordship, our advertisements. And Your Lordship, the another thing which is important, Your Lordship, is Mr. Sarkar has also argued, now he has come up with a new advertisement, so it's a different cause of action. No, you have first advertised that particular thing in the market when we filed the suit. And now you have only modified it. This is not a new advertisement. Here Anil Kapoor is not coming. Here the Ranveer Kapoor is coming. So the people will, when
yes, it was Ranveer Kapoor.
Is Ranveer Kapoor. Same ad, only Your Lordship, that bottle has changed. So
the color of the shirt of Ranveer Kapoor is same.
Same. It's only showing the different bottle and nothing else. The entire advertisement is same.
Right.
So basically, they are trying to preserve that particular advertisement.
Ranveer Kapoor's looks must have changed in the meantime.
But Your Lordship, advertisement is same.
Same.
If I can understand that, Your Lordship, there is a different shoot of the advertisement.
I get your point. We get your point.
Yes, Your Lordship. It's a completely different one.
Yes.
And Your Lordship, apart from that, if your lordship sees the judgment of the Honorable
Yes.
Delhi High Court and the your lordship the
Which
Madras
judge?
High
Most of
Court-
the judgments are out of the Delhi High Court.
Yes, your lordship, but the division bench which Mr. Ghosh has
Yes.
shown
Yes.
that those three judgments, your lordship, one Delhi, one your lordship of Madras, and one PepsiCo last
Yes.
judgment is covered our point. That there is a recall and one single judgment passed by the Delhi High Court, which clearly says that there has been there is a recall value.
Recall
and on
value
that
cannot
day-
be ignored.
Yes.
But whether that is applicable in a 1-year hiatus, that is the point taken by Mr. Sarkar.
Lordship, I have two contentions to make. First, when you actually advertise that product, there were various huge number of viewers who have seen it.
Yes, definitely.
Even if there is they stopped it only because there is an order of injunction. And on the basis of injunction, your lordship, they have stopped it. But your lordship, the people who have already seen that there is an advertisement where defamatory statements are against me.
The
your
perception
lordship-
has to be from the target group, a
Exactly.
common man. I
Exactly.
mean,
So
so
they-
I saw an advertisement 1 year back
Yes,
which showed a particular shape of a bottle.
lordship.
Now, if another bottle is used, I have to recollect that that was the shape of the bottle. One. Secondly, that bottle is related to your product.
Exactly.
These two things. So you say the two things you say that you are 80% market leaders on this.
Yes, your
No,
lordship.
40%.
40%. I have
It
given,
comes down by half then.
40%.
I have given all the details.
All right.
No,
And-
Malad, may I just
This
point out,
is
Malad, the bottle I'm now using, Malad, is a bottle never used earlier.
And one,
Malad,
and
let
your
me not
lordship-
be clear. Malad, let me be very clear on the facts, Malad. The bottle which was used in the advertisement, Malad, 1 year back by
Yes.
Dabur is not this bottle. It's a different bottle altogether.
yes,
which,
absolutely,
Malad,
yes.
was similar to the plaintiff bottle. That was the grievance. This
And your
bottle is
lordship-
not.
and your lordship, page 455.
What is that in your hand?
Your lordship, page 55.
The yellow one.
This is my notes, your lordship.
Page 50,
Page 55, 455,
450.
which Mr. Sarkar has again shown.
Yes. Yes.
These are the bottles, your lordship, which has very minimal, your lordship, presence in the market. And these are the documents we have disclosed. That there are various type of bottles, but you chose that
So
bottle
that was
only.
in answer to our query that whether other products were shown by any of the parties.
Yes, these are the other products in the market, but he chose my bottle because I am the biggest competitor of Japan.
According to you, what is their percentage in the market, share in the market? Have you given that anywhere?
Your lordship, that particular Dharmi Cool, your lordship, a new entrant.
Acha.
Dabur Cool King is the new entrant, your lordship, in the market.
All right.
And I was, your lordship, in the market for the
Yes,
last.
you are definitely there. Yes, you say that.
So these are my humble submissions that your lordship, that this particular advertisement, your lordship, in entirety should be injected. And when they file, your lordship, the vacating application, that may be a very minuscule argument that no opportunity has been given it to me to
But
deal
at
with
the
that.
end of the day, you said that this advertisement should in its entirety be injuncted.
Yes, yes, yes.
Please come to the impugned order, see the ordering portion, read out.
Yes, your lordship, by removing your lordship.
No, please read out the ordering portion once. Just read out the ordering portion, last paragraph. Ma'am, please wait for half a second. Let him
Yes.
just respond first. Please read paragraph 17 of the judgment. Last paragraph.
Justice Rao's judgment, your lordship.
The impugned judgment,
Yes. The impugned,
not Justice Rao, Justice Kapoor.
Justice Kapoor's judgment.
Please read out para 17.
70 text books. Next.
In view of the above, the ad interim order dated 11th July 2024 is modified to the extent that there shall be an interim order of restraint of the impugned advertisement.
Read the next sentence also.
It is made clear that the order of restraint is limited to the impugned advertisement as a whole and not to any particular portion or any particular word in the impugned advertisement.
That is precisely what you said just now.
Yes,
That
but
the entire advertisement should be stopped. That has been done.
no, but your lordship, if what your lordship has been granted to them, that they can use your lordship by using your lordship a different portion or
They have not
modify
been
it.
granted anything. That advertisement as a whole has been injuncted.
No, as a whole, your lordship in entirety, not your lordship is by removing by
Yes,
alterating your
in its
lordship some of
entirety.
the-
That's wider than portion.
But your lordship, that has been allowed also, your lordship. That's why your lordship, the GA to your lordship has been disposed of. Your
This
lordship,
is the ordering portion. This is the 17 is the ordering portion.
yes, your lordship.
Made clear that the order of restraint is limited to what? The impugned advertisement as a whole, not to any particular portion.
Yes,
The
yes.
word used is modified, but ultimately what you get is the entire advertisement is injuncted.
Entire
That
advertisement,
is what you are asking from us also.
entire advertisement is injected. But what they are trying to do, your lordship, they are only removing the bottle and they are trying, your lordship, to telecast that advertisement in the market.
But then that does not vitiate the order. Your remedy lies there in a contempt application or 39(2)(a).
But your
If you
lordship,
say the order is being violated, but as far as we are sitting in judgment literally
yes, yes, yes,
over this order,
yes, yes.
so then there is no flaw in the order, because you are asking at the end of your argument, you say the entire advertisement should be injuncted. That has been done. If you feel there is a violation of that, you can go take
No,
appropriate
I am not
recourse.
saying, your lordship, is a violation. What the honorable court, your lordship, has, if your lordship kindly takes page 41 and the order which is under challenge. In the page at page 41,
This is the last order, right? This is the last order which
this
is
has been
prevalent.
merged with the final.
Right.
Now-
And this is the final the temporary injunction application itself is disposed of.
Yes,
Not only their order 39 rule 4.
lordship. Now, order 39 rule 4, your lordship, has been allowed to that extent.
39(4) has not exactly been allowed also. That is another
Yes.
point. Because no, not the technical language. They paid for some other modification. That was not granted as such.
Yes, sir, that has been granted.
If
It's
you
on
come
that
to-
basis, your lordship, they are trying, or rather, your lordship, Mr. Sarkar has said that the modified advertisement, they have started using it.
But that is my client could take a risk. He only saw the order, he could take a risk. They can start again, fresh proceeding.
No, but your lordship, he has to take
That's
one
not covered by
stand,
the
whether he
order.
is violating the court's order or not. Because my reading, your lordship, in connection with the impugned order, said, your lordship, that by way of the by disposing of, your lordship, order 39 rule for vacating application, basically the learned trial judge, your lordship, has allowed the modified design, modified
You
advertisement.
just take paragraph 9, internal page 9 of the impugned order, right?
Order 39 rule 4. Provision नहीं, इसका application.
Page 9, para 9 of the impugned order.
Yes, sir.
There, Mr. Sarkar's order 39 rule 4 prayer has been quoted. That prayer is inter alia seeking modification of the impugned order on the ground
Yes, yes.
that the respondent was willing to vary the impugned advertisement by changing the design of the bottle and by removing the green cap as well as any other reference to the color green. So therefore, the modification sought by them was they were willing to vary the same advertisement by changing such and such.
Yes, your lordship.
But what was granted, it's a different proposition whether they're violating or not. What has been granted is order of restraint is limited, that there shall be an interim order of restraint of the impugned advertisement, made clear advertisement as a whole and not to any particular portion or any particular word in the impugned advertisement. Therefore, their prayer for modification was, we want to modify that advertisement by changing design such and such.
Yes, your lordship.
But that has not been granted. Injunction has been granted, restraining the entire advertisement from being telecast.
Yes.
So it's greater than their modification prayer.
In the modification prayer, I found, your lordship, at page 632, because they wanted an order of verification, vacation, variation, modification of the ad interim injunction order dated 11th July. That is the only prayer they have made in their
But they have
application.
they have clarified what paragraph 9 of the impugned order itself quotes what they have sought.
Exactly.
So that has been decided by the learned judge.
Yes, your lordship.
And the learned judge ultimately does not allow that. Willing to vary the advertisement by changing the bottle design of the bottle. They may be doing it, but we have to look at the injunction, what they're not doing right now. The injunction says, made clear that the order of restraint is limited to the impugned advertisement as a whole
As a whole.
and order of restraint of the impugned advertisement. So what has been given is
So what
impugned
was
advertisement is
actually troubling us, your lordship, if you ask me, lordship, it is made clear that the order of restraint is limited to the impugned advertisement as a whole, and thereafter not to any particular portion or any particular word
Yes.
in the impugned advertisement.
Yes, order of restraint is limited to the impugned advertisement as a whole and not to any particular portion of the order.
Correct.
That can have only one meaning.
That they can move there, but
It's somewhat oxymoronic in the sense that limited to, but as a whole. Limited and whole may not go together, but that was the way it was used. But what the judge meant was apparently that it is limited to this advertisement, not to future advertisements.
Yes, your lordship, future advertisement, your lordship, they may come up with a new advertisement.
May,
What they are trying to do is,
may.
what they are trying to do is, your lordship, same advertisement with modification, whether it is allowed or not. And
Okay.
our of the impugned order is by way of this.
That will be
particular order-
decided under order 39 rule 2A. That does not vitiate the impugned order.
Yes,
We are to look into the legality of the impugned order. And And also, why is this not one of the plausible views? You have to
It's a-
satisfy us on that also.
it's a-
Intra-court appeal, we are very strict in this.
Lordship,
We have been traditionally strict
discretionary
because
power.
we are a high court.
Yes, Your
The
Lordship.
learned judge was a high court.
Lordship.
Both are acting as high court.
Yes, Your
So
Lordship.
it's
But
not we are not an appellate authority as such.
I appreciate Your Lordship and Vander and Antox. Basically, Your Lordship, the discretionary power should not be interfered with. But Your Lordship, my Your Lordship submission is, if the order itself is perverse, Your Lordship,
Perversity, yes.
then certainly, Your Lordship, I am entitled, Your Lordship, to urge all those grounds before the Honorable Division Bench. My only submission is, by allowing this modified, Your Lordship, advertisement, Your Lordship, this has been allowed. Lordship, Mr. Ghosh, just 1 minute, Your Lordship.
Yes, take your 1 minute, Mr. Ghosh.
অ্যাডভার্টাইজমেন্ট পুরো তো ইনজাক্ট করেছে, মডিফাইডটা কোথায় করেছে এটা তুমি জানো। এই হচ্ছে এই জায়গাটা, অ্যাজ এ হোল তো ইনজাক্ট করে দিচ্ছে, বাট
Milord,
মডিফাইডটা কেন?
Yes.
Milord, Milord, it boils down. I am up in appeal against an order which has, Milord, injuncted the advertisement as a whole
Yes.
with a rider. As a whole, finished, fair enough. And not to any particular portion
Yes.
or any particular word in the impugned advertisement.
The impugned order, the restraint order applies to the whole of the advertisement, not to any particular portion.
Yes.
This is in the context of that 39(4) prayer, Mr. Ghosh has quoted in para 9 of that order, which says they seek a modification, that they want to modify the advertisement by changing the bottle, shape, size, whatever color. In that context, court says no, restraint order is granted regarding the advertisement as a whole, not to any portion. So not to any bottle or something like that. The entire advertisement is injuncted.
Yes. Now, Milord, if the entire advertisement is injuncted, then, Milord, it's a different consequences follow.
That
if it
is
comes up.
what is clear from the order itself.
Different consequences follow from, Milord, the other, Milord, or whether the modified ad is a disparagement or not.
Exactly. If it's a violation of the injunction, rather.
It's
That is a
violation.
different domain.
It's a different order. Now, if your Lordship, Milord, kindly takes, Milord, then, Milord, what happens, Milord,
Yes.
to, Milord, the word, Milord, the discussion, Milord, on the word sadharan and all those. Are they, Milord?
There is one contradiction in the ordering portion, with utmost respect. I mean, limited to and whole used together.
To and whole,
Used together, but the context has to be seen. The restraint order is limited to the advertisement
that advertisement
as a whole.
is restrained, he cannot use it. If, Milord,
Not a
this is
dynamic injunction, as we said. So it will not apply to successive future
successive
causes of
injunctions,
action.
in
No.
future, I have a separate, I will do that.
Yes.
But, Milord, in teeth of this finding, Milord, that, Milord, sadharan per se is not disparagement with, Milord, what is
Yes, they
running
can use
today.
sadharan again.
Yes, that, Milord, whether I can bring a fresh suit. That's the difficulty, Milord,
All
will
right.
come because of the order in question.
All right.
This will come because today, Milord, there is no appeal from the defendant's side. They have accepted the order.
Yes, yes.
If they accept the order, they, Milord, cannot say today that it was not their bottle then, it was not their bottle now. Because court has come to a prima facie finding that's my bottle, that's disparagement and injuncted. That's the end of the story. So, Milord, if that was so, Milord, there would simply say, Milord, an order to the effect that I restrain the advertisement altogether. I would have had a cause of action for contempt. I would have a cause of action for filing fresh suit. That is
what has been
taken away.
granted here.
That is taken away, Milord, by, Milord, the previous paragraph. Because this will be shown when I go to file a suit that, look, this is not restraint. I am now with a modified ad.
You
which is
cannot have a
basic-
challenge against the finding.
I
No
cannot.
appeal is maintainable against the finding.
No, appeal is not maintainable. My appeal is only as a whole, not to any particular portion or particular. Lordship, Milord, my finding restrain the advertisement as a whole.
That has been done.
And not to any particular part.
As
or
a whole,
portion.
the impugned advertisement as a whole and not to any part, the restraint is
Milord,
applicable
kindly have a look at
You
that.
read it out yourself, Mr. Ghosh, and just listen to it. Or ask your learned friend to read it out and listen to it.
Very good. I'll listen to it, Milord. This is very way, Milord, to circumvent an order with, Milord, 2 paragraphs in, Milord. Kindly, Milord, let us, Milord,
Yes.
take the order in question, Milord. If your Lordship takes the order in question, I'm very sorry, Milord. Milord, I did not have. Milord, my learned friend's argument is very simple. Look, the advertisement as a whole has been restrained. I am doing another advertisement, which, Milord, in effect, was asked for and was not permitted by the court. Yes, because Lordship has to now see the vacating application, what he has prayed for in the vacating application. If he has prayed for in the vacating application with a modified ad which has not been allowed, then either the vacating application should have been dismissed or allowed. That is also not there in the order. Because vacating application, my lord, someone comes with a plea with a modified advertisement.
It has been disposed of. 1 and 2 are disposed of together.
Disposed of.
1 must be injunction, 2 must be vacated.
Two is either the vacating application is allowed or not allowed.
Whatever it culminates and merges in this order, which
Is,
says,
my lord, the advertisement as a whole has been restrained. What is, my lord, whether, my lord, the modified advertisement, which, my lord, the respondent makes the subject matter of the suit at page 693, my lord, is, my lord, not, my lord, discussed in the advertisement at all. Because this, my lord, the plaintiff, my lord, did not, my lord, put at, my lord, that is, my lord, page number 634 also, or 692, whatever lordship takes. My lord, that was brought before the court. It could have been altogether different story. He comes up, but this was there, the new storyboard, and a prayer to such effect for affirming it was asked for by the court. It was neither granted nor refused. My lord, what is the consequence in law, my lord? One, my lord, faces, my lord, in such a scenario. If your lordship takes, my lord, the vacating application once, kindly, my lord, takes, it is paragraph 5. It is submitted that pursuant,
what is the page?
607. 607. It is submitted that pursuant to the order dated 11 July 2024, the defendant has modified the advertisement by removing the unlabeled and unbranded white container with green cap from the impugned advertisement without prejudice to the rights and assertion of the parties. 607, paragraph 5. A copy of the modified advertisement is marked A.
That has been quoted in para 9 of the order.
Yes. Now, my lord, kindly take, my lord, what is the vacating? 632. An order of vacation, variation, modification, or the ad interim order of injunction. In terms of what? In terms of, my lord, the modified advertisement. It should be, my lord, in terms of the modified advertisement. This is not granted. This was prayed for and not granted. Then, my lord, what is, my lord, the implication of the last two lines, not to any part portion there?
What is page 634, 635?
634 is the...
This is their suggested modification.
This is the modified advertisement. According to me, my lord, it's same thing. According
No,
to them,
that your bottle is not there.
my lord, kindly take, my lord. My bottle is of course there, my lord.
Where?
Kindly have a look at it. It's a modified ad. What he is showing,
It was their suggestion.
Yes,
It
it
does
was
not
their
contain
suggestion.
any bottle at all, apart from their own product.
kindly, my lord, takes what was the modified ad. So this is, my lord,
This was their suggested modified ad
suggested.
under order
This
39.
was not granted. With the word
Oh
Sadhana
yes,
saying
page
the ordinary.
634, the top right hand probably.
Yes.
No. That does not contain any bottle. He's not holding any bottle.
Kindly, my lord, take.
It does not contain any bottle at all. And that
Kindly
was
will
what
not
Mr.
take-
Sarkar was submitting also. That they had offered that they would remove the bottle altogether.
Yes. Yes. Altogether, which bottle, which ad? My lord, this is not, my lord, removed.
It's
at all.
annexed to the 39.4.
This is the proposed ad. What he is running. This was
Could have
not.
just agreed to that.
Yes.
Your
Kindly-
bottle is not shown at nobody's bottle is shown
Kindly,
apart
my
from
lord,
their own.
takes paragraph 5 along with it.
No, just see the picture. Show us the photograph where there is any other bottle than their product.
Gives me 1 minute. 1 minute. My lord, kindly take that a storyboard with proposed modification, which is page number 623, paragraph 28. My lord, 624 has the bottle top. I had showed your lordship, my lord.
Right. That contains a bottle.
Yes, annexure J,
And what is this 634 then?
634.
What they were showing at that point of time.
No,
During this 1 year, they were showing probably this.
was the advertisement they were already running. So this is the confusing part. A advertisement is the advertisement which they were running, my lord, during the interregnum. I have nothing to say. I have nothing to say with A advertisement. Now, advertisement title J has a bottle. So it's not a case, my lord, that, my lord, his proposed advertisement does not have any bottle. His advertisement J has a bottle. And A is during the interregnum.
That was the offer given to you. That was the offer given to you that they would
J,
remove
J.
the bottle altogether.
J.
That
Offer
was
given.
not accepted by you.
This is not accepted. So, my lord, A was in the market. So, my lord, A was in the market, my lord. A was in the market with the Sadharan. Nothing turns on it.
No. So with respect, my lord, J was, my lord, what was proposed, 692. Can you see that? Proposed modification. It is not in the market.
Of this application.
Annexure J, page 692 is the proposed modification.
At interim stage, which was
It is
disbanded.
not granted, my lord. They have
Kindly take, my lord, kindly. What
suit.
is there in the petition? I go by the petition.
No, I see the heading.
I
my
go
lord.
by the petition. With deepest of respect, my lord, I, my lord, with deepest, I cannot, my lord, go into, my lord, debate with my learned friend, my lord. He's much senior. Kindly
No, my
take
lord. You see
7.
the heading, Annexure J.
5-6 দেখো তারপরে যেটা
Annexure J, yes. Let us see.
Takes 607 paragraph 5. What is he has pleaded? It is submitted pursuant to the order dated 11/7/2024. Defendant has modified the advertisement by removing the unlabeled, unbrand white container with the green cap from the impugned advertisement without prejudice to the assertion before the court. So this is Annexure A.
Mr. Ghosh, where is Annexure J mentioned?
Milord, Annexure J, if your lordship takes Milord the
K,
paragraph
J, K, yes.
28, 2828.
623
No, 6 to
Kindly, Milord, take
J,
Milord.
J, where is J mentioned?
Yes, J Miller is 624 just after the screenshot. 624 after the screenshot. A copy of the screenshot of the TBC with proposed modification J. This is Miller with deepest of respect. The learned trial single judge also got Miller. No bottle shown, where a bottle shown, because there are two advertisements which are on board. Proposed advertisement of the defendant. J has a bottle in two places. That's like the bottle of the plaintiff. But Millard, A doesn't have it.
Therefore, para 28, these photographs in para 28 have to be seen together with J.
With J. This is J. This is
No,
annexure J.
J
at
is
page-
J. J,
I showed J.
but J does not contain these two bottles.
J
but-
contents, Millard. 693, I showed you, Your Lordship.
692 does not contain any bottle.
693, last,
Yes.
it contains.
And read with para 28, those photographs are also there.
Yes, red with and 690.
Yes, it is there.
Yes, it's there, Millard.
Right.
693, I showed to Your Lordship, Millard, and 696.
93 কাগজ
93 and 96. This was my. So, if that be so, now in this context, Millard, Lordship has to read the order in question. Now, which ad? It's Millard, someone comes up with a vacating application with two modified ad. Either Millard, the court rejects the modified ad or approves the modified ad. That is the modification. There has to be something on the modification. There cannot be an order that the advertisement should be read as a whole or seen as a whole with Millard and not limited to any part or parcel thereof. And Millard Sadharan, you do not have any right. So you don't modify, but yet you modify. This is Millard where I am aggrieved. That's the reason I am before this court, Millard. This is the Millard short point on the appeal. Unfortunately, I have.
What do you mean by short?
My lord, may I just clarify, my lord, with respect? Look
Like-
at my lord, my application, page 621. It's very clear, my lord. The one advertisement we were showing after, my lord, the order. Look at, my lord, page 621, paragraph 21, 22, and 24. My lord, when we had removed the bottle altogether,
Without
then,
prejudice.
my lord, comes 25 with a proposed modification.
Millard,
Please continue.
without prejudice to the
That's
above
very clear, my
submission,
lord.
it is submitted in compliance with the order dated such and such.
No, my lord, may I, my lord, conclude?
The
My lord,
defendant has
look at para 21, 24 are the existing, my lord, before the order was passed.
advertisement, he is going to use it.
Para 25, which is annexure J.
in
There was
compliance
no, and the judge was not confused at all. One was going on after the order when removed the bottle, and second
What
one
he
was
is
what
using.
you were proposing.
My learned friend has to be very clear in his mind with deepest of respect.
No,
Either
I'm
he
clear,
wants
my
to
mind. My
use Millard
should be
A
clear. That's what
or
it
he
was.
wants to use J.
And
If he use A, there is no reference to my
No, I
bottle.
can't speculate.
But
Millard,
if
what
he
would
Millard
happen,
says
what would
Millard
not
J,
happen, Millard.
then is
The
the
one is a
Mr.
question of fact.
Mr.
No,
Sarkar,
not-
With Sadharan.
Mr. Sarkar, it appears on a composite reading of para 20, please.
I'm
Para
sorry, I'm very-
21 and para 28.
Yes.
In para 21, you say that was at the stage when the modification was filed and was pending, right? Because it was filed.
No. Para 21, Millard, is after the 11th July order of Justice Rao. We, Millard, advertise without any bottle at all.
Para 21, you say Para 21 is contained in the Order 39 Rule 4 itself. Therefore, it has to be at that juncture what was going
No,
on.
no, no. I'm giving the
You
history,
say,
my lord. Kindly
without
see para
prejudice to the
21.
above submissions, it is submitted that in compliance with the order of this Honorable Court dated 11/7, the first
That's
order,
right. So, my lord, we remove
that
all
you
bottles
have,
altogether.
yes,
When I
you
made
have,
an offer, Lordship, remember
yes,
my
you have
offer, my lord,
removed,
I removed
yes,
the
you have,
bottles.
yes, you have removed the frames wherein the dummy pack is shown in the impugned advertisement. So you
Correct.
had removed, but you
Yes.
suggest the modification
It's from para
which is
25.
which is
When
in
I'm
para
bringing back a
28.
bottle.
Para
I'm bringing
28,
back a bottle. That's the
Pardon?
modification, my lord. We are wanting to bring back a bottle which is not, which is like 2 bottles shown at page 624, 2 white bottles, my lord, which is not the plaintiff's bottle.
yes, yes, absolutely. Right.
And
Right.
my lord, I've indicated in para 26, my lord, what is the difference?
Yes.
So, my lord, I can't speculate, my lord. I can only look at the order and answer. What could have happened, not happened, my lord? Question is, my lord, I have started advertisement. I'm looking
Yes,
at the order. If I violated the order, they have a remedy. If they have a new cause of action against me, they have a remedy.
Right.
I'm only answering an appeal.
My lord, in appeal, my lord, this order, my
Let
lord,
us not continue this. We'll conclude arguments. Yes.
Yes.
Heard learned counsel for the parties. Hearing is concluded and judgment is reserved in the matter.
grateful.
Thank you.
Okay.
Yes. এটা পাঠিয়ে দেবেন সব
Appellate side. Oh, কোচ্ছে তো।
Hearing no. Hearing we are not adding. Paper book directions. Then put to be mentioned, we will pass that direction. Yes.
Mention this matter instead of the editing hearing that has been completed, my lord. Declaring nullity of a matter.
Complete your sentence, then we'll.
Declaration of marriage.
You have done your duty. No, sorry.
My lord, in the sidelines where maintenance proceedings has been initiated by the wife, my lord.
Maybe. Yes.
For the extension of interim order, it's expired
Yes, yes.
30th of
My lord, may I have your lordship my lord, may I have your lordship kindly to mention a matter not happening your lordship, please. My lord, by an order dated 30.
What is the matter? Application or what?
My lord, it is FMAT.
Appeal hearing? No.
For inclusion, order
What? Order for 20. No.
Matrimonial.
Appeal hearing, it's paper, my lord, it's paper book.
Yes, please wait.
I'm giving.
What is this?
No, what do you want?
Yes. Application order for 20, please hand over.
We are giving the call.
May I permit to is expiring on 30th of June 2020.
Extension. Yes.
My lord, one modest prayer. I'm suffering. My lord, if possible, my lord, next to any date, because I'm suffering an execution order passed by the.
Whenever the files come, we are giving in the list. We don't wait for that.
It is same as what Mr. Mukherjee mentioned.
There are 3 appeals. I am
The same order.
So then mention together, otherwise it will be difficult.
ওই অর্ডারটার সাথে রেখে
এটা দেখবেন একটা কমন হয়ে যাচ্ছে, এটা নোট করে রাখুন।
রানিং ইন দ্য লিস্ট, ম্যাটার ইজ রানিং ইন দ্য লিস্ট।
একটা দেখবেন কমন হয়ে যাচ্ছে, সেটা yes.
And it's already in the list.
So it will appear us to be for extension for the timing, then we'll again relegate.
28 of 2025.
For what? Hearing or application?
For withdrawal, my lord, because it was.
To be mentioned? Yes. Oh,
Pertaining to matrimonial appeals, my lord, paper books are prepared since last year, my lord.
Last year is nothing. The appeals are pending since years. Yes.
My lord, it is for hearing, my lord, the paper book has been directed to file, but the last date for the paper book filing was extended till 9th June 2025, but it was expired. My lord, the appellant want to file 6 sets of paper book in the department. What was told that 8 sets were required. We have now prepared 8 sets of paper book, but the time has expired. My lord, let the matter appear as to be mentioned.
You file it in the department, we'll condone the delay. First file it in the department and then mention. Keep it with you, file it in the department, paper books, then come. Yes, call on the list. Fight it.
Item number 1 has come at my instance, my lord.
Pardon?
At my instance, my lord.
Yes, Mr. Shen.
My lord, the application, all the in the website, my lord, it is showing that all the applications have been disposed of, but the injunction application is yet to be moved, my lord. Injunction application is can 2, my lord. That may be listed any day, my lord.
Can 2 of?
I'm giving. Can 2 of 2018. Original number is can 2900.
Very well. Let can 2 of 2018 within bracket. Old number can 2900 of 2018 bracket close be listed tomorrow.
I'm appealing for point number 234.
No, I'll start copy.
কালকে দিয়ে দেবেন অ্যাপ্লিকেশন হেডিং এ।
For the appellant, my lord, led by Mr. Jantaran Chatterjee. My lord, this case is earlier dismissed for default, and we have filed an application for restoration, my lord. That is still pending. My lord, the petitioner is presently the
So I have mentioned for to be mentioned. It should be appearing.
He does not want to proceed with the case, my lord.
Say that.
And my lord, the another prayer is, my lord, the certified copy of the impugned order filed along with the appeal may kindly be returned.
Why?
She is asking for it.
If you don't want to file a fresh appeal after withdrawing, then where is the question of that? That is a part of the record.
This is my instruction from client.
No question of that. The appellant does not want to proceed with the restoration application and consequentially the appeal, full stop. Accordingly, can 517 of 2020 is, can 2 of 2020, bracket a old number, can 517 of 2020, bracket close, is dismissed. Full stop. Consequentially, the order of dismissal of the appeal bearing FAT number 206 of 2019 for default stands. No order is to cost. Next. In matters where we give liberty to file fresh appeal, then we permit that to be taken back. Otherwise, not.
I beg to appear for the respondent in this matter.
Yes, Mr. Kormak. Why is it appearing? They are mentioning. Mr. Mujumdar, yes?
Filed and not the substantial questions of law not were framed by an order of 21st of May 2025. Not there is an application for stay now. For staying the eviction.
They has to go before the single judge. That was told to your junior by your court officer, but your junior insisted. Learned senior counsel appearing for the appellant seeks enlistment of the stay application filed in connection with the present second appeal. Full stop. Next para. However, comma, since the determination of hearing second appeals and applications in connection therewith lies with the concerned single judge having determination, comma, let the matter go out of our list with liberty to the parties to mention for inclusion before the appropriate bench. Thank you. এটাই সেটা তো ইনসিস্ট করছিল যে
This is my application appeal.
Yes, talk about the what?
My lord,
Why appearing is to be mentioned?
my lord, that I don't know, my lord. My lord, so far as there is no decree, my lord.
You mentioned as to be mentioned.
Mentioned there might be, my lord, by mistake.
What are you wanting now?
My lord, there is no decree in the matter, my lord, and it hasn't been drawn up yet, my lord.
Pardon?
The decree has not been drawn up yet, my lord, in this matter, my lord. Decree. Judge,
So then, why did you mention it at all? Rajendra Kumar Nandi is your advocate.
it is.
So why did you mention it?
It's junior mention, my lord. The junior
No,
mention.
juniors are.
My lord knows the pressure from the client, and he mentioned. I stand correct, my lord. Kindly, my lord. Decree is not there, my lord. Leave be granted, my lord, to incorporate the decree in the meantime, my lord.
Although the appeal has been mentioned and is appearing in the list under the heading to be mentioned, comma, learned counsel for the appellant submits that no order can be passed since the decree has not, the impugned decree has, the decree in connection with the impugned judgment has not yet been drawn up. Full stop. Accordingly, on the prayer of the appellant, let the matter go out of the list.
বহুত বাটাম খেতে তোমার টু মেনশন এসে এখন এসছে তুমি
Yes. Yes, Mr.
I'm
Chanis.
appearing with Mr. Mukherjee. Although I'm leading him, but he is more conversant with facts and
All right, very well.
let him make.
Whatever you like.
that matter that I have mentioned section it's an suit filed for declaration of death under section 107 of the Indian Evidence Act. But in such a suit, your lordship knows the municipal authority for death certificate and all police authority.
Section 80, dismiss for section 80.
Section 80 notice, for that. Only one thing I must point out, at the time of admission, your lordship passed an order wherein it has been gone down, by mistake. It's our mistake that as if the plaintiff is the sole heir, being the daughter. He is the niece. He is not the daughter.
But
and
the
there are
sole heir.
Yes, no, not sole. There are other heirs also. But the original.
Then they have to be implemented.
No, they have already.
What order did we pass? So that correction is to be effected.
No, today, after paper book, everything is made complete. Today, your lordship kept it since this such small point is involved. Your lordship can dispose of the appeal itself.
No, what about notice on the others?
That has been notice of service of appeal, paper book, every compliance is being made. I pointed out before, your lordship.
Now it's ready.
It's ready. Everything is ready. The impugned judgment is only with regard to rejection of the suit on the ground of section 80 notice.
Very well. It is rightly pointed out by learned counsel for the appellant that in the order dated January 7, 2025, it was recorded erroneously that The plaintiff appellant is the sole heir and legal representative within bracket daughter of late Kamaleshwar Mullik, comma, for declaration of whose death the suit was filed. Full stop. Although the appellant is not the daughter but the niece of the said deceased, and there are other legal heirs of the heirs of the deceased, comma, since the other heirs have already been impleaded, and it is submitted by learned counsel for the appellant that service of notice has.
The other legal heirs are not impleaded in the suit.
Why? But their interests are affected.
This suit is for declaration of
But
death.
but since the থেকে কেটে দাও. Declaration of the death.
Yes, they are not affected. They are not affected. It's I have kindly takes up my plate.
No other relief.
No other relief. No other relief short for. It's kindly see page 12 of the paper book. Today your lordship kept it.
Paper book. একটা কাজ করো, ওটা কেটে দাও। In the order January 7, 2025, comma, in paragraph number 1, comma, it was erroneously recorded that the appellant is the daughter and the sole heir of the deceased Kamaleshwar Mullik, comma, for declaration of whose death the suit was filed in the trial court. Full stop. Accordingly, let it be deemed that the reference to the appellant would be as the niece of the said deceased Kamaleshwar Mullik, and that she is not the sole heir of the said deceased. Full stop. Next para. Since a short point is involved in the appeal, comma, let the same be listed for hearing under the appropriate heading on June 30, 2025. 30th June. Paperbook আনিয়ে নিয়ে লিস্টে হিয়ারিং লিস্টে দিয়ে দেবেন।
Can it be in the because it will take 2 weeks of
appropriate heading না করে under the heading specially fixed matters করে দাও। এই দীপঙ্কর যেখানে আপনি specially fixed দেন ওখানে ঢুকিয়ে দেবেন। But Mr. Mukherjee, you have satisfied us whether the other legal aids there would be an implication on them also.
Today this is arising out of an order of rejection of plaint on the ground of section 80.
Oh.
That's why I will not inviting your lordship. Otherwise I can make that submission that it's not.
We'll look into that later.
Only 30th my learned senior friend has difficulty on 30th.
তাহলে July 1, 1st July?
First.
তাহলে July 1 returnable.
July আছে। Great.
Thank
The plaintiff responded. Actually, appellant depend on
deficit court fees.
20,000.
It transpires from the office report dated June 18, 2025 that the instant memorandum of appeal has been preferred with court fees of only rupees 22, comma, leaving a deficit court fee of rupees 20,958. Footstep. Next para. The appellants are accordingly directed to deposit the deficit court fees within 4 weeks from date. Footstep. In default, comma, the matter be placed in the list under the heading Lozima for final orders. এটা অফিসে পাঠিয়ে দেবেন, এটা একটু অ্যাট্রাক্ট করে দেবেন, এটা ওরা রিপোর্ট 4 সপ্তাহ দেখে রিপোর্ট দেবে হয়েছে কিনা, তারপর তা নাহলে পাঠিয়ে দেবে লজিমা ফর ফাইনাল অর্ডার হেডিং এ দেবে। 7 দেখে অর্ডার শিট মনে হচ্ছে আগে অর্ডার হয়েছে। None appears for the parties at the time of call. Full Let the matter stand adjourned for the day.
My lord, this matter, my lord, I am appearing led by Mr. Moinak Bose, my lord. My lord, due to his personal difficulty, my lord, make this matter, my lord, not this week only matter.
On the prayer of the appellant, let the matter stand appellants, let the matter stand adjourned for the week and be listed next on June 30, 2025. Give your names, please, whoever is appearing. Mr. Shen, you're set also.
This matter I have been for the respondent number 1.
Yes.
Bengal Amateur Commanding Association.
Appellant is not there.
Lord, this is in effect an application for expedite hearing of the appeal. The matter, Lord, went up to the Honorable Supreme Court, but in the application itself, the order of the Supreme Court has been annexed. Kindly just look at that order at page 12. The special petition was filed at the instance of the respondent number 1 before your lordship. But only at internal page 3,
Yes.
last but one paragraph. Now, Lord, this appeal has been directed to be heard.
What about the application? That was not moved. That was the reason it was decided. For addition of party?
Additional party application, Lord,
Still not filed.
they did not appear. That is the reason the Supreme Court.
Yes. We find that impugned judgment unsustainable for the reason that respondent 1 had failed to prosecute the application
Yes.
for being implemented as a.
Filed the application.
You are the respondent number 1.
I am the respondent number 1.
So you had failed to prosecute the application.
This is for the appellant.
Oh, respondent number 1 before the Supreme Court was the appellant. It was your appeal. All right.
Mine.
Cannot be set aside in view of the conduct. You understand?
The appeal is directed to be heard by the Honorable Supreme Court.
We are allowing these applications, although they are not.
Don't mind. And only one thing, Lord, this matter appeared before the other division bench presided over by my Lord Justice Chitranjan Das, as his lordship then was. In that matter, on 1st of April 2024, an order was passed, Lord, dispensing with the filing of the paper book. LCR was called for. The order dated 1st of April 2024.
No, I am appearing on behalf of the applicant.
Yes. Paper books were dispensed with why? This is appeal is against what? A regular first appeal.
This is today's application, Lord, I mentioned before your lordship.
That is for expedition, your learned friend has pointed out. He was almost going to move it.
Lordship will also given liberty to file an application for fixing the matter. On the code number 16.
We are 16. Not that. Your learned friend says that Justice Das's bench has dispensed with paper books.
Yes.
I don't know, my lord.
You don't know.
But there is no reflection in any order. All orders I also checked.
1st of April 2024.
Oh, 1st April, the date explains it.
Not marked in the calendar.
1st April order, naturally, whatever is its effect.
Paragraph 8 of the order.
We don't find that order, that's the difficulty. কোর্টের অর্ডার আর অফিসের অর্ডার একসঙ্গে করা কেন? কোর্টের অর্ডার আলাদা থাকে।
For your lordship's convenience, may I hand up my copy?
Yes, please hand
Of
over.
course, one copy is there. Kindly turn to the second page of the order at paragraph 8.
কোথায়? 1st April 2024. কোথায় অর্ডারটা দেখি? এই তো দেখি এটা ফেরত দিন। 1st April অর্ডার আছে। For the time being dispensed with, but paper books were never filed. But paper books are required to be filed.
I think so. Lord, in fact, I tell your lordship, Lord, while this matter was being taken up by the other coordinate bench, Lord, one affidavit, all the documents are not available. One affidavit was sought to be placed, but unfortunately the bench did not see. Lord, today I am praying for a copy has been served upon my land friend.
What is this affidavit?
But some documents which were not there before the was not filed in the appeal filed before this honorable court by my London client. That is why Lord leave was sought for to submit those documents. Affidavits were prepared.
So, trial court, neither of the courts below, these were part of the record. These were not part of the record in any of the courts.
Most of them are part of record. Few of them are not there.
Those which are not part of the record, we cannot look into. You have to file an order for Rule 27 for looking into those, if we allow only.
He was not even a party, my lord. He was not even a party. I tell you, Lord.
We cannot look into documents which were not exhibits in the court below. If you have to produce such documents, you have to file order for Rule
Then
27.
you have to check the record.
You have to check the records. That's
You have
why.
to check the LCR. Otherwise,
Anyway, we are allowing this application and directing the. If you feel that some document you want to produce as additional evidence, file an application. We'll
yes,
keep
no
it with the appeal
let me
and
check
mention that
the-
application. We'll take that up. But for the timing, let us pass this direction for paperwork.
What,
You are appearing for all the. Oh, you're the
What number
plaintiff
one?
respondent.
What?
Milord,
What was the suit for?
here, Milord, suit for declaration filed by the Milord defendant number 1, Milord, 2011.
How can the defendant number 1 file the suit? Respondent number 1 file.
Respondent number 1, sorry.
Then the other defendants can be dismissed with service.
Other defendant not dismissed with the service, but problem is that in this application, Milord, the administrator not functioning at present, who is a party. Secondly, Milord, Janardip Singh Gehlot, who also died. So at present, Milord, the national body and Milord, the
Whatever.
one is a party, but other
No, this is an appeal prepared against what? A decree was passed in favor of the plaintiff.
Yes.
plaintiff.
Then only the plaintiff is a necessary respondent.
This
Why
is
should,
no, Milord, the affiliation, Milord, given by the national body.
if they did not, the other defendants
challenge-
contested.
No, the defendant number national body contested, Milord.
If they contested, but
Contested.
this appeal you are paying. If your appeal is allowed, then it would go in their favor. Why should you direct notice of the
Respondent
appeal?
number 5, learned administrator. In absence of the national body, pursuant to the order passed by the apex court, Milord, administrator appointed, Milord. At that point of time, Milord, the administrator was functioning, the national body, who, Milord, controlled the all over the West Bengal unit. West Bengal unit and other unit in the state, Milord.
See, you are the only defendant. You are not a defendant in the suit.
No.
Ah.
Because, Milord, I was the affiliated body of the national body.
The Supreme Court permitted you to proceed with an application for impleadment. Have you filed any application for being added?
No, not Milord. The appeal was
Both cannot be.
appeal was allowed. There is a order, interim order passed by the Honorable
Did you
Justice I.P.
prefer any
Mukherjee.
application for leave to prefer
Yes,
the
Milord.
appeal?
Thereafter, Milord, stay application heard by the court.
Leave application was allowed.
Yes, Milord.
When?
Yes.
If you're not a party in the trial court, you had to file an application for leave to.
Possibly the application filed. Thereafter, Milord, the interim application also heard by the Honorable Division Bench.
When was the leave application allowed?
No, the
No,
leave
madam,
application
not in
not
the
even
record,
filed.
madam.
No leave,
Milord,
leave to
check up,
file
but,
the appeal
but
was
Milord,
filed.
but Milord, I filed this case by
This appeal is
taking
not
this
maintainable
la-
at your instance unless there is a leave application which is allowed by the court.
That
This is basic civil law.
court allowed Milord the and heard
When?
application.
Find it out from the record.
Find the first order, Milord, kindly see.
What first order? Find out.
First order,
That
Milord.
Don't know the
was
date
the
of the order also.
specific
The
Just-
Hey,
Only stay application.
Only stay application was filed. This was the specific submission.
find it out,
by the
Mr. Chotavat.
Coordinate bench. No
Don't
leave
lose
to
the papers in the.
application was filed.
Don't lose the papers in the way. You don't have a copy of that order.
Yes, Milord.
Don't have a copy of that order or your leave application.
No, not leave application, Milord, I check up, Milord. But
We
I
have
mentioned
one only question.
verbally, Milord.
Verbally, it cannot be allowed.
In that case, Milord,
Without an affidavit, how do you know how you are affected?
no, Milord,
It cannot be allowed verbally. What are you saying? Verbally allowed leave application.
intravenous party, affected party. That's why, Milord,
How do you know you are an affected party without an affidavit to say that?
application, Milord. I mean the stay application, Milord.
Stay application cannot be entertained without a leave application being allowed.
Milord, I see the Milord documents on enter file. Thereafter, Milord, kindly fixed on next week, Milord.
Lord, I
The
personally
entire file,
appeared
Milord,
in that paper
he was
because
both the parties also.
You are the appellant. You don't have a copy of your leave application. You are saying it has been allowed.
No, on that occasion, Milord, Mr. Kamalesh Bhattacharya, Milord, appeared at the time.
You are advocate.
You are the
Record.
advocate record.
The
You
appeal was
appear
connected.
Lord, that
You are the advocate and record. Where is your copy of
Yes.
the leave application? Show us the copy.
No,
Ferat niye na hota, Dipankar.
Milord, verbally, Milord, mentioned before the Lordship, and Lordship allowed to file before
It was
filing.
done entirely verbally without recording any order. You went to the judge's chamber.
In that case, my lord, if not, my lord, I
That
will file
case.
the leave.
Why are you misleading the court, Mr. Chattopadhyay? This is not expected of you.
But, my
You
lord,
are
not
absolutely
misleading,
misleading. I asked a specific question. Was there any leave application allowed? You said yes. Then we did not find out any order. You said it was verbally allowed.
my lord, not application.
Could
my
not
lord,
have been
not, my lord,
verbally allowed by any court of law.
But I'm not in a position to ascertain at this moment.
Say that.
Yes.
Why do you shy away?
Yes, my lord. That's why, my lord, I'm.
Why are you giving a lie to the court? I asked you specifically whether any leave application has been allowed. You missed some thought about that. There's a limit to everything.
I'm sending an apology.
You are sufficiently senior for this. Palpably misleading the court. Why are you doing this? And going on and on and on?
No.
Specific question put to you whether leave application has been allowed. You say yes, it has been allowed. Then you say it has been verbally allowed. Verbal orders are not recorded. There is no order on record. The appellant was admittedly not a party in the trial court. Full stop. Next para. Hence, comma, the appeal is not maintainable in the absence of any application for leave to prefer the appeal. Full stop. We even find from the order of the Supreme Court remanding the matter to this court that it was recorded that the respondent number 1 therein, within bracket appellant herein, bracket closed, had failed to prosecute any application for being impleaded as a party. Full stop. Next para. We grant leave to the appellant to prefer an appropriate application for leave to prefer the present appeal. Full stop. Further leave is granted to the appellant to mention such application for inclusion in the list as and when the same is filed. You have filed 2 applications for the same relief. Can 2 and can 3 both are for appropriate orders?
Appropriate order earlier filed, my lord. That was disposed of.
File an application for leave.
Prayer.
File a 2-page application for leave. Mention it. Give a copy to them. We'll allow it. Yes.
Lord, problem is that, my lord,
You are the problem, Mr. Chattopadhyay, not the matter.
not in a position to.
Problem is with you, not with the matter.
In
Next
the-
matter.
In the meantime, if my lord, the LCR comes, my lord, may I?
Nothing will come. The appeal is not maintainable in the eye of law. Yes.
Special messenger cost also, my lord, deposit.
Thank you very much. Yes. Call on the next.
This is the application for acceptance of special messenger cost, my lord, file out of time, my lord.
The special messenger costs were deposited by the appellant beyond time, full stop. On verbal prayer of the appellant, comma, the delay in deposit of the same is condoned and the special messenger costs are hereby accepted. Full stop. The office shall take steps accordingly to call for the records in terms of the earlier orders.
My lord, I am for respondent number 1 to 5.
You have filed a can for acceptance. তাহলে verbal প্রেয়ারটা দেবে না on the prayer of the appellant can 3 of 2025 is allowed in terms of the above order without any orders to cost. Why a can for this? What is happening in our court?
Told to me, my lord, it was advised by the department only.
Who advised you? Department advised you.
But
Now it has been reversed.
But we do not take any chance, my lord. We bring a coin, my lord, to expedite the matter.
Next.
Even I am appearing on behalf of the appellant applicants, my lord.
This is appearing for the first time.
Yes, my lord, copy has not been served. One is
Serve copy. Oh, can 1, can 2 serve both? The appellants shall serve copies of can 1 of 2025 as well as can 2 of 2025 on the respondents, indicating that the matter shall be listed next on July 14, 2025, when an affidavit of service to that effect shall be filed by the appellants.
grateful.
Thank you.
Number 12.
I'm for that. This is suit for partition, my lord. Partition.
Injunction.
Dismissed. Injunction application.
Any defect in the appeal, Mr.
No, my lord. Tolavana has been. It's a
Partition suit was dismissed.
Dismissed, my lord.
Why dismissed?
Dismissed on the ground that the
Take the microphone a bit, please.
on the ground that the one of the vendor who was previously transferred the property, who was the his father was purchased the property in the name of Dilip Maiti, one of the vendor. Subsequently, he was transferred. Thereafter, another transfer was also in the year of 99. On that deed, plaintiff became owner. And
so why dismissed?
Dismissed on the ground that that vendor vendor has no right to transfer the property because only single deed, by a single deed, that 19 decimal property along with other property which was inherited by from his father, that was transferred. That's
But
why he said that
everything belonged to him, both the
yes,
inherited.
yes,
That is the ground on
yes,
which
my lord.
we find from the impugned judgment and the materials on record that a sufficient prima facie case for injunction has been made out. Full stop. The present appeal arises out of the dismissal of the appellant's suit for partition. Full stop. Next para. The balance of convenience and inconvenience and irreparable injury ingredients are also in favor of grant of injunction. Accordingly, the respondents and their men and agents shall remain restrained by an order of injunction from transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property till disposal of the application. Full stop. Both parties shall maintain status quo with regard to possession in respect of the suit property, comma, also till disposal of the application. The appellants shall serve copies of the application on the respondents, indicating that the application shall be listed for hearing on July 14, 2025, when the appellants shall file an affidavit of service to that effect.
The lower court record maybe now.
Not now. When the injunction application is disposed of, we'll do that.
I'm grateful.
Thank
my lord, I am for the appellant.
Yes.
For the my lord, service has been effected upon all the respondent, my lord.
Pardon? All. Yes, very.
Private for all the respondents, there are certain defects.
Defects.
My lord, two applications before your lordship. One is my lord condonation of delay and another my lord stay application. Suit is my lord under.
No, condonation of delay, we understand, we'll check up whether there is any other defect.
Yes, my lord, court fee.
Report on the part. Yes. Certified copy of impugned decree is not there.
And the court fee also, subject to correction, my lord.
Yes. Court fee.
Yes. Court fee not.
My lord,
30 has been
original certified copy, my lord, I have annexed with the memo of appeal.
Stamp sufficient as per valuation.
Not in form, my lord.
The classification of appeal furnished in words. This you are challenging a decree.
Yes.
My lord.
In the memorandum you have stated memorandum of appeal from original judgment and order. You delete the judgment and order. You have a copy of the memorandum.
Yes.
See the caption. The front page.
My lord. Judgment and.
Mr. Banerjee, show him. Score through the judgment and order and write decree there.
In his brief, it is correctly stated.
Oh, do that in our copy also. Both the judges.
Leave, my lord.
We'll grant that leave and then take up the stay application. The leave is granted to the learned advocate on record for the appellant to carry out the necessary rectification by giving the correct classification of the appeal in the memorandum of appeal. Full stop. Why haven't you filed the decree? Certified copy of the decree, when shall you file it?
My lord, I have filed it at the time of filing of the memorandum of appeal, memo of
Judgment you have filed.
My lord, this is in the suit for under section 92 of the Code of Civil Procedure.
So,
my lord, it's a
regular. No degree is drawn up.
Yes, my lord. Still, suit is pending, my lord, for submitting proposed scheme by the appellant. Preliminary form.
But it is registered as a regular suit.
It's registered as regular suit. There is, my lord, so much anomaly, my lord. No leave has been granted, my lord. I will come at the fact of the case.
But there is no final decree. It has only been held that you are entitled to get relief or relief as mentioned in section 92. You have been directed to file suggested scheme.
My lord, this
you have been directed.
Yes, my lord. This suit is, my lord, purely based on the declaratory suit. That is not come under the purview of the.
No, we appreciate that, but
no,
it has not been finally decided.
But my lord,
we come to the ordering portion.
Yes, my lord. But the property, which is a private property, that has been declared as a public charitable trust. Now, my lord, direction has been given to submitting the proposed scheme. I mean, how the trust will carry out the function. My lord, it's altogether a private property. My lord, I will come.
It has been declared that the trust is a public Devotta trust.
Public Devotta trust, but that is my property. I have purchased that property.
Let us see have you annexed the copy of the plaint?
No, my lord, I have not
Should have
added.
annexed. Have you got a copy of the plaint? Give us a copy of the plaint.
Copy of the plaintiff copy আছে?
টুকটা কিভাবে ফ্রেম করেছে দেখে নিন। যদি উপরে 92 লেখা নিচে ডিগ্রি চায় তাইলে
My lord, relief as sought for, my lord,
I have to see that.
plaintiff copy টা।
My lord.
কি করে হবে?
ওটা relief as
কি বলছো? You have captioned as 92. It's a declarated suit. He's right.
Yes, my lord. And my lord, the mandatory leave should not, has to be taken prior to institution of the suit, not after institution of the suit. The court at the time of the passing of the order under Order 39, Rule 1 and 2, that time leave has been granted, my lord, without any application. Suit at all not maintainable. Even, my lord, I have registered deed. That is a private property where
No,
70
declarated suit is maintainable. The caption will go. Caption section 92, that misnomer. It's a misnomer.
But, my lord, it
The
will not
declarated
come under
suit.
the purview of the 92. I have judgment, my lord.
Wrong caption, it's also will settle that wrong caption does not vitiate a suit or anything
But,
for
my
that
lord, it
matter.
will file in the Munshef or, my lord, civil justice.
It was filed with the district judge.
It has been filed with the district
Ah.
judge. 92 is, my lord, only for the district judge. Two or more person having
Caught
interest.
you on the wrong foot.
Two or more person having interest
valuation.
with the
There
trust.
has been a delay of 786
My lord, that
days.
is a procedural things. I will come, my lord. Why delay?
There has been a delay in 786 days in filing this instant appeal.
But I will come. Why delay, my lord?
My lord, may I use an affidavit to this, my lord?
My lord, my lord, why delay, my lord?
There has been a delay in
Wait. বললাম যে কি বললাম মেঘনাথ, we find that no, the trial court decree has not been filed. ওটা হয়ে গেছে, আচ্ছা খুশি। It is also pointed out by the report of the stamp reporter that no certified copy of the trial court's decree has been filed. Full stop. However, since the suit was captioned as one under section 92 of the Code of Civil Procedure, there is some doubt as to whether any decree can be drawn up as per the frame of the suit. Full stop. Accordingly, such defect may be ignored for the time being. Full stop. Next para. But you carry out that correction in the memorandum. Acha. Since learned counsel appearing for the respondents, plaintiff stroke respondents, seeks to use an affidavit in opposition to TO2 can 2 of 2025, which is an application for condonation of delay, we direct the respondents to file affidavit in opposition to can 2 of 2025 within a fortnight from date. Reply, if any, shall be filed within 1 week thereafter. The application shall be listed next for hearing on July 21, 2025. But there is a fair chance that we'll allow this application because of the palpable wrong that has been done. তার আগে একটা দিয়ে দেবে affidavit of service file today be kept on record.
All the complete, my lord.
But why is there? Why were you so late?
No, my lord. After passing of this judgment, my lord, one application was filed for vacating of the order in the court below by the advice of the learned advocate.
That time was taken.
That time was, my lord.
Very well. We have given you back the bunch of papers. Have you ফেরত দিলেন তো ওটা? আচ্ছা, Mr. Banerjee, as well as you, please just ensure that all the relevant documents are with us on the next date. Plain written statement. You also ensure it's your appeal. Plain written statement, at least plain written statement.
My lord, it has in my brief just.
Take out photocopies, sufficient photocopies for us, him.
But I'll come with a compact.
Thank you. Next. ফ্রেমটাই ভুল, সেকশন 9 বলে ক্যাপশন করে সেকশন 9 হিসেবে ডিল করে দিয়েছে।
My lord, I am for the appellant, my lord. This is the matter, my lord. Terms of settlement, my lord, filed by the parties, my lord. This is the first miscellaneous appeal, my lord.
Talks of settlement were going on.
Parties
Still going
have
on.
arrived into they have signed terms of settlement, my lord. We have filed a CAN application, my lord, CAN number 2.
Can please before us?
Yes, yes, where we have appended the copy of the terms of settlement, my lord. My lord, may I just point out, my lord, one thing, my lord?
Yes.
This appeal, my lord, arising out of a civil suit, my lord, that is in respect of a flat.
You are the plaintiffs.
Yes, I am for the plaintiff. Apart the issue of flat, there are several other issues where the parties have filed suits, counter suits for recovery of money. There are 2 criminal proceedings are also pending. So in the terms of settlement, parties have resolved all issues.
Who are the applicants? They are not parties to the suit. Plaintiffs, defendants are different.
No, applicants are parties
Oh,
to the suit.
acha, yes. You are the
Applicants are
plaintiff.
Yes,
sir.
yes.
You have
Since it
separately
was a
mentioned as
joint
applicants.
affidavit filed.
Oh, that's, therefore you have mentioned all the parties.
Yes,
Very
yes, yes.
fair enough.
Only defendant number 2, who is the developer.
Without defendant number 2, how can we
Not de-
compromise cannot be arrived at without all the
terms-
parties?
He has signed the terms of settlement, but so far the CAN application is concerned.
Yes, signed the terms of settlement. Show us that
yes,
portion.
yes.
Show us that portion he's signed. Because the others are before us.
Yes, my lord, the terms of settlement are, my lord, annexed at page 9 of my application, my lord.
Signature for.
Kindly see at the bottom.
Yes, for master right.
Master properties, my lord.
So in terms, we are passing in terms of this, we are making it a part of the decree, terms of settlement.
My lord, my lord.
Right. Learned counsel for the parties submit that the parties have arrived at a settlement, comma, the terms of which have been reduced in writing and marked as Annexure A to Can 2 of 2025. Full stop, next para. On a perusal of the said terms of settlement, comma, we find that the same is in order, is otherwise in order and in accordance with law. Full stop. Accordingly, Can 2 of 2025 is allowed, comma, thereby disposing of FMA number 124 of 2025 in terms of the settlement. In terms of the settlement as reduced in writing and marked as Annexure A to Can 2 of 2025. Full stop. Let the said terms of settlement be treated to be a part of the decree. Full stop. There will be no arrest to cost. Can 1 is still pending.
Yes, my lord. That was an injunction application.
Can 1 of 2025 stands disposed of accordingly as well. Interim order, if any, stands vacated.
My lord, may I just indicate, my lord, this appeal, my lord, was arising out of a refusal to injunction order. The main suit is still pending before the learned trial court. This is not a first.
We'll give you liberty. We cannot do that. We cannot dispose of the main suit from here.
No, my lord.
No, trial court is in season of the matter.
Yes.
We'll give you liberty to approach the trial court and
Lord,
we'll put it in our order.
I have made prayer.
Parties are at liberty to approach the learned trial court and seek a disposal of the suit in terms of the settlement arrived at by the parties.
My lord, if your lordship, my lord, set a time frame, my lord, it would be helpful. Because, my lord, because
terms of settlement, it will take
my lord, why there is some urgency? Because the flat in question, my lord, parties have agreed.
First, we have to apply before trial. Why do you anticipate that the trial court
No,
will
we can file it within a week. It's already.
Do it within a week. It will be hard within another week.
Grateful, my lord.
Thank
Grateful.
Your suit is pending.
Yes,
you file it, file a put up petition together and then get it ordered.
Affidavit of service, my lord, may be kept.
First, every day. Have be made a part of the decree. Terms of settlement a part of the decree হবে. Terms of settlement ওটা তো ছেপে দিতে হবে part of the decree হলে. Terms of settlement a part of the decree. Sorry. The terms of settlement be made be treated to be a part of this order. Thank you. We thought it was a suit. That's why you said it. Thank you.
That is why I indicated, my lord.
Right.
Grateful, my lord.
Yes.
Lordship, advocate on record, Nitai Chandra Shah, suffering from high fever. Kindly.
Who are you?
I am plaintiff appellant.
You are his junior.
Yes, yes, yes.
Move the matter.
I am not aware this case.
Be aware. We'll give you 10 minutes time. Make yourself aware. We're giving you 10 minutes adjournment. We'll take up the matter after 10 minutes. Pass over. Remain here, study the matter. Next matter.
I am appealing the appellant petitioner.
Regarding quantum of the occupation charges, the tenancy, according to me, is in a Muktaram Babu Street that is just beside the Tontonia Kalibari, and it's a commercial place. Almost, in my application, it is 400 square feet ground floor.
The area was not given in the schedule of the plaint.
Well, it is under 2G, so the only
No, the area was not given in the schedule.
was not given, my lord.
Only two rooms, common bath.
What are you using it for? Residence?
200
Residence?
residence purpose. And one first floor and second floor also use the landlord as a residential purpose. Entire building for residential purpose. And it was situated in the last part of the gully.
Girish Park area?
No, it was not in the main road. That was situated in the gully and last end part of this.
Have you annexed anything in your?
My lord, I do not get any particular document which this court will accept. So,
Why this court accepts what?
my lord, all these things are coming. Your lordship knows very well. There are something given the hand slips and all these things because nobody is trying to create at this.
What was the trespasser?
60 rupees that has also not been paid.
Oh, your defense was that you were a tenant, Mr. Das?
Yes.
Your defense was that you were a tenant?
Yes.
But they got a suit on the ground that you 2G.
2G, my lord.
What is your point in the appeal?
Lordship.
What is your point in the appeal? What is the prima facie case?
Appeal, lordship, suit was decree ex parte.
So, 2G applies, that is sufficient. You don't have a prima facie case.
Then
why should you continue the stay?
I'm not giving any opportunity to contest the said suit, lordship.
You did not file your written statement?
No.
This is not an order 9 rule 13. In appeal, first appeal, you have to satisfy the court on merits also.
Yes.
You have taken the choice. You could have filed an order 9 rule 13.
No.
In appeal, you have to satisfy the court as to what is your status.
Yes, lordship.
What is your status?
Lordship, then
Admittedly, you were the
married daughter.
Married daughter of the deceased original tenant. When did the tenant die?
Oh.
Memote? With impugned judgment?
Oh. Lordship, earlier also filed a suit. That suit was dismissed. Thereafter,
it's on a different ground. 2G is a different ground. What earlier?
The suit was on the Premises Tenancy Act. Since he died and 5 years lapsed, so we
Yes.
take up suit and file the 2G.
Let us see. In your application, have you stated anything regarding the date of death, Mr. Das?
Date of death? No.
In your application, what is?
Application
Previous ejectment suit was filed against your predecessor.
Yes.
Your father,
Yes.
father or whatever. You are the children.
I am the daughter.
One is daughter, one is wife, probably.
My lord, kindly come to page 6 of Can 2 application. While deposing, they admitted that Bodhyanasure already expired In the said shoot, respondent disclosed mother Ranibala Shoot died on 2008 and even produced the death certificate. However, respondents disclosed the name of Baidyanath Shoot dated 2001. So even before the Ranibala Shoot, Baidyanath Shoot died. That was the disclosed in the while deposing evidence. So thereafter we withdraw the.
Was Ranibala Sur was the
Ranibala Shoot was the wife.
wife of Baidyanath?
Yes. She died on 2008 and Baidyanath died even prior to that. No intimation was there, so we naturally withdraw the shoot and thereafter file 2G.
Previous suit was withdrawn, Mr. Das?
Yes.
Dismissed.
This is withdrawn.
Dismissed on merits. Have you got any copy of that judgment, the previous suit?
Previous. No, my lord, I don't.
That order was not a great loss.
Even if it was dismissed, res judicata does not apply because a new ground was available, subsequent cause of action, 2G.
No.
Previous suit was filed against your predecessor on the ground that he is a tenant. After his demise, this is a new cause of action. 2G is a new cause of action. So nothing remains. We will dismiss the appeal and the application.
Also kindly giving.
Don't have to pay anything.
I gone through the.
Go through the brief, come back tomorrow.
I'm grateful, my lord.
On a cursory perusal and upon hearing learned counsel for the parties, it transpires that the present appeal has been preferred against an ex parte decree granting eviction against the appellants on the ground that the appellants are trespassers within the contemplation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Full stop. Even in the averments made in Can 2 of 2025 before this court, it has been admitted that the original tenant Baidyanath Sur and his wife Ranibala have died after coming into force of the 1997 Act, leaving behind the present appellants as their legal heir, as their heirs and legal representatives. Full stop. Next para. Be that as it may, no, Ranibala was not the heir.
Ranibala was the wife, my lord. So she will get 5 years and.
Then who is Shapon Sur?
Son, my lord.
78-year-old. Very well. যেখানে স্টপ করলাম কোনখানটা ছাড়লাম শুভ্র? হ্যাঁ, legal representative. Footstep. Next para. Hence, as per the admission in the application itself, it is evident that the appellants were rendered rank trespassers after the expiry of the statutory period of 5 years from the date of demise of the original tenant. Footstep. Next para. Since the appellants have chosen to prefer a regular first appeal instead of an application under Order 9 Rule 13 of the Code of Civil Procedure, the scope of consideration in the present appeal also touches the merits of the case of the appellants and is not restricted to the cause of the absence of the appellants on the date when the suit was decreed ex parte. Full stop. At this juncture, hence, we expressed our opinion that the application along with the appeal should be taken up together for hearing on the papers already on record and dismissed on the basis of the admission made in the application before us. Full stop. Next para. At this juncture, learned counsel for the appellants seeks some time to prepare himself in the matter. Full stop. Accordingly, let the matter stand adjourned till June 30, 2025, when it will be listed under the same heading.
I'm grateful.
Passover. পাস ওভার আইটেম 15 বাইরে দেখাচ্ছে an adjournment was sought.
Ready.
Respond then.
No, I am the appellant.
Respond then. You are not the respondent. Appellants also respond when the court calls a matter. Yes. What is the matter about?
The suit was, we filed a suit.
আপনি এটা Yes, what is your matter? Just come up.
We filed a suit for partition of the property. The case is that my mother was one of the co-sharer of the property.
Why was it dismissed?
The case was dismissed because it was found that it is not a Ismaili property. Because during the lifetime, it is alleged that mother made a deed of gift in favor of his brother. We disputed that document. We disputed that document. My mother, at the time of execution of the deed of gift, was suffering from cancer, and he was not mentally fit. And
Cancer, suffering from cancer does not mean she cannot execute a deed.
My mother was one of the joint purchaser of the property, and my father contributed that amount. My mother has no income, source of income. He was a mere housewife. That
You sought a declaration to that effect also. What is the relief in your plaint? Let us see that. You have not challenged the deed. Page 49 is your plaint relief.
49.
Page 49 of the application is your relief. You have sought for a decree of partition simpliciter. Without challenging the deed, how can that direction that judgment be? Even you have not challenged the deed even. So how can that relief be given to you?
We pleaded that
Pleading won't do. You have to challenge the deed because it stands against you.
because in course of during the proceeding of the suit, we have challenged that that deed that the money was provided by my father.
Unless you challenge the deed or seek a declaration to that effect,
Now,
there is no scope of the court granting that relief. Please show us from the impugned judgment where the discussion is regarding your argument and how it was dealt with by the court.
no.
Yes, mental disability fraudulent. Page 13-14.
And my father contributed the entire amount.
But court has observed in page 14 of the impugned judgment that although you have alleged that she was not mentally fit, no evidence has come forward to the court. It has been disbelieved. Subsequently, she executed a deed of rectification. She wrote a letter that was exhibited.
The deed of settlement, and it was
What evidence did you lead to show that she is not mental? She was not mentally fit.
we have added the minute.
Rather, from exhibit E, it was seen that plaintiff, you had knowledge about the deed of settlement.
No, we are not party to that deed of settlement. My father and my I being
Exhibit
a daughter.
B, exhibit E was an MP case. In that MP case, from the pleadings there, you had knowledge. That is the finding of the court. This is page 13, internal page 13 of the impugned judgment. Frame of the suit was also held to be bad. Anyway, that was overlooked by the court.
The deed of settlement was done behind our back and knowledge. My father and myself.
In view of a prima facie arguable case having been made out, the appeal is required to be heard on merits. Push up, since the balance of convenience and inconvenience is in favor of grant of injunction, we pass an order of injunction restraining the defendants stroke respondents from selling, transferring, alienating, and or encumbering the suit property in any manner, and or from changing the nature and character of the same till the disposal of the application. Full stop. Next para. আচ্ছা প্রথম লাইনে একটা সবকিছুর আগে দিয়ে দাও the present appeal arises from the dismissal of a suit for partition and ancillary reliefs. তারপর যেখানে শেষ করলাম, the appellant shall serve copies of the application on the আচ্ছা till disposal of the application যেখানে বললাম ওটা till disposal of the application না, till July 31, 2025 or until further order whichever is earlier, interim order টা. The appellant shall serve copies of the application on the respondents indicating that the application shall be listed for hearing on July 8, 2025 when an affidavit of service to that effect shall be filed by the appellant. Interim order till 31st July, subject to what? Yes. Dada. Yes. Yes.
Lord, I-
Yes.
There is suit for
He's coming precariously close to you.
No, my lord, I am afraid of him for other reason.
He doesn't waste his talents on these
Maybe, my lord, if he is
people like you who
is treating me as a student of karate and hit me.
he has the top belt. He's a national champion. I don't know at the international level.
That's why I'm afraid.
He's a national champion.
I know that.
Taekwondo uses legs, so you're safe with his hands. These people don't waste their these skills on ordinary people. Their limbs are weapons. They can be treated as weapons, Mr. Bas. You must be knowing.
But if he's annoyed for some reason or that,
Then also,
I'm afraid of.
that's a part of their training. That has been tested for Mr. Chaturvedi several occasions. Not in court only. I mean, in court, but you know that.
My lord,
Yes.
only one small thing, my lord. Kindly permit me to say this. How am I being misutilized nowadays? Mr. Basu asks me to tell the court that he would be taking a longer time to argue a particular case and hence release the other matters. And this happened only in the next court, my lord, in courtroom number 25 yesterday. So when the neck is in the guillotine, the strength of the goat does not matter.
Right.
My lord, in the suit for partition,
Yes.
3 defendants, my lord, are the appellants before my lord, and the subject matter of challenge is, my lord, an application under order 39 rule 4, my lord, being rejected. My lord, very briefly, my lord, a suit is filed by Mr. Basu's client, my lord, simpliciter on a story that by dint of a deed of gift executed in the year 2008, title has devolved on the plaintiff. Lord, there was gross suppression of some conspicuous facts. These are relevant in as much as the plaintiffs later on themselves want to bring it on record by filing an application under Order 6, Rule 17. Lord, what are these facts? Lord, I bring these facts on record under Order 39, Rule 4, and the facts are that in the year 2000, my predecessor our predecessor in interest, they purchased the property. They purchased the property from the same person from whom Mr. Basu's client claims to have received the gift.
Later.
Later. Lord, on coming to know about this later gift, because they were interfering with my possession, I came to know they disclosed that this is by dint of a deed of gift. I file a suit challenging the deed of gift. I also file
a criminal complaint case against the donor and donee both. That is Mr. Basu's donor, my vendor, and also against the donee. That is Mr.
The vendor
Basu.
was unrelated to you, not related to you.
Not related.
It was a sale in your favor.
It was a sale in my favor. So a prior sale from the same title holder.
Yes.
Lord, the name of the lady is Shamoli alias Fuli. So I lodge a complaint, criminal complaint against Fuli as well as Mr. Basu's client, the plaintiff.
Yes.
Lord, these facts, Lord, were merely suppressed, and a simpliciter story is, Lord, given to the court that I have got title over the property by dint of this deed of gift, and Lord, my clients, Lord, and the other co-sharers of the property, they are interfering with the plaintiff's possession. And accordingly, Lord, the court was made to believe that the interference is wrongful and an injunction, Lord, is granted. Lord, when I filed this Order 39 Rule 4, Lord, Mr. Basu's client files an application under Order 6 Rule 17, taking up a plea that my vendor and his donor was a minor when she executed the deed in my favor. This application, my lord, is on board, has not been, my lord, heard as yet.
But in that Order 6 Rule 17, they also admit the rest. That did have to, because otherwise.
Yes, yes. Now, this application under Order 6 Rule 17 has not been, my lord, heard and disposed of. So this fact that the donor and my vendor, the common person, but that she was, whether she was a minor or not, but is not seen the light of the day insofar as the court's records are concerned. My application, my lord, though under Order 39 Rule 4 is rejected on that ground.
But that is a material fact. So gross suppression of a material fact, at least, because sale deed was suppressed by them altogether.
Yes,
that is your case.
Yeah, my case is, my lord, one, that there is a suppression, and two, that the court relied on, my lord, such facts which are not on record, my lord, as yet. And the relevancy of this fact is admitted because the plaintiff himself says that this is relevant and hence has filed an application under
The
Order
court
6.
takes into consideration that they have a challenge to the majority.
Yes,
On that premise, 39(4) has rejected.
Yes.
Has been rejected.
Yes. Now, Lord, I say that Order 39 Rule 1 and 2 is also, Lord, on board.
So you say that their amendment application at best can be taken as an admission of what you now try to bring out, because they have stated on oath.
Yes.
But the challenge to the majority or minority, that is not yet on a part of the pleadings.
Right.
Therefore, we have to
Right.
rather segregate on that.
Right. And Order 39 Rule 1 and 2 was also on board. So Order 39 Rule 1 and 2 and Rule 4 ought to have been heard together.
39, 1 and 2 kept pending.
Kept pending. Lord, may I now, Lord, take, Lord,
You have filed a written objection to that.
Yes, yes. Lord, may I, Lord, only take my Lord, to the Lord, relevant, Lord.
No, the appeal was admitted by us.
Yes, Lord.
So we had granted ad interim injunction, no?
Lord, my Lord has, Lord, made an observation, Lord. Kindly, Lord, seize my Lord's, Lord, order.
Arguable case and all, can one allow
that even if the amendment application is heard and allowed, yet, my Lord, insofar as the injunction or Order 39 Rule 4 is concerned, it will be considered as if those facts would not,
because it took up
unaffected by it.
So we are taking up the appeal virtually for hearing.
Yes, my Lord has fixed it for that purpose, my Lord.
Yes.
Lord, kindly, my Lord, take up, my Lord, the relevant portion, my Lord, of the pleading in the suit. Lord, I would not trouble my Lord with the entirety. Lord, kindly comes to page 17.
Yes.
Lord, kindly sees paragraph 2, Lord, with regard to my vendor and Mr. Basu's, Lord, donor. Lord, the title, Lord, is flowing from one Nonilal Mondal, Lord, who was, Lord, the father of Shamoli. And then, Lord, kindly skip over and come to the next page.
Mr. Chaturvedi, it's not in dispute that you are a co-owner of the property.
But thereafter, I have purchased the entirety of the property from the other co-sharers.
And also, but your case was, even if you had to be a co-sharer otherwise, but Shamuli sold her entire portion to you, 1/18th,
She has sold her entire portion to me.
and gifted her entire portion to them also. Therefore, since your deed preceded them, so therefore they don't have a locus standi to file the partition suit in even otherwise.
Against me, insofar as I am concerned, their
Yes.
claim cannot be more than what I have purchased from Shamuli or what they have got from
Do they
Shamuli.
claim anything else apart from Shamuli's share?
They are claiming partition in respect of the
On the
property.
strength of the gift deed by Shamuli in respect of her entire share to them.
Right.
So if that gift deed does not pass any title, then the suit is even not maintained.
Right.
Mr. Basu is confident on that. He's saying yes.
Well, the facts, my lord, possibly now would not be.
Probably not in dispute. Yes.
Now, my lord, kindly sees, my lord, paragraph 4. Srimati Shamuli
Yes.
Pulmoni, wife of so and so, while owning and possessing her 1/18th share in the suit plot by executing a deed of gift in 2010, gifted, transferred, and handed over possession of her entire share in the suit plots to Tanmoy Banerjee, the plaintiff. And then the plaintiff herein got 1/18th in the suit plot and is possessing the same by doing various acts of possession. And while possessing the same, the plaintiff so and so, due to education, so and so left to Lucknow and started residing there. Therefore, to protect the preservation of the property by executing a power of attorney appointed so and so.
These are not relevant because
And this power of attorney, this attorney, Millard, has instituted the suit.
all right.
Now, insofar as the criminal case is concerned, charge sheet is filed. The plaintiff is absconding. And that persuades me to believe that the suit is filed by the attorney. I do not know, my lord, whether it would be relevant, my lord, and I am not trying to, my lord, persuade my lord with any fact which is extraneous, not considered
So
by the court.
you now have one suit challenging the deed of gift,
Yes.
plus a criminal case on basis of your complaint.
Wherein the
Those
charge
are
sheet is
pending.
filed.
Those are pending.
Yes.
Even without those, you say that gift deed was subsequent to your sale deed.
Yes.
So even if you don't succeed in that suit,
Yes.
in any event, your purchase deed was prior.
Right. And in so far as the later fact which Mr. Basu's client now wants to bring in on record, that being not on record, my lord, the learned trial court, my lord, could not have taken that into consideration in adjudicating my application under Order 39, Rule 4. And that it is causing undue hardship to me, that is one of the criteria, my lord, to be taken into consideration in deciding Rule 4. Now, my lord, simplicity, my lord, this is, my lord, what has been alleged. My lord, kindly now, my lord,
The initial injunction was ex parte order,
injunction was ex parte.
which you are seeking vacating of.
My lord. My lord, the injunction application at page 25, my lord, I would not, my lord, take the trouble of, my lord, would not give trouble to my lord to come to that. My lord, they are verbatim same as in the plaint. My lord, kindly, my lord, comes to page 106. This is a FIR.
Yes.
And my lord, kindly now, my lord, come. My lord would find the names, my lord, kindly sees in serial number 7, name of the suspects,
Yes.
Fully Mondal, and then number 2 is a plaintiff.
Yes. Yes.
Lord, kindly, Lord, comes to page 114. An order dated 21st November 22. Lord, immediately after the second paragraph, my lord would find accused Tanmoy Banerjee, the plaintiff, is absconding.
Yes.
And then, Lord, kindly comes to page 124. Lord, kindly sees the last longish paragraph.
Yes.
The last 4 lines, 3 lines starting with the words in the middle. I see so and so PS. I submitted charge sheet in this case. Lord, I bring all these facts, Lord, on record in my application. Lord, the application was initially not on record. On the last occasion, Lord, I have filed a supplementary affidavit. With my lord's kind leave, my lord has taken the affidavit on record. Lord, kindly take up, Lord, that supplementary affidavit for a moment. Copy this. No, order 39, rule 4.
Yes.
My lord, kindly sees, my lord, paragraph page 6. paragraph 3, that the plaintiffs has managed to obtain the said order of ad interim and temporary injunction by suppression of the facts by stating in paragraph 4 of the plaint, which reads as follows. And then Lord kindly comes to paragraph 7. Lord, the third paragraph, starting with the words that Rashmoni Mondal, Ranjit Mondal, Fulmoni Mondal jointly sold, transferred, and conveyed their entire share and interest in the suit property to Rajendra Kumar Agarwal. Lord, he is not the predecessor in interest of my clients. And this is Lord 3rd April 2000 and delivered possession to them. And then, Milord, the next paragraph, Rajendra Kumar Agarwal during his lifetime executed a will on so-and-so and bequeathed his property in favor of so-and-so, and it has been probated. So my devolution of interest happens in the year 2000.
Yes.
Much anterior. Now, Milord, kindly now, Milord, take up, Milord, the impugned order. Milord, kindly comes to page 77 of my application.
Yes.
Milord, in paragraph 3, which is the longish paragraph, Milord, kindly skip over, Milord, the first 8 lines. The line starting in the middle with the words, it is contended by the defendant, number 20 to 22.
Yes.
It is contended by the defendant, number 20 to 22, that due to willful suppression of material facts, the plaintiff is guilty of causing mischief under Order 39, Rule 4 of the Code of Civil Procedure, for which the order of injunction dated so-and-so is liable to be set aside in limine. It is also contended by the defendant that the suit property original belonged to so-and-so, and then the devolution of interest which I placed before my lord is stated. Now kindly turn over. But the next page 78. But the last 6 lines starting with the words, it is specific case of these defendants that.
Yes.
After the execution of sale deed number so-and-so, in respect of their entire share in the suit property to one Rajendra Kumar Agarwal, Fuli Mondal, Shamuli Ghoshal had no right authority to transfer any portion of the land in the suit property to anyone. Hence, the gift deed dated 5th January 2010, executed by Fuli Mondal, Shamuli in favor of Tanmoy Banerjee, the plaintiff is void, inoperative, having no force in the eye of law. And the defendants number 20 to 22, that the plaintiff has falsely stated that he along with defendant number 1 to 19 are in Ajmali possession of the suit land, and they along with the defendant number 1 to 19 are the owners of the suit property. The plaintiff suppressed the fact of the suit property is under occupation and possession of the defendant number 20 to 22, and right of the predecessor in interest of the plaintiff was extinguished by sale deed number so-and-so. The plaintiff also suppressed the fact that the say Sarala Agarwal and 2 others by claiming their ownership filed a title suit number 503 of 2023, and a criminal complaint was also lodged against Fuli, Shamuli Mondal, Tanmoy Banerjee and so-and-so. In spite of that, plaintiff has filed the suit and injunction petition, and by virtue of clever drafting and suppressing of material facts, obtained impugned order of injunction from this court. Hence, the defendant number 20 to 22 have filed this petition seeking modification of the ad interim order. Lord, kindly turn over the page. Lord, kindly come to page 80. Yes. The last 5 lines starting with the words, it is the specific case of the plaintiff that.
Yes.
It is a specific case of the plaintiff that Fuli Mondal Shamuli Ghoshal was a minor when she, along with Rashmoni Mondal and so-and-so, allegedly sold their entire share in the suit property to one Rajendra Agarwal with the deed number so-and-so. Lord, I pause here for a moment. Lord, I place the plaint before my lord. Lord, I could not find, Lord, on a first blush or on a scrupulous reading that this fact, Lord, emanates from the plaint. And for this purpose, Milord, an application under Order 6, Rule 17 has been filed, which is pending. This fact, Milord, will be borne in the plaint with whatever effect, Milord. But as on that, it is not there at all. and could not have been considered. It is also argued by plaintiff that there is no cause or documentary evidence to show about the truthfulness of the petition in question. Therefore, the plaintiff prayed for rejection of the instant petition with cost. Now, my lord, the decision starts from the next paragraph. I will not trouble my lord with the entirety of it, which narrates, my lord, the facts. Lord, kindly come to page 83.
Yes.
The relevant portion of the reasoning, the last paragraph.
Yes.
Thus, from the above discussion, it is crystal clear that deliberate suppression of material facts or misrepresentation would disentitle a party to any discretionary relief. But said deliberate suppression of material fact or misrepresentation should in regard of a material fact of the case, that is material for the purpose of determination of the suit. But in this case, which we are dealing at present, there is nothing on plaint as well as in the injunction application which show that the plaintiff has deliberately suppressed any material fact or made any misrepresentation in order to obtain impugned order from this court. Then, moreover, in the alleged deed, with a deed number so and so of 2003, in the deeds of the predecessor in interest of the defendants 20 to 22, as well as in the deeds of the defendant number 20 to 22, plaintiff is not a party. And in this aspect, it is specific case of the plaint that said Fulmoni Mondal, alias Shamoli Ghoshal, was a minor when she, along with the said Rashmoni Mondal and Ranjit Mondal, allegedly sold their entire share in the suit property to one Rajendra Kumar Agarwal with a deed number so and so. Moreover, without taking evidence, it cannot be said that the plaintiff had knowledge about the said deed at the time of hearing of thing. Now, kindly see, my lord, this is, my lord, that application. দিয়েছো লাস্ট দিয়েছো জশপকে দিয়েছো these blood are the application. I am not blood addressing my lord on that, but this blood this application contains blood the proposed amendment, and the proposed amendment insofar as facts are concerned blood only to the extent that Fulmoni at the time of execution of the deed of sale in my predecessor in interest favor was a minor. This is the only fact.
Yes. But
if my
they may
lord
say that
desires-
it was not a deliberate suppression because they did not have knowledge. Apparently, that is the premise of the court.
Yes, insofar as suppression is concerned, blood that is blood the ground taken, and insofar as blood
Party has knowingly made a false and misleading statement. He'll be relying on that.
Yes.
So how do you deal with that?
blood kindly sees blood in the criminal case the charge sheet is filed. In the suit, the summons are served. He's avoiding appearance there. He's avoiding appearance there.
Is there anything to show that summons are served in the suit? How do you know that?
Blood, this is
or any averment of yours?
blood. I have
Only one copy, my lord.
No, I have
Copies.
But what is this?
He knows
Key.
It's a,
Someone.
Sir, next day, January 26th.
কি দেখালে দেখাও একটা কপি তো আমি বলবো তো
give a copy to him also.
and this is a suit anterior to the suit filed by the plaintiffs herein.
There's nothing to attribute knowledge, Mr. Achudivedi.
Yes, if this is a statement, I am told that summons were possibly sent. The service
Must have taken steps.
Yes, steps were taken contemporaneously, but possibility is not served on him. And Milord, interestingly, in respect of all summons, whether it is by the criminal court or by the civil court, the summons are being sent at the same address at which the present suit is filed. But all the summons are returned back with endorsements, insufficient address. So the first time when it was sent, it returned back. Alternative steps were taken in the suit filed by my clients. But my lord, kindly see charge sheet filed and absconding. And the co-accused is none else than the donor.
There is nothing to attribute knowledge to them.
Lord, if I am
Maybe deliberately doing it.
if I am absconding in a case wherein a charge sheet is filed against me, my lord, can I take a plea that I am not aware of the proceeding? I am absconding because I abscond by, I am a habitual absconder.
What is the absconding finding?
Lord, page 124. Uh, 114, 114. Lord, about 8 lines from top, accused Tonmoy Banerjee. My lord has very kindly found it.
114.
Page 114.
Yes, absconding.
And this is in the year 2022. And the charge sheet is filed in 2020, in 2022. At page 124, my lord, I showed, my lord. The last 4 lines. I submitted charge sheet in this case with a charge sheet number so and so dated 31st July 2022. My lord, I say, my lord, the suppression, my lord, is manifest. My lord, I say that as against a rightful owner, my lord, a person who is yet to, my lord, build up a case to rake up an issue of rival title, Lord, it is yet to born, and the court yet recognizes his case in adjudicating my application. But the hardship, my lord, is caused to me. And the
Order 6 rule, in their order 6 rule 17, they say that they derive knowledge of the deed from your
from my order 39 rule 4.
How can you fix knowledge to them only because they're absconding? Absconding may mean either way, with or without knowledge. They're not there. Just because they're absconding.
Lord, I say, Lord, could the learned trial court, Lord, take into consideration insofar as, Lord, the
minority, yes, you're right.
Lord, because the entire thing is, Lord, I have a deed, a registered document which confers title to me.
Mr. Chaturvedi, definitely in the final hearing of the injunction application, that deed has to be considered. Has to be considered.
And the injunction application was on board.
That we can direct to decide. There is a compulsion on the court to decide injunction along with the 39.
But I am only
we generally do it. There is a compulsion.
No, I'm saying that in that event, Lord, if had he decided both the application together, Lord, my scope to impress upon the court.
But that's his choice. He might have, might not have. We generally do that, but did not. But we can direct that to be heard out. In injunction, definitely all these have to be considered. But this does not make out a case, 39(4) case on suppression of material particular. And knowingly made a false and misleading statement, that does not come in.
But the whole foundation that the plaintiff has a title and hence entitled to an injunction on the foundation of a prima facie case, that will not stands demolished the moment I produce a deed which carries will not a presumption
that is
of an anterior date.
That is true in respect of a 39 order 39 rule 1 and 2 application.
Yes.
But 39(4) is on specific ground, varied or discharged or set aside, provided that if in an application for temporary such and such, supporting such application, parties knowingly made a false and misleading statement in relation to a material particular, and the injunction was granted without giving
and
notice.
hardship.
The hardship has not pleaded.
Hardship comes in only when it was, let us see, provided further that where an order for injunction has been passed after giving to a party an opportunity of being heard, the order shall not be discharged valid, etc. unless undue hardship. So this was not a contested order. Undue hardship, normal course does not come in, but that can also be a ground. There is a bar also. Hardship, there is not such a high case.
If I am showing to the court that here is a registered document which carries a presumption.
No, that does not create a hardship for you. Hardship has to be something else.
No, the injunction which restrains the rightful owner. And the only rival claim
Then there would
apropos
not
the
be
title.
then there would not be any necessity to hear out a finally a temporary injunction application, Mr. Chaturvedi. 39.4 is on a very specific consideration, and injunction has been granted.
I agree. I bow down.
Mr. Chaturvedi, but undue hardship, you have not made out such a case because injunction has been granted. What injunction has been, status quo has been granted?
The status quo has been.
So for till disposal of the injunction application, you cannot transfer, dispose, alienate
and
with the property. That is not an undue hardship of
because the other co-sharers who are impleaded as defendants, they are no more owners of the property. I have purchased their shares as well.
Mr. Chaturvedi, you have got an excellent case. We need not say that in the injunction. You have filed your written objection.
Yes.
We'll direct the injunction application to be decided within a limited period.
Let order 39 rule 4 be heard afresh. Reason being, the reason kindly sees the alibi ascribed to justify this order 39 rule 4 rejection is that Fulmoni was a minor, and hence this issue has to be gone into in trial.
But knowingly, we also have to be satisfied that it was knowingly. Otherwise, the conclusion is correct.
No, because this fact
no. Court also said that there is nothing to attribute knowledge to them. That has also been considered.
Both the things have been said.
But even if you don't accept his contention, the court's finding on minor, which you have a point there, it's still not a part of the pleading. But the other ground remains that knowingly that has not been cannot be attributed to them, just because they're absconders.
But the moment before the order 6 rule 17 is adjudicated and allowed.
Minority is a wrong ground. But the conclusion is right on the knowledge.
This also affects the criminal trial.
No,
because
how?
if the issue of minority is Fulmoni is cast a cloud, then in that event.
How can it? You say the deed is fraudulent. If she was a minor, the fraud is more patent. Fraud by a minor also, then she'll be dealt with under the Juvenile Act.
No, but then not in this case. In this case, my case is
this does not affect the criminal case in any manner whatsoever. Does not have any bearing on the.
I leave it to your lordship. I only humbly submit that the order 39 rule 1 and 2 and rule 4 be heard together.
No,
so that
34 will not reopen 39.4 because 39.4 court is right in saying that you could not attribute knowledge to the appellate. The general
yes, and the summons status I can't go beyond that. The status of service
we'll
of
keep
summons.
This on record. We'll take judicial notice of this. This has been handed over by them. The general notice under section 2 of the Transfer Property Act on registration, that is a very vague thing. I mean, that would not attribute specific knowledge. So many registrations are happening. All of us then will know.
Yes.
Maybe our property is being transferred right now. We don't know.
The judgment of the court.
What judgment of?
Judgment. The knowledge is there.
You suppress deliberately and you abscond and you are saying.
Minor's property and register it, and minor has the knowledge.
Yes, very well, but you're palpably. Why are you not there? You filed a suit with the plaintiff address and your summons are not being served there.
I should have waste your lordship's time. 330. Paragraph 5 I have said.
No, 330 does not affect us. But what is the reason for your client not being served the summons? We can come to a conclusion, Mr. Basu, on the materials on record. We can constitute this. We are putting this question to you. We have not concluded hearing. The question is that you file a suit by disclosing a particular address of yours. At the same address, summons are sought to be served, could not be served.
Look to that paragraph.
Criminal case, summons could not be served. What should be the presumption?
I have been specifically said in my plaint that I am residing there at Lucknow.
They have given the address. Serve the summons of the criminal case there. Lucknow address is now there.
It is not coming back, not found. It is saying insufficient address.
Lucknow also.
No. The present address has now been disclosed, but the address furnished is the same as.
Get him behind the bars. Either the civil code or the criminal code gets him.
suppress, by knowledge, they could not prove by any means. And
What-
if it is not proved by knowledge, then question of suppression does not arise.
But we can
40-day notice could not be served on him because of insufficient address. Then he was shown apps.
then we have to haul up the postal authorities. That's a postal endorsement. Anyway.
And the address he furnishes again, kindly sees. He says Tanmoy Banerjee, Lucknow. Lord, Mr. Basu would be known by Mr. Basu Howrah. Is a complete address.
Only Lucknow. What is that?
Lord, internal page 18, paragraph 5, which Mr. Basu was relying.
Now, of what? Of which document?
Of yes, this is his plaint.
Internal page?
18, 1-8.
What does he say? He's in. Oh,
Lord, paragraph, Lord, page 18. My lord is at page 18 of my stay application. Paragraph 5, starting with the words, thus the plaintiff herein got. My lord has got the address.
Oh, this is my plain case. I am not deciding here.
who is your constituted attorney? Amit Ganguly resides at the same address as given by you.
Here he is deciding. Amit Ganguly.
If he is your constituted attorney, he should have been served the summons. Then how can it come back as insufficient address?
For that, ballot, he has not been authorized.
Where is the power of attorney? Must have annexed it to the plaint.
Maybe with me, but it is not annexed here.
It's a part of the plaint, so you must have it.
I certainly should. I should have.
Show us that.
But it is not here. It is their application. They have not annexed.
জালি করে বলেছি কেন হচ্ছে ওই অ্যাড্রেস দিয়েছে if you have given that address in your plaint Mr. Basu then there should be a presumption that it was sent at the right address.
Well, up to now, not been served on record.
You're deliberately avoiding service.
No court has come to a conclusion that it has been served upon the power of attorney also.
We'll remand the order 13 rule 4 for consideration of that by setting aside the order of this. And
Court is actually come to a conclusion that there is no deliberate suppression, which is the language of the 39(4).
knowingly suppressed.
First is suppression, second is knowingly. To mislead the court, obviously has to be there. These three ingredients are there. So if this suppression could not, the knowledge could not be proved, these two other ingredients cannot be proved.
It's your plaint address. You have not disclosed your Lucknow address in your plaint.
This is my plain case. Why it has been given?
We have to go by that plaint address.
Why I am not here?
There must be someone to receive your summons there because it's your address and you have not disclosed your Lucknow address. So we'll constitute that this is the right address.
Which one?
174 Godia Station Road. Your only plaint address. You have not given your Lucknow address.
For the time being, my lord, I am saying. So that is my address.
Let us reject the plaint, then the plaint is not informed. You have not disclosed your address.
Till now, it has not been served upon me.
Your plaint. Your plaint. Tanmoy Banerjee, page 14.
Today, my lord, how your lordship will constitute this? Because I have disclosed one address with the power of attorney holder. Because I am not here, I have given a power of attorney.
Yes.
So at best, I have not seen the my lord power. At best, it can be served on the power of attorney. Everything is given to him.
You have given this only address. But order 6, order 7 are very clear that you have to give your address, name, address.
For the time being,
If then this is your address.
For the time being, can I constitute the address of my power of attorney is my address.
No, Mr. Banerjee, Mr. Basu, you have not said that. You have stated your address as well as the power of attorney's address to be that. If that be so, if summons returns from that address.
Now kindly see as well as the pleading in my paragraph 5 that I am not deciding here. So it can be served upon the power of attorney.
Yes, it is returning as someone's insufficient address.
Can be
Plenty files Hajira.
I was asking the question to myself. High court could be insufficient address. Is my power of attorney holder address is there?
So what?
So it can be served of him.
It can be, but even without serving, if you give an address, Mr. Basu, that has to be constituted to be your address. That is the address given in the FIR also, in the charge sheet also, and you are absconding.
This has to be read along with my statement in the plaint. In my plaint, I have said I am not residing here. So if your lordship constitute this plaint, it has to be served upon the power of attorney. This address, up till now, it has not been served. Still this process is continuing. And the
Particulars to be contained in the plaint, it has to contain the place of residence.
I have contended.
Then this is your place of residence. The language is not your address, place of residence of the defendant.
I probably could not make something clear.
And the
For the
plaintiff.
timing, constitute that this is my address.
Then you are deliberately avoiding service of the suit as well as the.
But from my lord is getting this. I am deliberately.
It was served to you.
Where? Can you produce the records?
Sent as per the plaint.
Say.
And absconding also, that finding is there. Charge sheet and the FIR mentions your address as this address.
I am not residing there. I have stayed in the plaint. This is no suppression. I have said that I am not residing. I am residing at Lucknow.
No, Mr. Basu. Lucknow, you have not disclosed even the address.
Well, criminal case not filed by me. So they have to give the address. So for a civil case, I can say that I kindly.
Civil case, your plaint.
My plaint. This
your
is my
plaint, you have given one address only. In the body you have said for a job you went to Lucknow.
I am being highly constituted. This is my address. What I have disclosed, that is my address.
Then you are absconding deliberately in the criminal case where the specific charge is regarding that manufacturing of that gift.
But address has been given and absconding. It is not known to the court.
Yes,
because of your suppression.
Where
You suppress the address at the current address.
Where
You suppress the fact of the sale deed.
from I have suppressed the fact? My address I have disclosed here.
What is your address?
This is the address I have given for the time being constituted.
Then you are a deliberate absconder, and it's deemed that you have knowledge of the criminal code. The allegation against you.
It cannot be presumed unless it is my lord seen the light. I have not seen that up till now.
Why are you absconding then?
I am not absconding. I am.
You said that we should constitute that to be your address. Then you are absconding. You cannot argue both in the same breath.
Saying in the criminal case, what address I was given, I don't know.
Yes, let us see the FIR. We'll find it from there.
This, how can I know whether police was there or sitting in table says absconding?
No, investigation took place and charge sheet has been filed. You don't know, and your power of attorney is merely residing there in an armchair.
If that we show,
disclose your address, they'll immediately arrest you. You have suppressed your address also. Your conduct is not good.
Page 106 and 107.
that should be knowledge. My lord is now considering 39(4). I have the knowledge and deliberately suppress that, having knowledge.
Yes.
Well, I have no knowledge up till now. That could not be produced before the court. But this is the knowledge.
পুরো FIR এতে FIR টা রয়েছে তান্না মুখার্জি
পাওয়া যাবে But I find here I have given my lord the Godia Station Road, Narendrapur. In the FIR, my lord, 106 Sonarpur. As should be shown as absconded. That's why I say I don't know. This address must have been given by the complainant. 106, my lord, I was looking at. আরো কোনো জন্ময় ব্যানার্জি হবে। It may not be me. I not seen that.
কোথায় দেখলেন অ্যাড্রেসটা?
106, my lord, is 106.
After
জোসেফ কি দেখছে বুঝতে পারছি। ও বাবা দেখছে জোসেফ একটা।
I kindly tally this with page 87, the deed of gift which he claims to have derived title from. 87. This is his address. I lodge complaint on the basis of this.
কমপ্লেন্টে কি এর কথা লিখেছে, আগে সেল ডিডের কথা লিখেছে? দেখতে হবে। হরিনাবি গিফট ডিডেও আছে, ডিড অফ গিফটেও আছে,
Gift deed as it appears, my
গিফট
lord.
ডিডেও আছে, কমপ্লেন্টেও আছে। ওই অ্যাড্রেসেই তো
I'm residing here.
will constitute knowledge, Mr. Chivas.
Constitute, my lord, by respect to submission.
Injunction is equitable if you obtain injunction without by suppressing material fact.
Has to be knowledge on me. What I have suppressed. Absolutely, it is equitable remedy. It is a discussion of the court on the fact situation, and it is a partition suit. Summon of the suit has not been served upon me. And this is my address.
But this is insufficient. This order number 6 merely says today is fixed for taking steps. We don't know whether previous steps were taken by them or whatever.
Up till now, it has not been served. Well, if it is not served in the address, there is substitute service that has to be done.
No, we don't know previously whether this is order number 6. They must have served previously, but what we have to know the fate of that service, whether it came back as you are not producing those orders.
It will serve, my lord. Yes, sir. I will bring, I can bring. SRAD will not be there. My lord has ample experience.
SRAD may be there, but if they have served at your address as you disclose in your plaint,
Yes.
you are disclosing different addresses in different places.
He has to constitute the plaint. The plaint address, my lord, I have disclosed here. Knowledge, my lord, in my humble submission, there is no knowledge at all. Thereafter, question whether delivery suppression.
You open for 39 for a please শুনতে হবে ওকে কনস্টিটিউট ওকে ট্রায়াল করতে বলবো এগুলো কনসিডার করতে যে এগুলোতে দেখা যাবে কি
My lord, that pulmonary episode, minor or not, that is in addition to that.
in addition
The point is that I have no knowledge. While, my lord, I have filed the application in response to their order 39 rule 4, I file an objection. There I have stated that.
stated what?
Stated that when the deed was executed, he was minor. But that nothing turns on that. The court has only construed that the knowledge was not with me.
Where is your order 6 rule 17? Haven't you admitted that? You have stated that you have knowledge from their
Application only. But three dates may be relevant. No.
You also know that she was a minor then.
But
Pulmoney is also absconding.
No.
Pulmoney has been caught. Obtained bail.
Obtained bail. Lord, this application which I am moving before my lord today, Lord, copy was intended to be served on the parties as well. So the copy sent to his attorney, the plaintiff's attorney, that has again come back. Item
Copy of what?
insufficient address. It has come back.
I am here.
Copy of what?
But since there was a caveat
In this matter?
in this matter, Lord, we intended to serve it on the learned advocate. We could not find him on a particular day. There was urgency for moving this application. So in addition, what we did is we sent the copy directly to the clients as well and wanted to take a chance on the next day.
How did you, what was the endorsement there?
Insufficient address. Yeah, I have, Lord, affirmed an affidavit of service for my Lord's convenience. If my Lord directs me, Lord, I shall
File.
file it. Since Mr. Basu was
Without a
appearing,
copy
I
to,
did not.
without a copy to him of, this is an affidavit of service.
Affidavit of service, same one. Duto copy.
Din.
Lord, I have folded one copy for my Lord's convenience.
That insufficient address at their instance or the insufficient address in the plaintiff?
One 170 Goria Station Road. Forwarding letter is there.
Page 8, my Lord would find the second
Details has been given.
postal receipt.
Goria, what the Prasad High School, Goria PS, Narendrapur, Kolkata, what more?
Page 8 on the left
Postal,
side.
postal slips are there.
Yes.
No, no. Other is going to be not found.
Insufficient address.
How it can be insufficient address?
Then the address you have given in the plaint is insufficient.
Well, see, but since address in your lifetime, how it can be insufficient? It can be a wrong address. So, not found will be there. I have categorically said 174 Godia Station Road, opposite Godia, such and such, PS Godia, PS Narendrapur, Kolkata 684, everything given.
Everything is found in the receipt. All that Mr. Basu is saying is all to be found here. Amit Ganguly, 174 Goria Station Road.
I don't know. It cannot be by any means insufficient address. It can be person not found. Insufficiency when my lord one digit is missing, number is wrong.
Knowledge attribute kota mushkil hoye jacche.
This cannot be a presumption of my lord service.
Yes, Mr. Chaturvedi, what do you say in reply? Because knowledge, to attribute knowledge, we can understand everything, but to attribute knowledge, we don't have anything to hold the bull by the horns.
Lord, only Lord, only one thing, Lord, kindly sees in all these diverse
Directive 39(1) to be heard within a limited period.
Lord, along with
Every
Order
point-
39 Rule 4, Lord, why I say, Lord, because Lord, Order 39 Rule 4 has been, Lord, adjudicated on a wrong premises. Lord, I did not, Lord, had an opportunity to show all this, Lord, suppression to be on the anvil of the documents which, Lord, now have come. Because this service, Lord, in the other suit that he is avoiding, that he is an absconder in the criminal proceeding, that the service that we intend to make in other ancillary proceedings are being avoided and should be presumed to be good service, and that he had knowledge. He knows that the donor was a minor, but he does not know that there's a criminal case pending against the donor and he himself. And he avoids to give the particulars of the address where he is residing now in Lucknow. Lord, all these things, Lord, would go, Lord, lead to a presumption. This presumption I had no opportunity to argue. And once the court is hearing of 1 and 2, Lord, there is no harm, Lord, this Order 39 Rule 4 would be heard. Along with that, they would suffer no prejudice.
So this was a suit for partition. The present
Suit for partition, they have impleted the other co-sharers from whom I have purchased.
No, you are defendant number, which defendant?
20 to 22, 20, 21 and 22.
Very good. The present appeal has been filed by the defendant numbers 20 to 22 in a suit for partition instituted by the plaintiffs stroke respondents, comma, against an order whereby the appellant's application under Order 39 Rule 4 of the Code of Civil Procedure for vacating an ex parte ad interim order obtained by the plaintiff stroke respondents was rejected. For sub next para, learned senior counsel appearing for the appellant's contents that the learned trial judge erred in law in proceeding on wrong premises to reject the said application. Full stop. Next para. It is submitted that by a sale deed executed on April 3, 2000, comma, one full money, comma, the alleged predecessor in interest, one Shamoli alias full money, comma, the alleged predecessor in interest, stroke donor of the plaintiff stroke respondents had sold the property, sold her share in the suit property in favor of the appellants. Full stop. Next para. However, comma, by gross suppression of the said fact, comma, the present suit was filed for partition, comma, without challenging the said sale deed, comma, on the strength of a purported deed of gift executed by the said Shamoli alias Fulmoni on January 5, 2010, comma, that is 10 years subsequent to the transfer in favor of the appellants, comma, in favor of the full stop. Next para. It is submitted by learned senior counsel appearing for the appellants that apart from the suppression of the existence of the sale deed and no relief against the said deed having been sought in the suit, comma, the plaintiffs also suppress the fact that the present appellants have initiated a suit challenging the purported gift deed executed in favor of the plaintiff stroke respondents. Full stop. In the said suit, comma, although service was sought to be effected at the address as given in the cause title thereof, comma, which exactly tallies with the address of the plaintiff number one as plaintiff, comma, as given in the plaint of the current partition suit, comma, returned, the summons could not be served. Full stop. The postal article, comma, despite repeated efforts on the part of the appellants, comma, returned with the endorsement insufficient address. Full stop. Next para. It is argued that the plaintiff stroke respondent also suppressed the fact that on the basis of a complaint lodged on the ground of forgery against both the plaintiff stroke alleged donee and Fulmoni, comma, the alleged donor, comma, first information
Not against both the plaintiffs.
one. There is only one plaintiff. Amit Ganguly is only a.
Plaintiff arrayed as a plaintiff as a power of attorney holder.
He has been added as a plaintiff, not that.
Plaintiff number one is
Only one plaintiff. Amit Ganguly is a part. কি বললাম?
sorry.
No. Comma, a first information report was registered, comma, which led to a criminal investigation, comma, culminating in a charge sheet being filed, comma, inter alia, comma, against the plaintiff stroke respondent number one. Puts up next para. In the said criminal proceeding, comma, it has been recorded by the concerned court that the plaintiff stroke respondent number one is absconding, comma, which also indicates that the plaintiff stroke respondent number one herein is deliberately avoiding service of summons in the suit filed by the present appellants as well as in the criminal proceeding. Full stop. Next para. It is sought to be argued that the expression double inverted absconding makes it implicit that the plaintiff stroke respondent number one is deliberately avoiding to appear in the said proceedings. Full stop. Next para. Learned senior counsel argues that the learned trial judge proceeded on the premise that the parameters of the proviso to of the first proviso to order 13 and rule 4 is not applicable, comma, since no knowledge of the previous sale deed or the suit or criminal proceeding could be attributed to the plaintiff stroke respondent number 1. Full stop. It is submitted that in view of the circumstances as indicated above, comma, such finding is erroneous. Full stop. Next para. Also, comma, the learned trial judge proceeded on the premise that the allegation of the plaintiff stroke respondent number 1 in his application under Order 6 Rule 17 of the Code of Civil Procedure, comma, for amendment of the plaint of the present suit, comma, to the effect that the vendor of the appellant's stroke donor of the plaintiff stroke respondent number 1 was a minor at the relevant juncture when the sale deed was executed was also erroneous. Full stop. Next para. It is argued that since the Order 6 Rule 17 application has not yet been allowed, comma, the alleged minority of the vendor of the appellants is not yet a part of the pleadings and was not so even on the date when the ex parte ad interim injunction was passed, and, comma, as such, comma, could not be looked into by the learned trial judge while passing the present impugned order. Full stop. Next para. However, comma, the admission of the appellant of the respondent number 1 to the effect that there was a sale deed in favor of the present appellants, comma, which was sought to be avoided on the ground that the vendor Shamoli stroke Fulmoni was a minor, comma, can be construed for the purpose of the adjudication under Order 39 Rule 4. Full stop. Next para. Thus, comma, the premise of minority was also erroneous. Full stop. It is thus submitted that the impugned order ought to be set aside on both counts. Full stop. Next para. Learned senior counsel appearing for the plaintiff stroke respondent number 1 vehemently opposes the arguments of the appellants and submits that in the plaint of the present suit itself, comma, it has been categorically averred in paragraph 5 that the plaintiff Tanmay Banerjee, comma, due to his education and thereafter job, comma, went to Lucknow, comma, Uttar Pradesh and started residing therein. Full stop. Next para. It has also been explained that therefore, comma, a power of attorney was executed in favor of Sri Amit Ganguly, comma, his constituted attorney, comma, who has been contesting all proceedings in the trial court as well as this court. Full stop. Next para. Thus, comma, it is argued that the service of summons in respect of the suit filed by the present appellants regarding the gift deed executed in favor of the respondent number 1 could not be completed. Push up. As such, comma, it cannot be said that the plaintiff stroke respondent number 1 has or had had any knowledge regarding the purported challenge to the gift deed and stroke or the pendency of any criminal case against the plaintiff. Full stop. Next para. Insofar as the existence of the sale deed in favor of the appellants is concerned, comma, it is argued that the knowledge of the same was derived for the first time from the averments made in the application under Order 39 Rule 4 of the Code of Civil Procedure filed by the present appellants. Full stop. Learned senior counsel hands over a photocopy of a server copy of Order number 6 dated June 19, 2025, passed in title suit number 503 of 2023, comma, which is the suit filed by the appellants challenging the gift deed of the plaintiff herein, comma, to show the court that summons of the said suit have not yet been served on the plaintiff stroke respondent number 1, comma, thus negating the contention that the plaintiff could have any knowledge about the prior sale deed and or the initiation of a criminal case against him. Next para. Learned senior counsel appearing for the respondent number 1 heavily relies on the language of Order 39 Rule 4 and argues that the suppression of any material fact, comma, even if any, comma, has to be knowingly done in terms of the said provision, full stop. It is argued that in the absence of anything to attribute knowledge to the plaintiff stroke respondent number 1, comma, the yardsticks stipulated in Order 39 Rule 4 could not be applied, and as such, the impugned order was justified. Full stop. Next para. In reply, comma, learned senior counsel for the appellant submits that for abundant caution, comma, copies of the present application was also sought to be sent directly on the plaintiff stroke respondent number 1, which was also returned as insufficient with the endorsement insufficient address. Full stop. It is submitted that in view of the deliberate avoidance of service, comma, it can very well be construed that the plaintiff stroke respondent number 1 is well aware of the pendency of the suit as well as the criminal proceeding against him. Full stop. Next para. Upon a careful consideration of the rival contentions of the parties, comma, we find that the first premise of the impugned order, comma, being the alleged minority of the vendor of the appellants and donor of the respondent number 1 was an erroneous premise. Full stop. Next para. As rightly argued by the appellants, comma, since the amendment application filed by the appellant by the respondent number 1 is yet to be disposed of, comma, the allegation regarding alleged minority of the vendor of the appellants has not yet seen the light of the day insofar as the pleadings in the present partition suit are concerned. Full stop. Hence, comma, the maximum worth which could be lent to the averments made in the Order 6 Rule 17 application would be by way of admission of the execution of the sale deed, comma, which was sought to be challenged by citing the alleged minority of the vendor. Full stop. The minority of the vendor itself, comma, not being a part of the pleadings and as yet, comma, could not be looked at while deciding the application under Order 39 Rule 4 of the code. So next para. There is some doubt as to whether knowledge can be attributed to the plaintiff with regard to the material facts which were suppressed in the present case or not. Full stop. Next para. However, comma, we are of the opinion that sufficient materials have been placed before us to give rise to a doubt as to whether the plaintiff stroke respondent number 1, comma, despite having full knowledge of the criminal proceeding and the suit filed against him by the appellants, comma, is avoiding the process of law by deliberately abstaining from his residence as disclosed in the cause title of the plaint of the partition suit. Full stop. Next para. The moment the criminal court observed that the respondent number 1 is double inverted with the absconding, comma, a presumption arises that there is an element of deliberate and willful element of willfulness in such abstention. Full stop. That apart, comma, an evasive game is apparently being played by the respondent number 1 by disclosing his residential address as 174, comma, Goria Station Road, comma, P.O. Goria, comma, P.S. Narendrapur, comma, Kolkata 700084, comma, District South 24 Parganas in the cause title of the partition suit, but in the body of the plaint, comma, in an elusive manner, comma, merely mentioning that due to his education and job, he has gone to Lucknow, comma, Uttar Pradesh, comma, without caring to disclose such address. Full stop. Next para. Order 7 Rule 1 within bracket small b imposes the duty on the plaintiff to include the name, comma, description and place of residence of the plaintiff. Full stop. in the absence of disclosure as to his Lucknow residence by the plaintiff stroke respondent number 1, comma, it is evident that Order 7, Rule 1 has not been complied with. Full stop. Next para. In the event the address disclosed in the plaint, comma, more to be particular, comma, in the cause title of the plaint, comma, is the correct address, comma, there could not be any reason why the summons as well as the service intended in the present appeal would return with the endorsement insufficient address. Full stop. Next para. More importantly, comma, we find that the address disclosed, address of the plaintiff stroke respondent number 1 disclosed in the purported gift deed, comma, on the strength of which title is claimed in the plaint, comma, is again different from that disclosed in the cause title of the plaint. Full stop. The criminal case was initiated on the basis of a complaint where the residential address of the plaintiff stroke respondent number 1, which has been given in the gift deed, was shown. Full stop. Next para. Despite the same, comma, the plaintiff stroke respondent number 1 could not be apprehended in respect, apprehended or traced in connection with the criminal case, comma, showing that the said address is also an erroneous address. Full stop. Next para. The learned trial judge ought to look into the matter as to whether the plaintiff stroke respondent number 1 genuinely did not have knowledge of the sale deed executed in favor of the appellants, as well as the suit filed by the appellants, that is title suit number 503 of 2023, and stroke or the criminal case initiated against the respondent number 1 at the behest of the appellants, or whether the plaintiff stroke respondent number 1 is playing an elusive game with the process of law by disclosing different addresses in different places and in an illusory manner, comma, states in the body of the plaint that he resides at Lucknow in Uttar Pradesh, comma, without disclosing the particulars of the said address. Full stop. Next para. For such purpose, comma, it is necessary that the learned trial judge gives further opportunity to the parties to establish their respective cases in connection with the application under Order 39, Rule 4 of the Code of Civil Procedure. Full stop. Hence, comma, we also take the observation in the impugned order to the effect that the plaintiff stroke respondent number 1 did not have knowledge of the above germane facts has to be taken with a pinch of salt. Full stop. In the light of the above observations, comma, FMAT 122 of 2025 is allowed on contest, comma, thereby setting aside the impugned order being
Order number 18 dated 28th April.
order number
18.
18.
18.
Order number 18
Dated 28th April.
dated April 28. Yes, so got it. April 28, 2025. Passed by the learned civil judge, senior division, cum assistant session judge, comma, second court at Baripur district, South 24 Parganas, in title suit number 138 of 2024, and remanding the application under Order 39, Rule 4 of the Code of Civil Procedure to the trial court for a fresh adjudication on merits, upon giving opportunity to both sides to produce further material, comma, if they so deem fit, comma, and to re-adjudicate the same in the light of the observations made above. Full stop. Next para. Since affidavits, since written objection has already been filed in connection with the main temporary injunction application pending before the learned trial judge as well, comma, it is expected that the learned trial judge shall decide the application under Order 39, Rule 4 of the Code of Civil Procedure afresh, along with the application under Order 39, Rule 1 and 2, Rules 1 and 2 of the Code of Civil Procedure, as expeditiously as possible, comma, positively within 1 month, within 2 months within 1 month from the date of service, from the date of communication of this order to the learned court below. Can 1 of 2025 is disposed of accordingly as well, no rest to costs.
Deeply obliged.
Right. My lord has decided everything.
No, we have taken it with a pinch of salt.
No, my lord has said that the trial court has to follow your lordship's observation.
Without following my observations, our observations, how can the matter be taken upon remand?
Observation is on merits of the 39-4.
In the light of the above observations.
My lord has decided.
Mr. Basu, what are you saying? When we remand the matter, we observe that these are the faults of the trial. Yes.
But your lordship has said that.
In the light of the above observations.
My lord has observed that the presumption is that I have no knowledge.
No, we have not said that.
Kindly, whenever lordship is.
We have taken it with a pinch of salt.
Well, whenever signing it, my lord, kindly find that your lordship has mostly observed that I have the knowledge.
Almost. Stop just short of.
If that be so, my lord, nothing remains to be decided.
No, we don't have the materials. That's why you didn't decide. If you had the materials, we'd decide here.
Without material, my lord, come to the conclusion that I have the presumption that I have the knowledge.
Mr. Basu, have you received your fees? From which address? Lucknow.
Well, that, my lord, I have.
Your client will be in deep soup.
No, your lordship has mostly observed that I have the knowledge.
Just stop short of that. Just stop short of.
So nothing remains to be decided.
Let us see. Yes.
Deeply obliged.
Number 18.
Lord, I beg to appear for the petition in this matter.
Yes.
If you didn't reply.
You are for the alleged contempt now?
Yes, there is a contempt also. No, the contempt is being heard out, not contempt also. The contempt is being heard out.
I filed.
May I file the reply?
The contempt application.
Yes.
Yes.
My lord, so the my lord's order and then the reply also.
The
supplementary affidavit to the contempt application.
Yes.
Lord, it's the composite opposition.
Yes, yes. And a reply also.
Yes, Mr.
Lord, first, Lord, kindly comes to the order, Lord, of contempt.
Yes.
That your lordship would find, Lord, at page 34 of the petition. This was passed on October 2017. The last paragraph.
That is the first one. Which page of the contempt?
Lord, page 34.
34. কি হয়েছে নিচে কি হয়েছে দীপঙ্কর কি হলো
The suit is for declaration of tenancy right. Where, my lord, it has been dismissed. Against that, I am with your lordship. The trial
Justice Jyotirmoy Bhattacharya sitting with Justice Sharaf. This order. Yes.
The defendant respondent is restrained from disturbing possession of the plaintiff appellant in the suit premise.
Oh, that. Oof.
Yes.
We'll decide this today. Yes. Yes. Over.
Now,
Yes.
Lord,
What is the contempt? They were shifting. I mean,
two
reconstruction and all
aspects of the matter.
Yes.
They say that because of the renovation, Lord, my electricity was disrupted. That is one chapter. Otherwise, Lord, they had issued a notice whereby they had directed me to vacate the premises. That they couldn't have done, my lord, in the teeth of the order. And I will also show from the opposition and the, my lord, sequence of conduct, the manner in which that letter was treated and what was their intention. Unless I would have come up before your lordship, my lord, in contempt, Lord, this would have been continued. Lord, kindly, my lord, takes my supplementary affidavit. On the last occasion, my lord, the averment your lordship has seen, but this letter was not there. That's why, my lord, the supplementary leave was granted.
Mr. Mittal, take your seat, both of you. Yes.
Kindly, my lord, comes to page 17 of my supplementary affidavit.
17, yes.
Lord, before 17, Acha, yes, Lord, before 17, kindly comes to 22. 22.
Yes.
This, my lord, I had addressed to the Lord contemners, indicating the protection, my lord, granted by virtue of, my lord, the order. This is to bring to your notice, my lord, the second paragraph, my lord, of that notice. This to bring to your notice that we have come to know from a newspaper daily named Times of India dated such and such that you are set for renovation of the entire hotel such and such for incorporating modern amenities and ensuring the highest standards of luxury, whatever is there, my lord, shall remain shut down from 15th of August for 18 months. So, my lord, they did not inform me in the teeth of the order. They did not inform me about, my lord, the closure of this hotel for, my lord, whatever purpose. In such context, it is pertinent to mention that the Honorable High Court at Calcutta, by way of such and such, at the time of entertaining the application for stay, as in such and such, preferred, my lord, the quotation is there.
Your possession and ingress egress could not be.
My lord.
So they have not demolished your portion, but your ingress egress was being disturbed for some time.
Some time, and
which has been probably.
They had issued a notice asking me to vacate.
Yes, that is more serious. Where is that?
Lord, kindly comes to page.
And electricity was probably cut and disconnected, again restored probably.
Because of my lord. Because of my lord's intervention, Lord, it was restored. Else it wouldn't have. Now, my lord, I am showing this letter only to show their intention, nothing more than that.
Yes.
Kindly comes to page 17.
7?
Lord, 17.
17, yes.
That affidavit, Lord.
This is their letter.
Yes, 27th of August 2024. You have been occupying such and such illegally, Lord, whatever is there. The management of the has decided to restore and conserve the entire hostel such and such, and not take your lordship. You are requested
to vacate
the space occupied by your shop immediately by removing all the stocks, including the display items, without further delay, so that the restoration of the building could commence. We are confident you will take our advice in the manner in which it is intended and comply with the instructions of the management to avoid any untoward incident. Lord, an order was there subsisting since 2017.
They did not take any leave, anything from the court.
Nothing. They did not inform us also, Lord, so that we could have come to this honorable court, Lord, for taking our precaution. They straight away, we write to them that, see this, here is an order subsisting, please take precaution before proceeding. In reply to that order, notice letter, my lord, the 17th, this page 17 letter comes in. Now, Lord, prior to this, Lord, they move a writ petition without making us a party, seeking direction from this honorable court, Lord, for carrying on, Lord, whatever the renovation works are required, and making some of the, Lord, occupiers, hawkers, Lord, in front. The Grand Hotel in front, your lordship knows, Lord, there are several shop rooms and hawkers.
Filed a writ petition.
They had filed a writ petition without making us a party, although they knew that this order was pending.
What was the relief claimed in the...
Lord, in the relief, Lord, we don't have, Lord, they have annexed the order of the appeal court. Lord, kindly comes to page 34 of the affidavit in opposition. "29th of April 2025. I'm sorry, page 34. I'm so sorry, Lord, page 23. Kindly comes to page 23. I'm so sorry. This is 7th of October 2024. The writ petition, my lord, my instructions were filed sometime in the month of July, my lord, 2024, just before the act of contempt. Thereafter, my lord, they failed to obtain this and they now take up. Appellant number 1 is the owner of an iconic hotel such and such, an ornate arcade stand such and such, adjoining footpath. In the meantime, appellant has approached the corporation for making immediate repairs and renovation of the arcade. However, the repairs and the renovations could not be undertaken as the entire area is occupied by street hawkers. In the joint report submitted by such and such, the borough such and such, it was noted repairs of columns, front ceiling of the shopping arcade along with footpath needs immediate intervention. Some plastering is also needed to avoid accident. Inspection report, Lord, it's set down, Lord. We have considered, Lord, the last paragraph. We have considered submissions at the bar, report submitted before such and such, and leave no doubt that immediate repairs and renovation at the arcade is necessary to prevent an untoward incident. We also note that application detailing the necessary repairs has been submitted before the corporation authorities to stay application. We direct that said application to be submitted before the committee comprising of the impaneled architect, who shall, finally, they were permitted to construct. Now, this writ petition, the appeal, all were Lord, taken out behind my back. Lord, in the writ petition, I'm sure, Lord, there was no mention of this order of injunction which was subsisting. So, Lord, I at least, Lord, was entitled to a notice of this writ petition that they were moving because of the renovation work. Now, they might say, they might explain that, Lord, it was only for the facade, only for the frontage. That's why you were not required to be made a necessary party. The requirement is you are inside the hotel. So, Lord, you don't inform me about.
You are inside the hotel, not under that.
I'm inside the hotel. I'm inside the hotel. Now, Lord, you don't inform me about the renovation. I get notice of that.
Your part has not been demolished.
No, Lord, nothing has been demolished.
Then
they are taking out, Lord. They are taking out
vacate,
steps for repair and renovation.
Notice to vacate we will consider.
Yes,
that is
notice
a
to vacate.
very, very serious issue. But regarding the rest, your non-implement here might not have been
this
fatal.
Is only to show their intention to commit the willful contempt, nothing more than that. This is only to show that it's a demonstration with your lordship.
Apart from the letter, what have they done?
Not apart from the letter, the disconnection was there. The disconnection now.
Your ingress and egress have never been
ingress and egress.
Not so seriously.
Not so serious. Not so seriously. Now,
so electricity disconnection was there for what period?
From 14th of November 2024 to 4th of March 2025.
Again, 16th March.
And thereafter, my lord, from 16th of March to 21st of March 2025. They say that they had asked for reduction in the load capacity of the hotel.
Yes.
From 1400 kV, my lord, to 750 kV. Now, my lord, my shop room operates on the basis of few lights and my lord, ceiling fan. So, my lord, for operating that,
must be AC also.
Is not AC is inside built, my lord, so it's not.
So doesn't consume
electricity. Is the electricity was stalled. My problem is electricity was stalled. Lord, I never complained that the AC was not working. I say the lights were also not working.
What is their explanation to that?
Lord, their explanation is because of the Lord,
renovation work, something.
Yes, renovation work. The first thing is their explanation is the disruption was never there. That's not statement on oath. The renovation, because of the renovation, the second part is because of the renovation, they were not disruption in electricity.
But so, this vacating notice is crucial.
Yes.
Notice to vacate.
And this has been subsequently, my lord, clarified also. My lord will kindly come to 27 তারিখের 27 নভেম্বরের পেজটা ওখানেই আছে 21 নভেম্বর lord grants me 1 minute's time. Oh. কত নম্বর পেজ?
64 of the contempt.
Yes.
Lord kindly comes to page 64 of the contempt application, Lord. Page 64. Again, they are issuing.
64.
We acknowledge the receipt of your letter dated such. I'm sorry.
64.
We acknowledge the receipt of your letter dated such and such, wherein you have stated that your shop located within the hotel premises has been without electricity for the past 7 days and have been requested restoration of the connection. We would like to invite your attention to your letter dated such and such, to our letter dated such and such.
Let's see, read it. What is the difficulty in this?
No, the
they are saying restoration team is working on it due to the renovation work, which is one of the feasible defenses. Why not?
The feasible
if renovation work is going on for the entire hotel, then there may be.
Suppose, for example, Lord, I am a tenant in a property which is supposed to be developed. Lord, I obtain an order of injunction for only one single room. The remaining property is free, Lord, for construction. In the garb of, Lord, that demolition.
Not always possible to save the electricity connection. I mean, it may get disrupted when a renovation work is going on for the entire building.
I have shown, Lord, on the last occasion that the remaining some part of the building was enjoying electricity. I have shown from the photographs also.
Yes, it may be that a part of the premises got disconnected and then
in front of my shop room. The hall of the hotel was having electricity. But I'm only on the electric connection. I'm not saying about AC.
Those are the photographs with the newspaper.
Yes, Lord. 67 onwards.
Yes.
Page 67.
This is the lounge. Appears to be the lounge of the hotel itself.
Hotel. I'm
You are inside the hotel?
inside the hotel.
Acha, on the ground floor?
My lord, I'm inside the hotel.
Only your room was disconnected.
Ma'am, kindly comes to page 71.
These are all in front of the shop.
Lord, the electricity is there. Lord, the person sitting is one of them, Lord.
This is my store.
One of you?
Yes, Lord. The Lord, door appearing on the right hand side of this photograph is my shop room. Inside that there is no electricity. And Lord, renovation work 7 days I can understand, but it continued from, Lord, as I indicated, from 14th of November till 4th of March.
Submission that till
Lord,
February. there was
sham
time for-
defenses cannot be permissible. Lord, defense which has some logic, understandable. Lord, in the garb of renovation, Lord, one can say that 7-10 days, understandable. I issued a notice. They replied to that. Lord, kindly
After
seize the
this
reply.
letter, what happened? You communicated again?
After this reply, Lord, it remained like that. After this letter, Lord, until and unless I came up before this honorable court, I filed this contempt. Rather than
There's
I
another
mentioned the
letter.
matter.
Another letter of 3rd December. Next page, 66.
Same, Lord.
That's you writing to them.
I'm writing. No electricity since November 14. Repeatedly. And then I mentioned this matter. Did not come up in contempt. I mentioned this matter before your lordships. Your lordship not say that it's a contempt.
Regular
filing.
contempt.
Lord, it's only there.
Yes, because this has to be on oath. Otherwise, we cannot take notice of that.
My
Has to be on oath. Otherwise, we
My
can't.
lord. This is exactly, Lord. May I come back to that?
Hard in part একটা করে রাখো, এটা appear করছে. Hard in part for further hearing tomorrow.